Too many things to think of. I'd like to declare District Plan Committee meeting DP 22/5 open. I note for you all that this meeting is being held for the purpose of plan change hearings. It's being live streamed to the public and Zoom facilities are available, and some presenters may be zooming in. Today this hearing is for Plan Change 93 to the District Plan, first review. And this relates to Tapuna Springs. And continuing tomorrow, we'll be hearing Plan Change 94 to the District Plan, first review for Washer Road Business Park. To begin, just to let you know who your panel is here. My name is John Scrimger. I've been a councillor for the last 9 years. I've been Deputy Mayor for this past 3 years. Among other responsibilities, I am Chair of our District Plan Committee, and I hold a qualified RMA Hearings Chairperson's qualification. I'll let my other colleagues introduce themselves. First, Councillor Dean.
Good morning, my name is James Stenier. I'm a councillor for the Katikati Waihi Beach Ward. I've been a councillor for 3 years. I'm a qualified hearings commissioner, and I also chair the Audit and Risk Committee at Council.
Good morning, my name is Murray Granger. I'm a councillor for the Kaimai Ward, and before that I was chair of the Mokoroa Community Board, and I also hold a hearings commissioner qualification.
No, this one down here.
My name is Alan Withy and I'm an independent commissioner acting under delegation from council to participate in this panel. I've been doing this stuff for probably 30-something years, and I bring that expertise to assist the panel in its deliberations.
Thank you, panel. Next item on our agenda is apologies, and as we're all here, there are no apologies. So I'll move on to the next item, which is declarations of interest. And I would like to start by pointing out that an issue has been raised by a submitter suggesting that I have a conflict owing to the fact that I was a mover of a motion to connect the Tapuna Springs site to reticulated wastewater. I've given due consideration and believe that this does not constitute a conflict for myself nor for my two colleagues who were also party to that decision. And I note that this decision, that decision is contingent upon the outcome of this plan change decision. Are there any other conflicts? I don't believe so, but are there any? No? So are there any other procedural matters that people wish to raise before we proceed with the hearing? It seems not. Okay, we move on then. And but before I go to the planning report, I just would like to point out a few other things, that we will have break times scheduled. We have them scheduled, but they will be adjusted depending on the flow of evidence and when is convenient. If in the case of an emergency, staff will direct attendees to the exits and evacuation gathering points. There will be morning tea available in the foyer for those of you who've come to take part or to listen to this hearing. Evidence has been circulated to all parties and we intend to take that as read. Our panel has spent many hours reading those documents, so you don't need to repeat that for us. And witnesses may provide a summary of key points as they see fit. expert witnesses, when they provide their evidence, may wish to stop at points to take questions from the panel. So we'll manage that as suits you. And I'd also like to point out, it's not news to you that we have a large number of documents. And so if we're a bit slow at times searching for a particular point in question, just be patient, we ask. And if you are using microphones, the right-hand button is the one you need to activate to be heard. So with that, we'd like to move on to the planning report. And I'd like to invite our senior consents planner to provide an overview of Plan Change 93.
Good morning, Chairman and Commissioners. This morning we're here to hear for Plan Change 93. It's a private plan change which has been prepared by Collier Consultants and Oricon, and it's been accepted by Council for processing. The purpose of the plan change is to rezone rural land within the subject site to commercial and create a new structure plan which overlays over the subject site. It proposes a number of changes to the district plan, including rezoning 4.5 hectares of land from rural to commercial, creating a new structure plan for the 5.93 hectare subject site, and the structure plan will guide the development of the area, showing areas for development, roads, stormwater, landscaping, etc. It also proposes some new rules to allow development and to manage effects. There were 13 submissions and 5 further submissions made on the plan change, and the applicant has made changes to the structure plan as a result of the submissions received. The revised structure plan has taken into account feedback from submissions and made changes to the location of stormwater ponds, green space as a result of further ecological assessment, and made changes to the roading layout. The district plan provides guidance for structure plans in relation to stormwater management, ecological areas, roading and access, with these shown in general locations on the structure plan. It is not until the further development and consenting that the finer detail of footpaths, toilets, road formation and width, parking locations, etc. is finalised. Several submitters requested changes to the structure plan at a level of detail which is not required for a structure plan, and the design of infrastructure cannot be completed until the future tenants and building and car parking locations are confirmed. The level of detail and assessment provided in the application and revised structure plan demonstrates that that suitable infrastructure can be accommodated within the site. My report recommends that the plan change be approved subject to a number of changes which are outlined in my Section 42A report, and I won't go into those further here. I've reviewed the applicant's evidence, experts' evidence and the submitter's evidence, which has been received and circulated prior to the hearing, and just have a few comments to make for you. Aaron Collier's planning evidence for the applicant, point 5.8, with regards to access from State Highway 2, which is in line with Anne Frosby's evidence. I accept that change, which is in relation to restricting access to the area A, I believe, until further on in the development. Point 5.12 is accepted regarding riparian margins also. Regarding Fiona Wilcox's evidence, I accept the correction, at point 28. It was my mistake. Point 29A and B are also supported regarding ecology and riparian margins. Just turning to the submitter's evidence, Mr. Child's evidence on behalf of DC Kirk Family Trust. I disagree with Mr. Child's point at 3.1 on the plan change being spot zoning. The plan change provides for an expansion of the commercial area on the subject site, and it is not a new commercial area outside of any other commercial area. With regards to the boundary treatment, the evidence of Mr. Childs and Mr. England failed to recognise the existing screening rules within the district plan as stated in my planner's report, which currently addresses the interface between any commercial and rural zones. I disagree with point 5.1. The current commercial zone rules require buildings to also be set back by way of a daylight plane. This ensures that a wider boundary setback is achieved if a 9-metre high building is constructed along that boundary, and along with the 3-metre wide screen planting required ensures setback and screening is achieved. Joe Gravitt, on behalf of the Te Puna Hall Committee, has asked for clarification on the zoning status of the hall site. And as shown on the structure plan, it is to remain as commercial zone. She also makes several references to mixed-use residential spaces within the structure plan. And it is noted that in the current commercial zone rules, residential dwellings are currently provided for, and no further provisions are recommended under this plan change. Both the Te Puna Hall Committee and Heartland submissions have commented on the connectivity of the site for walking and cycling. Anne Crosby, for the applicant, will speak to this matter further shortly and show the intended pedestrian cycle linkage planned as part of the TNL upgrade of the intersection. Regarding the stormwater matters which have been raised by submitters, we have Council's Acting Asset and Capital Manager, Rhian Rousseau, who has prepared a statement of evidence. This was circulated to you yesterday. He is available this morning if you have any questions for him. So I can now take this time to, if you have any questions for either myself or Rhian that we can answer. Thank you.
Okay, panel members, do you have any questions, Murray?
Yes. Thanks, Chair. On page 15 of your evidence, Ms. Price, you discussed the northern boundary landscape strip and say that it talks about 3 metre wide, but on the plans that we've seen, it appears to be 2 metres, and in other times it's talked about as 4 or 6 metres. So I'm not quite sure exactly what that northern boundary is, and the plan change, the structure plans have changed a number of times in the documentation we've got. So do we have a final clarity on the width of that northern boundary planting strip? Not necessarily you to answer, but if somebody could help us out with that.
Sure, I can clarify a point on that if you would like. So under our current district plan rules in section 4, we have a requirement for amenity planting between a rural zone and a commercial zone property, which is a 3 metre wide landscape strip. And I believe that's maybe not very clear on the structure plan, but it is a requirement under the district plan.
Sorry, but you say that they have agreed to provide an additional landscape strip along the northern and western site boundary. So on the western one, it did seem to be wider, but on the northern, it didn't. That was the point I was making.
I can perhaps just clarify that. Morna Hugo from Boffin School, landscape architect. Initially, I think we proposed a 2 metre strip on that boundary, but then the district plan rule has overridden that. So I note on the structure plan that hasn't been updated. So we just need to update that. It's just there's been quite a few changes to that structure plan, so we just need to catch up a little bit. So we'll make sure that gets.
So there's 3 metres.
That's 3 metres, yes.
So perhaps, Mr. Chairman, that could be clarified by the experts when they give their evidence later on.
Yep, thank you.
On page, sorry, on page 23, you make the comment that the area sits within the catchment, which may already have downstream issues with flooding. And this has been brought out by others. So have we got council records or information about historical flooding in this catchment, and to what extent and how often?
I've checked with our utilities engineers this morning and I confirm that council hold no historical records for flooding information on those properties or any properties.
Thank you.
You finished?
Yeah.
Yeah. Councillor Daniel?
I do, it's on the page. Okay, I had a question about I'll just read from page 22. It says the proposed structure plan area does not present unique or special characteristics such as an identified landscape feature or heritage area, which may trigger specific urban design requirements under option 2. So the question is it possible to provide new urban design requirements, or does the lack of identified landscape features and heritage area preclude that?
The lack of landscape or historical features does not preclude there being additional urban design requirements for the structure plan itself, but it doesn't necessarily mean that we have the level of detail that we would maybe require it for a specific landscape feature or historical feature as well.
You could add it if you wanted to.
But you can add it if you wish to. Yeah.
Thank you. That's it for me.
Thank you. Commissioner Willie, do you have any questions?
Just one question, Ms. Bryce. The Regional Council has addressed particularly the stormwater issues and asserted that they be addressed in the change, whereas others are arguing that those issues can be dealt with at the consenting stage. What's your position on that argument?
For stormwater matters, I always refer back to our utilities engineer, and they have reviewed the information and provided the advice to me that they are satisfied with the level of detail that's been provided. And perhaps Rhian might be able to answer any further questions on that if you have them.
Commissioner, yes, it is true that is the position that I have. I think that the level of detail at this stage is good enough because it gives satisfaction that it can be workable once you get to the detail stage, but we don't require more detail than what was presented at this stage.
Thank you.
Right, it seems there that's the questions there. So thank you for that, Ms. Price. So we can move now to the applicant, and I'll call on Mr. Collier to present your evidence, please. Oh, first. Okay.
Thank you, Mr. Chair, and good morning to the panel and council staff and submitters. Just if I could, in terms of housekeeping, talk about the plan presentation on behalf of the applicant. The concept in the chronology is that Mr. Collier will present a PowerPoint, and that will just provide an overview of the plan change in a very summary form. And from there, we will then lead into the applicant's witnesses. And Mr. Collier's actual full brief of evidence, including his rebuttal, will actually be left till the end in terms of talking to the technical nature of his planning evidence and the plan provisions. So if I could, with your leave, Mr. Chair, have the PowerPoint turned on and present that overview, and Mr. Collier will go through that PowerPoint.
Yes, that's fine. Thank you.
And just if Committee Secretary, Ms. Clark, has a pointer that could be used with the, thank you. You might need to.
Yes, sir, it might help to all of the people can leave them on his hand. sort of technical issues on the.
You hear that? You can leave your microphones on, so. Pardon? So they tell me. Don't blame you.
Yeah. So
Good morning, Commissioner. So my name is Aaron Collier. I'm a planner, and I was involved in assisting Oricon with the preparation of the plan change. I have put up a series of slides which our experts will be talking to as part of their presentation of their evidence, but I just thought it was useful to take you through a couple of the slides. The first one is effectively showing the site relative to State Highway 2 roundabout and frontage, the existing hall site, which is located in this location here, and obviously Te Puna Road, the DMS packhouse and cool store facility, which is here, what's been referred to in my evidence as the Zareba site, which is in this location here, and obviously the rest of the existing commercial area, which is on the southern side of the state highway. This plan has been updated to show in this pink outline area the extent of the existing commercial zone. So that is what is already zoned, including this island of land. There is a long history with respect to how this roading situation occurred. I think it's fair to say most of it is very historical and related to the original hall proposal and the state highway changes. The hall was originally proposed to be in this location before it was moved to its present location. What this amended structure plan does is it incorporates a number of changes that have been made to the original structure plan following receipt of submissions and some further work that was undertaken by the applicant. And so this amended structure plan and that further work was circulated to all submitters as part of a covering letter, which is included as an attachment to my evidence. So you have a copy of that. The main changes that occurred was that previously the site access, principal site access is from a location here in Te Puna Road. You'll hear later from Ms. Fosbury in relation to her view on whether that is a kind of fixed location or not. But the original proposal was to bring a road through, and this road was to come down and connect to the state highway frontage. That road was reconsidered in the context of the location of the three branches of the streams. So there's three areas of streams that were identified on the site. Previously, this stream was proposed to have been piped and moved as part of the original hall development. And so the road came down and was over the top of effectively that area. And this road here, there was a previous road that sort of ran internally, which was within internal to the applicant's site. That road was in response to some discussions that we had with the Hall Committee, that internal road heading north was removed from the structure plan. And what the structure plan shows is effectively the extent of the original kind of pond areas and the wetlands that were proposed originally as part of the Oricon engineering assessment. Now, that has changed, and you'll see some evidence from Mr. Rayner in response to the regional council's concerns. So the regional council's concerns were basically that the stream system that runs through here would end up being part of that wider stormwater management system. Mr. Rayner's amended proposal, and there is a slide that he'll take you through to show you that, effectively bypasses the stream. So the current stream, which is part of the pond, will be rehabilitated so that it's separate to the pond, but we still will have sufficient space to provide for both stormwater treatment and attenuation, excluding, sorry, I'm just trying to get this pointer. Oh, it's going in. Excluding the large areas of potential car parking that we'll have in this area here, and in this area here, and in the other areas that are part of the plan change, which we can use if we need to for stormwater storage and treatment. And that's an expensive option, but that's an option that's available to the applicant as part of their detailed design for their stormwater. So the site is currently all, apart from the Hall site, is effectively the additional area that's proposed to be rezoned, which is all of this, is all within the applicant's site. There's a very small area of the Hall site here that was zoned rural. But the rest of the land is all within one ownership and effectively one site. So the future discharge consent process will be relatively straightforward because there aren't multiple owners involved in this plan change. There is only one landowner, and that is the applicant's intention following the plan change process. Once they determine what buildings will be going on here, car parking areas, and what areas will be developed, that is at that point that they will apply for their stormwater discharge consent. They will also need consents to sort out the existing pond situation in the streams and separate the stream so that it's no longer an inline stream. They will need various consents to rehabilitate these arms of the streams and the gullies. And when you do a site visit, you will see that all of the streams have been significantly modified in straight line, effectively turned into, I suppose, in layman's terms, drains in parts. That is detailed in the evidence of Fiona Wilcox, who is the applicant's ecologist. The other change which has occurred is that previously there was an area shown as an area in here where the Te Puna Spring was thought to have been located. As part of the further ecological work, the spring has actually been confirmed as being in this area and here. And so there was certainly no point in setting that area aside to contain a spring when it doesn't have a spring. So that is also an amendment that came out of some of the further work that has been done since the plan change was originally lodged. And this plan change has progressed over about a 5-year period. It's taken a significant period of time to get to this point. So as I've said in my evidence, there was some very early consultation with council staff, the public consultation exercises that were carried out, meetings with neighbours and workshops, including design workshops with council staff. So that's an overview effectively of the main changes that have been made to the structure plan. And as I say, I've included the extent of the existing zoning on there so that you have an indication or an understanding of the scale of the addition. It's not, in my opinion, a large plan change at all. It's simply providing for the future immediate and local needs of the Te Puna community. So thank you. I'm happy to answer any questions on the changes if you have any at this point.
Okay, Councillor Daniel.
Yeah, I had a question of clarification on regard to the stormwater pond and the stream. I think it's fair to say it's been in a state of flux, the actual design there. So you talk about the stormwater pond no longer being in line with the stream. I can't quite see on the map how that is, because it looks like the streams are still flowing into that pond, but you can explain that.
It's not. That's a further map which Mr. Rayner will take you through in a bit more detail. It gets into a little bit more engineering detail, and if it's okay with you, I prefer that he kind of ran you through that.
Sure, mate.
But I'm just pointing out the applicant's intention is not to put the stormwater into a pond and then out of the pond in an inline situation. So that is all historical. It's something we've been left with. And as I say, there's an opportunity here to fix that up and effectively recreate about 120 metres of stream. And we're happy to do so. Unfortunately, that's all been brought forward into this process because it would normally be dealt with as part of the discharge consent process. But the Regional Council have certainly been making significant efforts to have a whole lot of further work done up front, which has been done by Mr. Rayner, and he's going to cover that in his rebuttal evidence.
Thank you. Did you? Yes.
Mr. Collier, you heard my question to Ms. Price. What's driving my question, and I make a question of you also, is that we get the procedure right. And I'd just like you to confirm that the amendments that have been made, which come out of stormwater issues, are adequate for the change process, and that any further refinement of the stormwater system can be handled at the consenting phase.
Yes, in response to your question, I do consider that the amendments that have been made and the applicant's approach is appropriate. I think you need to be satisfied that stormwater can be adequately managed and dealt with. I think the level of detail that's been provided in the last week is almost getting towards the level of detail that we would expect for a discharge consent. As I've said in my rebuttal evidence, I have quite considerable experience with discharge consents, as does Mr. Rayner, albeit most of this high level of detail really applies as part of larger comprehensive stormwater consents. But yeah, I'm very much satisfied, particularly from the further work that Mr. Rayner has done around the issue of the streams and the national policy statement for fresh water, that what this plan change offers is actually significant enhancement above and beyond what's already existing. And there is a good stormwater solution. What we haven't included, as I've said earlier, is potential for further mitigation, if you like, within the actual flat areas up the top. So that's also available for us if we need it.
One further question, Mr. Collier. I know there are some submitters who made the suggestion that stormwater areas, the green space, and actually the internal roads as well, could or should be vested in council. Has that been considered, or what are your views on that?
My views on that are that once we look at completing all the rehabilitation of these areas and all the works are done, we do need to have a discussion with council as to whether or not they are happy for us to vest those areas. At the moment, they're private. So I don't believe it's a matter for this plan change, but it may be that given that the areas are taking stormwater from State Highway, Te Puna Road, DMS, Zariba, that we do have a wider discussion with council at some point about that. But it's certainly not, in my view, a matter for the plan change. That would need to occur through a future subdivision process. You will hear from the applicant that what their plans are in relation to the long-term development of the site. They do intend to develop it all themselves and do individual buildings. So yeah, in answering your question, that is an option long-term.
Thank you.
Councillor Granger.
Thank you. Was there any consideration given to that internal road being moved to the northern boundary to assist in the separation between the commercial area and the orchard?
This road here.
Yes. Has that ever been considered as?
Sorry, is the question, is the road moved to, could it be moved to this location here?
Yes, was that ever?
No, I don't believe so. I think Ms. Fosbury has looked, and probably Ms. Fosbury is more appropriate to comment on what the optimum location of that is. I understand there's a little bit of flexibility about that being able to be moved, but there are other entrance locations and separation distances and things from intersections which are relevant. But Ms. Fosbury is probably best placed to answer that question.
Thank you.
Okay, it seems that's all. Thank you, Mr. Collier.
Thank you.
So we. Right, thank you. So next up we have Mr. Rayner.
Yes, good morning.
Sorry, sir. It appears as if the presentation order is slightly out of order, and that it's usual practice that I would present my legal submissions and then head into the witnesses to present their briefs.
Okay.
So with your leave, I'll
My apologies.
try and race through my legal submissions and then turn over to the witnesses who I'm sure you're looking forward to hearing from. Now, I did send these through late last night, and hopefully you all have a copy in front of you. If I could first perhaps turn to introducing my witnesses at 2.1 and go through introduction of the witnesses. I have Mr. Heath, economist, who's presenting on Zoom, and I'm not sure if he's already online or shortly will be, but he will be presenting first, just so that we don't tie up his day, and then he can address any questions. Then I have Ms. Anne Fosbury, who is here as a traffic engineer from Oricon, who I'm sure the panel knows already, and Mr. Neil Rayner, who's also behind me from Oricon, dealing with stormwater and infrastructure. Then Mr. Mornay Hugo from Boffa-Miskell as landscape architect and urban designer. Then Ms. Fiona Wilbo is ecologist from Wildlands Consultants, who's here behind me. And then the director, Ms. Annalise Michael, who's the director of Te Puna Springs, who's here behind you. And then Mr. Aaron Collier, who's beside me, giving the planning evidence from Collier Consultants Limited. So I'm presenting the evidence in these submissions on the basis that the panel has pre-read all the evidence and rebuttal evidence, and with the witnesses intending to summarise that in front of you and then answer any questions. In terms of the outline of these submissions, I've run through that, and I'll deal firstly with the legal framework and general requirements of a plan change, the planning framework of higher order documents, the regional policy statement, environmental effects, scope and relief sought or available, non-statutory documents, evidence and remaining areas of disagreement and issues for determination, and some concluding comments. Now, Mr. Chair, I'm not sure the extent to which the panel is familiar with plan changes and the law around this. I have set out the requirements under clause 29(1), section 31, section 32, 74 and 75. And I'm just wondering, do you want me to talk that through, or are you happy to take it as read? It's relatively dry. That's all I'm saying.
I believe we're happy to take it as read. Thank you.
All right. So then if I could turn to number 5 at page 7, where I've referenced environmental effects. And environment is defined in section 2 of the RMA, although the meaning of the words need to be understood with reference to case law. The environment as it exists can be considered the starting point for an assessment of what constitutes the environment. In the case of Queenstown Lakes versus Hawthorne Estate, the Court of Appeal found the word environment has a wider meaning, holding that when considering actual and potential effects on the environment of allowing an activity, it is permissible and will often be desirable, even necessary, for a consent authority to consider the future state of the environment on which such effects will occur. Obviously, that case was talking about a resource consent, and in a plan change by its very nature, you're looking at long-term future changes and the zone is enabling. But the relevance of the case law and the context of the word environment, I think, is important for setting out what this area may look like in the future, as well as what's there now. The RMA remains an effects-based, forward-looking statute. Its overall purpose has not changed since enacted in 1991. Section 5.1 of the RMA states as the purpose of the Act to promote the sustainable management of natural and physical resources. The relevant Section 32 assessment is to assess the effects of the proposed change to the land uses enabled by rezoning, not existing zone land or consents that already form part of the existing environment, even though this additional land has been spatially included in the proposed structure plan area. And Mr. Collier showed you on the PowerPoint the extent to which within the structure plan area, you have this pocket of existing commercial zone land. A summary of these effects is, first, the area comprises a small and highly modified land resource with a mix of rural and commercial zoning that sits at the edge of rural Te Puna. The location is characterised by the four corners of Te Puna due to being on the edge of the recently redeveloped state highway and in an area with an elevated level of local demand for local retail, entertainment and community services, as discussed in the evidence of Mr. Collier and Mr. Heath, and confirmed by submissions which refer to the number of ad hoc consents granted in this locality. The site is within an area that has already been in a variety of urban uses for many years. There is an existing petrol station and Foursquare supermarket and an area of land that was compromised during the construction of the state highway when used by Waka Kotahi as a construction site and for access to what was a previous hall site fronting State Highway 2. The plan area includes council land containing the Te Puna Hall. This facility, which when granted consent, noted as its purpose to meet social and cultural needs as a physical hub for the community to gather. As stated in the expert rebuttal evidence of Mr. Hugo, the area already has the look and feel of an urbanised peri-urban area. The plan change seeks to rezone this land to recognise its character and ensure it will be managed sustainably into the future. The land will not be used for a purpose envisaged by the existing rural zoning, albeit that it has not been used for rural purposes for many years since it was purchased by from the adjacent Kirk family. The evidence filed in support of the plan change in the Section 42A report confirmed that the proposed commercial zoning is the most appropriate of the two zones and that retention of a rural zone is not the most economic or practical alternative given its location, current uses and demand for further commercial business land in this locality. Any potential effects on the environment can be appropriately avoided, remedied or mitigated through proposed provisions, and the zoning will more appropriately recognise the site as commercial and provide plan provisions to enhance outcomes for the site and freshwater streams, as well as the wider rural area by avoidance of further ad hoc consents sought to meet business demand. The performance standards set out in the infrastructure requirements to service the land provide an attractive and efficient layout of future development, will enable public viewing and potential future access to and along streams once their protection and enhancement has been completed, if they are vested in the council, and will maintain appropriate amenity outcomes with planting and buffers along the two rural boundary interfaces. The risks from natural hazards have been addressed through the engineering and infrastructure reporting and have confirmed that the site is suitable for the business land development outcomes that are anticipated. The plan change provides for additional plan provisions to not only manage and avoid environmental effects, but enhance the existing site characteristics and local environment as covered in the evidence of Mr. Collier and Ms. Wilcox. Turning to the scope of submissions, I've referenced a case of Albany North landowners versus Auckland City Council, which is a High Court decision which indicated the scope for a coherent submission being on a proposed district plan in the context of a full plan review is very wide. And Mr. Chair, with your leave, if I could take the quotes as read. Sorry, I've got a
Certainly
little bit of a
can.
dry throat going on.
Yes, that's fine.
In the High Court, the landowners case also noted there can be nothing wrong with approaching the resolution of issues raised by submissions in a holistic way. That is the essence of integrated management demanded by section 30 and 31A and 31(1)(b), and the requirement to give effect to higher order objectives and policies pursuant to section 67 and 75 of the RMA. It is entirely consistent with the scheme to draw on specific submissions to resolve issues raised by generic submissions on the higher order objectives and policies, or the other way around in terms of framing the solutions in the form of methods to accord with the resolutions of issues raised by generic submissions. There have been some positive outcomes with engaging in consultation with submitters involved in concerns raised. Amendments to the proposed plan change through the Schedule 1 process can be made, so long as the amendments fall within the scope of submissions. The legal principles on limitations of scope are set out below. The scope of an appeal is bounded by the submission at one end of the notified plan at the other, and that's the same in terms of your scope for this decision-making phase. This principle is summarised by Judge Kirkpatrick in Federal Farmers versus Otaronga District Council. He states that a careful reading of the text of the relevant clauses in Schedule 1 shows how the submission and appeal process in relation to a proposed plan is confined in scope. Submissions must be on the proposed plan and cannot raise matters unrelated to what is proposed. If a submitter seeks changes to the proposed plan, then the submission should set out the specific amendments sought. The publicly notified summary of submission enables others who may be affected by the amendments sought in submissions to participate either by opposing or supporting those amendments, but further submissions cannot introduce additional matters. The Council's decisions must be in relation to the provisions and matters raised in submissions, and any appeal from a decision of Council must be in respect of identified provisions or matters. The extent to which the jurisdiction of the Environment Court is delineated by the relief sought in the submission then limits any subsequent appeal. This topic has been the subject of discussion in numerous higher authorities. The test as to whether a provision or matter has been referred to in a submission was set out by the full court of the High Court in Countdown Properties. The local authority must consider whether any amendment made to the plan change as notified goes beyond what is reasonably and fairly raised in submissions on the plan change or review. It will usually be a question of degree to be judged by the terms of the proposed change and of the content of the submissions. A leading authority on submission being on a variational plan change is the High Court decision in Clearwater Resort versus Christchurch City Council. It set out a two-limb test whether the submission addresses the changes to the pre-existing status quo advanced by the proposed plan change, and that should read B, sorry, whether there is a real risk that people affected by the plan change, if modified in response to the submission, would be denied an effective opportunity to participate in the plan change process. A submission can only fairly be on a proposed plan if it meets both these tests. And this test has been adopted in a number of subsequent High Court cases. One of those is Palmerston North versus Motor Machinists, where he described the first limb in the Clearwater test as a dominant consideration, namely whether the submission addresses the proposed plan change itself. This was said to involve two aspects: the degree of alteration to the status quo proposed by the notified plan change, and whether the submission addressed that alteration. There were two further tests introduced in Motor Machinists that relate to scope. One is if the submission raises matters that should have been addressed in the Section 32 evaluation and report, then it is unlikely to be within the ambit of the plan change. And if the submission seeks a new management regime in a district plan for a particular resource, it must be in response to a plan change that alters that management regime. The second test is most relevant in considering those submissions, if any, that seek to add a management regime for the district-wide matters that have not been notified. Turning to the first test posed by motor machinists, the Environment Court in Blue Haven Management versus Western Bay District Council considered the inquiry into matters raised in the Section 92 report. The court did not regard the inclusion or exclusion of matters in the Section 32 report as determinative as to whether the submission is reasonably within the plan change. It stated that our understanding of assessment to be made under the first limb of the test is that it is an inquiry as to what matters should have been included in the Section 32 evaluation report and whether the issue raised in the submission addresses one of those matters. The inquiry cannot simply be whether the Section 32 evaluation report did or did not address the matter raised in the submission. Such an approach would enable a planning authority to ignore a relevant matter and thus avoid the fundamentals of an appropriately thorough analysis of the effects of a proposal with robust, notified and informed public participation. The High Court in Albany North has departed from the motor machinist Section 32 test, but in the context of a full district plan review. And that's where Justice Faddis stated that in terms of the motor machine case, in summary, he differentiates between what is a full plan review, where in the motor machine case, as same as this one, it was context specific and relating to a plan change where the area and reach was a discrete one. So in contrast, the proposed plan change 93, 32 and 32A reports are in the context of a limited and discrete district plan change in comparison to a district plan full review. The case law indicates there are differing relevant considerations and whether a submission is reasonably and fairly raised by a submission depending on the extent and complexity of the plan change. Accordingly, while most of the evidence and changes sought in submissions on proposed plan change 93 may be within scope, some matters covered in evidence are far removed that I submit they are out of scope. They are not specifically subject to the original Section 32 evaluation. For example, seeking other land be considered for rezoning or other Local Government Act decisions or future RMA plan changes yet to be notified. The case law and scope dealing with discrete plan changes differing to that of a full district plan review or a substantive partial review when it comes to scope. Plan changes or variations are usually directed at defined geographical areas or specific issues to be resolved. By contrast, a full plan review by its nature involves a broader approach to the question of scope. And I've just cited there another quotation where that was acknowledged in terms of Justice Faddis saying that in terms of the unitary plan process, that covered the entire Auckland region and therefore basically said everything was effectively up for grabs and discussion in the context of that plan review. This was also discussed in a case that I've cited in Tussock Rise Limited versus Queensland Lakes, where they point out the obvious in terms of those High Court decisions and saying there is a large difference between the strict rules of engagement prescribed by the High Court for submissions on plan changes and the much looser rules for submissions on new replacement plans. Much of that difference can be understood in the context of specific plan changes as to whether or not a local authority wishes to change a rule in a plan. Submissions on the operative objectives and policies would be beyond scope as not on the plan change. In contrast, on new plans, almost everything may be open to challenge, although the strategic issues I have identified do then often arise. This is relevant to my submission of matters raised in the Te Puna Heartlands evidence by Beth Bowden, where decisions made by the Council under the Local Government Act in relation to infrastructure or what is not included in this plan change is notified are treated as valid submissions on this plan change, or whether submitters Kirk and the Regional Council expert witnesses criticise existing rules within the district plan as inadequate for addressing natural hazards, or the fact that wider strategies for an extensive plan review have not been included in this plan change. If the submission is not on the plan change, it is submitted, the Council has no jurisdiction to consider them under Schedule 1 or 6 and case law on scope. Turning to the higher order documents and planning framework, there are currently 5 national policy statements currently in place covering matters such as urban development, freshwater, renewable electricity generation in the coastal environs. Only 2 of these are relevant to this plan change, being the National Policy Statement on Urban Development which came into force on the 20th of August 2020, and the National Policy Statement for Freshwater Management, which came into force on the 3rd of September 2020. The proposed National Policy Statement on highly productive land has not been addressed. It has no weight at this time. It is noted, however, that much of the proposed plan change area has already been subject to significant earthworks, construction, compaction, and existing buildings, with those parts of the site still in a semi-natural state being able to be set aside for wetlands and natural stream rehabilitation. Turning to what's known as NIPSA 2020, this replaces the previous UDC National Policy Statement, which was promulgated to ensure that district and city councils would adequately plan for urban growth. As the Environment Court has said, the purpose of the previous urban development capacity was to open doors and encourage development of land for business and housing, not to close them. The NPS UDC did not, however, contain directive provisions relating to plan responsiveness and agility. And addressing why the subsequent NIPSID was needed, the Ministry for Environment website states, some urban areas in New Zealand are growing quickly. To support productive and well-functioning cities, it is important that there are adequate opportunities for land to be developed to meet community, business, and housing needs. In September 2017, the government established the Urban Growth Agenda. The NIPSID contributes to this urban growth agenda, which is described by the ministry as a program that aims to remove barriers for the supply of land and infrastructure. The NIPSID contributes to the urban growth agenda by addressing constraints in the planning system to ensure our system enables growth and supports well-functioning urban environments. Te Puna and the Western Bay of Plenty District Council's projected population is set to grow, with the wider Western Bay of Plenty treated holistically as a high growth area, noting that Te Puna on its own is not characterised as an urban environment, as it does not have a population exceeding 10,000. Along with the Bay of Plenty Regional Council and Tauranga City Council, the three councils are identified collectively as Tier 1 councils with stronger directives to enable growth than Tier 2 or 3 councils. Policy 1C requires well-functioning urban environments to have, amongst other things, good accessibility for all people between housing, jobs, community services, natural spaces and open spaces, including by way of public or active transport. Policy 3 requires Tier 1 urban environments to enable intensification in city and metropolitan city centres in a prescribed manner, and to consider building heights and density at other locations. Other business locations, such as Te Puna, are generally based on accessibility and demand. In Part 3 implementation, every Tier 1 territorial authority must identify by location building heights and densities required by Policy 3, and there are also qualifying matters that can be taken into account. The overall anticipation of the district's population growth is reflected in the Tier 1 status of both the Western Bay, Tauranga City Council and the Regional Council, and demand for business land is meant to be addressed through plan changes. Previous urban limit constraints or planning policy opposed to out-of-sequence development is no longer the primary objective or criteria that the Regional Council and Western Bay must consider. NIPSID 2020 contains a broad suite of objectives and policies that encompass high-level goals and explicit instructions to Council as to how to accomplish those goals based on a three-tiered approach. And again, if I could take objective 1 and 3 with your leave as read, those are set out in my submissions and carry through to page 17. Focusing on the directives around business land, the Regional Council and Western Bay Council must assess business land demand and provide sufficient development capacity for business land in the short, medium and long term. In this context, sufficient is a minimum, not a maximum, and means both plan enabled and infrastructure ready. This site should be plan enabled as it is infrastructure ready with necessary Section 32 and 32AA assessments undertaken to consider the infrastructure needs as part of this plan change and subsequent resource consent processes that will follow under the proposed provisions. There are explicit directions within NIPSID that all three local councils within the Tauranga urban environment, including the Regional Council, are to work together to better enable land supply for urban development. Objective 3 and 6 and policy 3.3 and 3.4 are relevant here. It is not in my submission for the Regional Council to sit back as arbitrator over the Western Bay on what suitable level of urban development is, or to focus on prioritising policies in the National Policy Statement Fresh Water over its duties in the NIPSID 2020. It is for this panel as decision makers to weigh up these matters and make this decision. The Regional Council and the District Council as Tier 1 local authorities must be actively working together towards delivering capacity for both business and residential land in its district and region to provide for at least sufficient development capacity, plus the appropriate competitiveness margin to meet expected demand, regardless of whether it is out of sequence with the RPS, which is now out of date with NIPSID 2020. Mr. Heath's evidence states that there is current and short-term unmet demand for business land in Te Puna, and this applies regardless of whether the site is within urban limits or defined as an urban environment or not. This plan change will release business land development to address current demand and is consequently consistent with NIPSID's general directives for both councils. Proposed plan change 393 aligns and gives effect to the objectives and policies of NIPSID in relation to directing more supply of business land, as it will contribute to a well-functioning urban environment in terms of objective 1. Relevant parts of policy 1 description of well-functioning urban environments are to support the competitive operation of land and development markets, support reduction in greenhouse gas emissions through less car trips into the city to access commercial services and business, and are resilient to the likely current and future effects of climate change. Although the site is not identified as subject to climate change natural flooding areas, indicative developable areas have been modelled for the site based on worst cases, along with 1 in 100 flooding predictions to achieve neutral 1% offsite effects. Section 9, Plan Change 93 enables additional business and residential capacity in a location that is adjacent to an existing commercial area, readily accessible to the Minden and Te Puna local area, which already provides residential, business, employment and transport options, and are planned around the community facility of the Te Puna Hall and its outdoor surrounds, which is land owned by the council. It was always the intention to develop the whole site for commercial land and integrate with the hall land when Mr. McIntyre offered to sell this piece of land for the community hall to be moved to this location and avoid the costs and risks of the other site location fronting the state highway, which was appealed at the time by neighbours, the Muggeridge family. Additional business land in this locality enables more people to live in an area that is near to employment opportunities. Developing the land in this manner responds to the changing needs of people, communities, and future generations. Sure, carry on.
Yes.
Aligns with this objective as it reflects changing living needs and expectations for local areas to offer local community commercial offerings and services without the necessity to take car trips into townships further away. Provides for the development of land in a manner that takes into account the principles of the Treaty of Waitangi. The evidence of Mr. Collier confirms this principle has been taken into account through early engagement and discussions with Perirako, with a focus on Te Mana o Te Wai through restoration of the puna and buffers along the stream's tributaries on the site. Proposed Plan Change 93 will improve the existing urban environment in the 4 corners of Te Puna to be better integrated with infrastructure planning and funding decisions. It will address current and short-term demand for business land in this locality and is sufficiently small scale and strategically located to not compromise medium and long-term strategies and future plan changes. The Section 42A report and the evidence of Ms. Fosbury, Ms. Wilcox and Mr. Rayner confirms infrastructure planning is in place for roading and wastewater. The flooding and freshwater matters are able to be addressed on site to achieve neutral water quantity flows off the site and water quality improvements. Proposed Plan Change 93 consequently represents both plan enabled and infrastructure ready land referred to in NIPSID based on this evidence. Turning to National Policy Statement on Fresh Water and National Environment Standards for Fresh Water. These documents came into effect on the 3rd of August 2020. This instrument is premised on the concept of Te Manawa Te Wai, the fundamental importance of water and the role its good health plays with the wider environment and in protecting the Maori of water and mana of tangata whenua as kaitiaki. The NIP's fresh water has an overarching objective of ensuring that natural and physical resources are managed in a way that prioritises first the health and well-being of water bodies and freshwater ecosystems, second, the health needs of people, and third, the ability of people and communities to provide for their social, economic and cultural well-being now and into the future. As set out in the evidence of Mr. Rayner and Ms. Wilcox, the site contains freshwater courses and an existing stormwater pond with adjacent man-made wetland at its margin. The proposed detailed site diagram prepared by Mr. Rayner and included with his rebuttal evidence confirms that the earthworks and stormwater management on site will substantially exclude the potential for disturbance of the watercourses. Mr. Rayner's engineering response allows their margins to be set aside and enhanced with planting and ecological reserve type areas shown on the structure plan. These areas may be vested with council as part of future commercial development or subdivisions on the site. This provides for the likely ongoing protection and rehabilitation of these natural watercourses and their margins. The proposed plan change thereby satisfies the directly relevant policy 7, which directs that the loss of river and stream extent and values are avoided to the extent practicable. As noted by Mr. Collier, the applicant's commitment to the stream and Te Puna protection and enhancement were agreed to early on with engagement with tangata whenua of the area, and that included with workshops with the kaumātua and through Prairie Rakau's RMA manager Julie Shepherd at that time, thereby satisfying policy 2. Contrary to the evidence of Mr. Hamill, Ms. Wilcox's opinion and her evidence is that the buffer margins and wetland reserve areas are also sufficiently large to enable considerable riparian planting opportunities to improve the quality of these streams and tributaries. And these streams and their margins are already well defined on site. The delivery of the outcomes sought by the National Policy Statement on Freshwater Management will be demonstrated at the regional consent stage of the development for a stormwater discharge and stream walks consent. However, the proposed plan change is consistent with the provisions of this National Policy Statement by way of avoiding the loss of watercourses and providing for the ongoing protection of wetlands to be created as part of the plan change area. Turning to the regional policy statement, I won't cover what's been covered in the planning evidence in relation to this, but I note that I'm only covering here the matters in regards to the RPS in the context of national policy statements and where they're currently out of date, because those national policy statements on the NIPSID 2020 post-date the RPS in relation to urban growth. So there's been a recent plan change to the RPS, which was required to include the HBA assessment of bottom lines. But other than that, that future plan change has not occurred to align the two. And I just note there that in this regard, that means there's incomplete coverage with regard to business and housing capacity that councils have been directed to enable, even where not anticipated within existing growth areas. And that's identified in Appendix E to the RPS. And I note there that business land in the RPS was last updated in 2018. As noted by Mr. Collier, however, there has been no business land zoned in Te Puna since the 1990s. Future development strategy for housing and business land following NIPSID 2020 for the sub-region is due in 2024. And these changes to the RPS will need to go through a plan change process and will therefore be some time away. One, I'll just cover that. And so the extent to which the urban growth provisions in the RPS are contrary to or inconsistent with NIPSID 2020, as such as that cited in Beth Bowden's evidence as UG 7A in the RPS, priority must be given to the up-to-date national directives in NIPSID 2020 until the RPS is updated in 2024. Turning to evidence in areas of disagreement and issues for determination for the panel, I turn to Mr. Tapari's evidence on behalf of the Regional Council, which states in paragraph 24, and considering proposals to urbanise land, it is not uncommon to undertake a process to identify and resolve competing priorities, i.e. land use and stormwater ecology. This is correct. However, Mr. Tapari does not cover at all the competing directions of NIPSID 2020 and prescriptive directives that the Regional Council must adhere to with respect to providing for business land with the competing NIPSID fresh water. There is no reference to this document at all, nor attempt to analyse this competing priority. The Regional Council's original submission recognises this broadly, where it states overall the Bay of Plenty Regional Council does not object to the principle of either plan changes 93 and 94, as we recognise the need to provide for increased commercial and industrial development capacity in each of the locations. The evidence of the Regional Council witnesses appearing must be viewed in the context and scope of its originating submission, which does not object overall to the rezoning proposal for land to be rezoned from rural to commercial. Some of the evidence filed by submitters raised new issues or areas of disagreement, some of which were not covered through submissions lodged. The applicant's witnesses have, however, attempted in good faith to address relevant RMA issues, even though the rebuttal evidence, to the rebuttal evidence filed, so that the committee is assisted in narrowing of issues and with a clear understanding of the remaining areas of disagreement in the various experts' evidence. It is unfortunate for the panel that the aim of local authorities to reach agreement or gain focus in areas of disagreement with the plan change, so the overall cost of the proceedings to all is reduced, has not happened with the Regional Council. The duty of local authority experts engaging in the plan change process in particular should be to narrow points of interest, difference and save hearing time and cost, with the aim of reaching a common understanding of the relevant facts and issues. The Section 42A report has been criticised in submitters' evidence for being cursory or incorrect in some of the characterisations of submitters' positions. And that was in the evidence of Mr. Kirk and the Te Puna Hall Committee. However, where there are relevant issues of concern set out in submitters' evidence, these are subsequently addressed by the applicant. And in my submission, the hearings panel can rely and refer to the Section 42A report and rebuttal evidence, which succinctly identify and focus on the key issues of disagreement between the experts. I submit that the areas of differences in evidence for decision-making of the panel are not significant. There are effectively two appropriate zones which the panel needs to decide between for a small piece of land, where the zoning is being changed by weighing up probative evidence that is supported by sound facts and assumptions. The submission and subsequent evidence filed by Beth Bowden on behalf of Te Puna Heartlands and Ms. Gravitt of the Te Puna Committee is concerning in several aspects. Firstly, the Te Puna Hall Committee is an incorporated society set up for the purpose of operating the Te Puna local hall. It is effectively operates by virtue of the good graces of council to provide it a peppercorn lease to be located over council land. Having reviewed its constitution and the council lease agreement, in my submission, it is questionable whether the Te Puna Hall has legal scope to be making a submission to a plan change, as it does not fall within its objectives as an incorporated society as set out in its constitution. There's a question of appropriateness of opposing a plan change in an area to which council officers have recommended be granted and to which your own committee chair provided support for. This occurred at around the same time as the land was offered by Mr. McIntyre to locate the hall, and as noted in the evidence of Ms. Michael, he provided support for the resource consent to enable the hall. There has been no information as to their number of financial members by either the Te Puna Heartlands or the Te Puna Hall Committee. Recent financial statements are not recorded with the company's office. The extent to which either they, on behalf of the Te Puna Hall or Te Puna Heartlands Committee, have been mandated or delegated to speak, act, or represent the wider Te Puna community is questioned, given there is no detail provided as to who they represent. It is normal for societies to clearly identify their financial membership numbers with submissions lodged or subsequent evidence filed. While there is no doubt Ms. Gravitt and Ms. Bowden as local residents on these local committees are both individuals who are passionate about their local community, and this is to be commended, they do not have a mandate to speak for others beyond current financial members based on current financial returns filed with the company's office. If there are committee resolutions in place for them to speak on behalf of financial members in accordance with their incorporated society rules, it is suggested that these details need to be tabled with the committee. Further, the applicant has not received any formal advice that the written approval for the plan change provided by both the previous Hall Committee chairperson and secretary have been revoked by the current committee. And it is unfortunate that Ms. Gravitt indicates in her evidence that the current committee has no knowledge the prior committee has provided written approval to Mr. McIntyre for his future plan change. No doubt, under good faith reciprocity for his approval of the Te Puna Hall to be moved onto his land that was subsequently sold to council for this purpose. It seems trite to point out that it is the current appointed councillors who are representatives elected to act for their communities and have statutory duties under the Local Government Act, RMA and other statutes. Ms Bowden appears upset that the current council has resolved to allow Te Puna Springs commercial zoned area to connect to wastewater. And I might note there, as noted by the chair, subject to it being granted by this hearings panel. Whilst this is not a matter that can be challenged through this RMA process, it seems incongruous that the Te Puna heartlands should seek to oppose what is a significant environmental improvement to the current situation of unsustainable on-site effluent disposal in the area. It was a significant issue of Te Puna Hall when it planned, and that's through the designation process, I might add, which was a contested hearing, planned to utilise a septic tank disposal method when it is open to public events and within what effectively is an urban area close to streams. It is expected that the Te Puna Hall will be connected to the reticulated system as the pipework has already been extended to this area. Ms Bowden does not have any professional or technical expertise in planning or engineering, and it is submitted that these technical issues are addressed in the expert's evidence. It is for the panel to assess the remaining narrow areas of disagreement as set out in the expert witness statements, and where there is conflicting expert evidence, this will need to be weighed up. There is a limited number of topics and the planning positions taken from the planners involved in this hearing. Mr Child's evidence focuses on planning, providing some helpful suggestions relating to the interface with Mr Kirk's property and the commercial zone to avoid reverse sensitivity with kiwi fruit operations and to address potential visual effects. There are valid concerns raised in Mr Kirk's evidence regarding concerns over reverse sensitivity, which have either been agreed with, clarified as already addressed through plan provisions, and I note that that was covered by Ms Price in terms of existing district plan provisions, and with respect to the error on the structure plan referring to 2 metres, that will be corrected and updated structure plan provided to the committee. Or where they are disagreed with, that has been clarified in the rebuttal evidence of Mr Collier and Mr Hugo, and that was filed yesterday. The commissioners will need to weigh up the expert ecologists and engineers' evidence of the Bay of Plenty Regional Council and the applicant to inform their decision as to whether the matters are addressed through the plan change or appropriately able to be managed through subsequent consents required for the plan change area. If the panel consider that the site should be recognised for commercial use, then the zoning with the structure plan with updated amendments and the proposed plan provisions are considered most appropriate for the site. Criticisms with respect to the operative plan provisions raised in the Regional Council evidence are not part of this plan change and should be left for the next full plan review. It is understood that full plan review will be required by both councils by 2024. The evidence of the applicant is sufficiently robust to provide support to rely on as to effects. The site is sufficiently small scale that it will easily achieve coherent integration with the future plan reviews or future plan changes, with future strategies enabling more urban zoning for either residential or business land. The only issue of disagreement between the council reporting planner and Mr Collier is reflected in the section 42A report is the issue of permitted height for the commercial buildings. Mr Hugo and Mr Collier's evidence covers the reasons why, in their opinion, a maximum height of 12 metres can be supported within the plan change area without adverse effects on the surrounding area. And I would just note there that the rebuttal evidence of Mr Hugo does provide a helpful diagram of the necessary setbacks of a building of the various sizes, which shows how much it will need to be set back depending on whether it's 9 metres, 10 metres or 12 metres, and he will go through that with you. There have been some additional suggested changes to the provisions in response to the evidence of other submitters, which should give the panel confidence to prefer a commercial zone with the proposed provisions. The proposed zoning and provisions ensure consistency with existing uses within the structure plan area, the future outcomes sought for the site, as well as integration with other chapters in the Western Bay Plan and compliance with higher order documents. The plan change represents a block of land with significant potential to provide a modern and mixed-use commercial development to complement the existing Te Puna commercial areas, either zoned or consented. Turning to non-statutory documents, Some submitters have referenced non-statutory documents or strategies that have not followed either a full consultative process under the LGA or the RMA, and that includes the Te Puna Heartlands document. It's not a statutory document. There are several cases that directly oppose the appropriateness of giving weight or relying on non-RMA statutory documents when going through a Schedule 1 process. There's a namely Infinity Group versus Queensland Lakes and Redvale Lime and Wigglesworth. Section 74.2 states that a council may have regard to management plans and strategies prepared under other acts. However, it is submitted very little weight should attach to non-Schedule 1 strategy documents cited, unless they have been formally prepared under a similar public consultative process as expected for significant policy documents under the LGA. Clearly, even less than the minimal weight that can usually be given to statutory instruments newly proposed and not yet tested by submissions was cited in the Infinity decision, and in Campbell versus Napier City Council at paragraph 57, the court stated, we can place little weight on these documents for two reasons. First, they cannot be a substitute for statutory documents produced under the processes of Schedule 1 of the Act by which the public are entitled to comment through formal processes of submissions and appeal. In the case of Tram Lease versus Auckland Council, the court considered a spatial outline plan that addressed strategic management for Auckland's growth as a non-statutory document. Its only intent was to inform strategic planning for the Auckland Council that will have informed the preparation of the proposed unitary plan. The court held that it could have no status in the court in the context of a plan change. To that end, the court gave no weight to the aspects of evidence of the witnesses that relied upon the spatial outline to justify intensification of commercial buildings within particular zones. This is similar to evidence that seeks other consultation or spatial plan to be given weight with regard to this proposed plan change process. The public process of a plan change provides for members of the public to have their say on proposed plan change 93 as a private plan change that was fully notified to the public. The public is able to comment through submissions, and a public hearing is the opportunity for public comments and evidence. There has, in fact, only been a very limited number of opposing submissions to this plan change, consistent with an indication that this plan change is acceptable to the majority of the community. Most of the submissions in opposition have had the issues raised addressed to the point of not appearing, or the applicant being prepared to amend the plan provisions to provide for the relief sought, i.e. Te Toi Public Health and the Te Puna Hall with respect to removal of permitted industrial activities from the permitted plan provisions. It is certainly not a rushed plan change as suggested by Ms. Bowden. As the panel will be aware, the intention for this land to be rezoned has been well known for over 5 years. The plan change has been delayed several times, including to allow for community consultation to be undertaken by the council and for wastewater matters to be addressed. While some of the submitters may not like the plan change as proposed, it is not a reason to either delay it or decline it. A zone rather than a land use consent provides the flexibility and environmental standards necessary to meet changing needs for shopping and decentralised employment as the community grows and expectations change. A district plan needs to recognise and support the changing nature of demands for business land, which includes in areas outside of centralised centres where it can be provided efficiently and effectively. There is more than sufficient expert evidence to provide confidence in the outcomes projected, as enabled by the rezoning to support a commercial zoning of the site. The suggestion that declining this plan change needs to happen to wait for a fuller plan review is not sustained by any robust evidence or supported by the directions of NIPSA 2020. Repetition of this assertion by various submitter witnesses does not provide any further evidence of weight to be given on this issue, which is outside of the scope of the notified plan change. In terms of concluding statements, just turning back to the evidence, Mr. Rayner's and Ms. Wilcox's evidence and rebuttal evidence proves that there is a sustainable stormwater solution for the site that will result in ecological and steam enhancement because of the plan change. The expense and extent of the detailed engineering and ecological analysis undertaken exceeds that necessary for a plan change process, and I should note they're of this nature and smaller scale, but has been completed by the applicant to counter the concerns of the Regional Council raised in its submissions, which are limited to discrete issues related to stormwater and freshwater. The committee in its deliberations will need to be satisfied that there are sound stormwater solutions available to support the plan change. I submit that there is, as outlined in the evidence of Mr. Rayner. Further, the solution does not rely on site mitigation such as attenuation of stormwater under car parking areas, which is also available to the applicant if required. Mr. Collier has suggested further provisions in his evidence as permitted standards for stormwater that will apply to the plan change under the structure plan provisions for the site that address the regional council's concerns as to water quality as relevant to this plan change. Water quantity volumes have been modelled and addressed by Mr. Rayner, who confirms the additional runoff from the site will add less than 1% to the overall catchment. The evidence of Mr. Hugo addresses the matter of building height and scale and concludes that the concerns raised by Mr. Perkin as planning witness will be addressed through the plan provisions relating to daylighting that mitigate height through setbacks. The evidence of Ms. Wilcox and the more detail in the spatial structure plan provided by Mr. Rayner's rebuttal confirms that the stream can be retained and enhanced by keeping the stormwater pond offline from the stream tributaries running through the site. In summary, the rezoning of land sought through the proposed Plan Change 93 provisions are, in the opinion of Mr. Collier and Ms. Price, as the council's reporting planner, to be the most appropriate outcome for the site and will best achieve the broad policy objectives of NIPSA 2020 and the purpose of the RMA. The zoning and provisions now proposed align with national planning documents and good planning practice and are efficient and effective. The commercial zone, by meeting existing and short-term demand for business land in this area, will discourage ad hoc out-of-zone uses to be applied for on other rural zone land in the future. The applicant seeks plan provisions that address the benefits and amenity the commercial area will provide to the community, recognise and support changes inherent in the commercial area over time, while addressing infrastructure, cultural and environmental issues. It is acknowledged that the likelihood of future changes over the next 10 years and beyond that may affect Te Puna and the wider region, but it is considered the interrelationship effects on that process from the small parcel of land being rezoned, as suggested by submitted witnesses, is not just subjective and speculative, but factually incorrect, as one will not affect the other in any material way, given the size and character of the land included with this plan change. Te Puna Springs requests the hearings panel confirm the commercial zoning in the manner proposed in Mr. Collier's evidence and as modified through amendments to the provisions set out in the additional evidence provided in response to other submitted evidence. Thank you.
Thank you, Ms. Barry Casino. I'm going to call a break now for morning tea, and we'll return after that for any questions there may be in relation. So we break for 15 minutes. Plan to be back here sharp at 11:20. Available in I'd like to call our meeting to order again, please. And so, Ms. Barry Pacino, thank you for your presentation there. I'd just like to give the opportunity for the panel if they have questions for you before we proceed with the other evidence. So, no. Commissioner Withy? No. All right. It seems it was very well explained.
Off easy.
Thank you
Great.
for that. So now I'll let you resume your own order of evidence, and you can, I understand Mr. Heath was online some time ago, but up to you.
Yes, sir. The intention was for Mr. Heath, and if he is online, I'm not sure if he can hear me.
Yes, I can. Thank you.
Thank you, Mr. Heath. If the panel has read your evidence, but I wondered if you could please point to the key matters in your evidence and highlight them. Introduce yourself as well. I'm not sure if the committee knows you, and also answer any questions. Thank you.
Yes, thank you. It's good morning, everyone. Tim Heath, proprietor of Property Economics, been assisting with this plan change for a few years now, and do a lot of work around the country, and have done a lot of work in Tauranga and the Western Bay of Plenty for the last few decades now. So know the area and some of the growth issues that Tauranga are facing pretty well. I have produced a summary statement, and with your leave, I'll take as paragraphs 1 to 7 as pretty much taken as granted. Paragraphs 8 to 13, there's only a couple of main points really that I'd like to touch base on, and that is the existing commercial zone's been in place since the early 1990s, and nothing's really happened from a zoning perspective in Te Puna for almost 30 years. So, and clearly there are growth pressures and growth demands in the area with some of the ad hoc commercial development that has taken place in the ensuing years. From an economic perspective, the location of the subject land makes sense from an economic efficiency point of view. It tags onto the existing commercial zone and can tap into, and it's pretty accessible for the market it's designed to service. A quick point on population growth. The growth in my report that I did, which was a couple of years ago now, has been superseded with updated growth projections. So this is to sort of highlight some of the impacts of demand, or the growth in demand in Te Puna. In my original report, the projection at the time, the population base that was projected for 2028 has already occurred. So the current population base in 2020, in the updated population base of Te Puna catchment in 2021 was projected to occur in 2028. So it's running 7 years ahead of schedule, and that was the high projection series. So what the updated projections acknowledge now is that growth is occurring at a faster rate than that was anticipated. The new projections under the medium scenario for 2038 are 17% higher than what I insist in my report. So what that points to is my original report identified growing commercial demand. That's simply been amplified now with the updated growth projections, which reflect a population and a market which is growing faster than anticipated originally. So it's a positive thing, to be honest. Having to manage growth is a good problem to have, not a bad one. Excuse me. And I think the plan change would allow Te Puna to become a more competitive business location, and that's really important for fostering the local economy and local employment. And there's a lot of ensuing economic benefits to the local community if you can internalise some of that spend and employment within a local area. So that would certainly assist the ongoing development of Te Puna and its economy moving forward. As I've mentioned, the subject site is considered to be efficiently located and an appropriate site for expansion. And in my view, I think the proposal will foster development that is complementary to the existing activities. And in my experience in seeing plan changes like this in some townships around New Zealand, is it can act as a bit of a catalyst to encourage and facilitate further development above what's originally projected. So I see the Te Puna Village being a catalyst rezoning that will enable the development to occur to meet the market. And a good example of that is a similar type or similar scale type of development is Matakana up in Auckland, where it developed a niche, and the development of the Matakana village actually facilitated development of the broader rural area as well, and opportunities for that. So I think this could have a similar effect in Te Puna, which would be a great thing. So with those sort of overarching comments, I'm happy to take any questions you may have.
Thank you, Mr. Heath. Questions? Councillor Granger?
Thank you, Chair. Just on your latter comment there about further development, this plan change encouraging further development, are you envisaging in that comment further expanded commercial areas, or what exactly did you mean by encouraging further development?
No, not in terms of a further expansion of the commercial areas necessary, but what I'm saying is that development of that commercial area or commercial zone area could occur at a faster rate. And that development can also lead to additional business activity occurring in the rural production area as well. Because you're going to get support services and amenities that's required to facilitate and meet growth in the local economy. So I'd anticipate that the build out or the growth of business development within the zone would occur at a faster rate than was originally anticipated.
So you're meaning an overall improvement and raising of the standard of what is currently there in various parts of that.
Absolutely.
Yes.
Yeah, absolutely. More people, more money, more growth. It creates a better quality commercial environment.
Thank you.
Yeah.
Councillor Dean?
Mr. Heath, I wonder if you could comment on the implications or results of when the TNL is constructed. It's underway
Yes.
now, and what that would potentially mean for the Te Puna village and development, perhaps more generally in Te Puna area.
Yeah, I think clearly there might be a softening of some of the traffic that goes past the village directly, but I don't think what we've seen, for example, in Matakana, is that it becomes a destination in its own right. So people will still, who want to access that village, will still be able to in the future. So that potential loss, I think, is mitigated by Te Puna being able to be its own niche in the market. Just because a car is not driving past it, it may lose a little bit of opportunistic type of spend or capture from the market from that State Highway 2 traffic. But overall, I think the impacts are likely to be muted, given the commercial zone and some of the store types that are likely to be developed there.
Yeah, thank you.
Yeah.
Thank you.
Commissioner Williams? No. Okay. Thank you, Mr. Heath.
Thank you very much. Thank you. Cheers, Kate.
Thank you, sir. Next witness is our traffic engineer from Oricon, Miss Anne Fosbury, who's sitting behind me. Your evidence, but if you'd like to introduce yourself and point out the key parts of your evidence that you'd like to draw attention to, and then answer any questions. Thank you.
Good morning, Anne Fosbury, Traffic and Road Safety Engineer from Oricon here in Tauranga. If I could have the PowerPoint presentation up, so there are a number of slides that I would like to talk to. What's the
I
thing?
think yeah, I'm pretty sure that's the thing where the signs and that's the
Pointer?
point.
Yeah, that's the pointer. Yeah, the one's taken up this. Thank you. So what I would like to do, Mr. Chairman, is just do a general sort of transport description. Thank you. I'll look at the screen and talk to the mic at the same time. So State Highway 2 through here, Minden Road, Tapuna Road. And just from the wider context, when Takatimu North Link is operational, the road, State Highway 2 will be closed up here near Loop Road. So there will be no traffic coming through here, apart from the residents that are serviced by that cul-de-sac. As those of you who are well versed in the traffic issues currently in Tapuna, when State Highway backs up through here, bottle is in the way, excuse me. So now we better move that because I don't want to do an alimony. All right, so when traffic backs up through the roundabout in the morning peak and holiday peaks, those people in the know will come through the slip road through here and up around and cut through to come down through Tapuna Station Road out by the Wairua Bridge, which results in queues both on State Highway and Tapuna Station Road. And now to a certain extent, those people are also shortcutting down Snodgrass Road. So once Takatimu North Link opens, there will be no demand for traffic to take the slip road to avoid any queues, because there won't be any demand on that section. So in relation to that, this particular section of the development is proposed to not be generating traffic from development until the new State Highway 2 is operational. As you may recall, there was a link road originally that came through here. And as a result of the submissions, that has been removed, and we now just have the single cul-de-sac from Tapuna Road. To give an idea of what type of traffic might be generated, there is an example in my office, in my evidence, for a type of permitted activity, but potentially depending on what businesses develop within there, the traffic generation may change. And at that time that resource consent is applied for, those effects will be dealt with and managed at that time. So overall, from the changes that we've undertaken in the structure plan, we've dealt with the majority of the original submissions around traffic. I just wanted to talk about walking and cycling, and hopefully there is a, here we go. This is the Takatimu North Link planned shared path. Just to get some context, this here is the Takatimu Drive toll road. And this is Loop Road here, which will be where the stage 1 of Takatimu North Link terminates. We have Minden Road in here where there is a full interchange, full diamond interchange, so you can get on and off in all directions. If you want to go to Tapuna to carry out any business, or if for some reason you decide that you don't want to use the new road, you can get off and use the old road. However, this will be much quicker. The green is the proposed shared use path that you can see connecting to various bits and pieces. This here is the Cambridge Park K Valley BMX Park. This is the new Smiths Farm potential development, and the new road comes in behind Smiths Farm to a new intersection down on Takatimu Drive. And basically there will be a full shared path connection to Minden Road. There are footpaths on either side of this section of State Highway 2, plus all the way down to Puna Road that connects to the Omakura Cycleway that runs between the Wairua Bridge and Omakura. So that wider network walking and cycling is going to be completely connected. Internally within the structure plan, there are no current footpaths and other alternative transport links shown. And as discussed by Anna Price, that is something that will be part of the more detailed assessment when the resource consent applications come in. But rest assured, those people will not be forgotten. Let's go back to here. So a couple of things I was asked to address was that looking at whether there is potential to have this location, this access to this area further north. I think that was a question from one of the commissioners. The road access is required to get to the stormwater treatment area for maintenance. So there needs to be an access at this location. To put an access up here isn't really going to provide the access required for ongoing maintenance of the wetlands and stormwater ponds. There is potential to maybe move this a little further to the north, but you wouldn't want to move it too far. We've got another access in here to DMS, which would interact with that. This access here to DMS is an exit only. So moving it slightly north, that would be fine. But if you move it too far north, you're then conflicting with this one. And as I said, if you move it way up here, then you've lost your access to your stormwater. I had wanted to mention, I think it was in Mr. Child's evidence, he did talk about the future 5,000 to 8,000 residential development earmarked for Te Puna in the UFTI report. That's a 30-year plus timeframe for that development. That's really not relevant at this point in time. The only project sitting within UFTI relating to Te Puna is planning in the next 1 to 5 year timeframe for Park and Ride, with development of the Park and Ride in the 5 to 10 year timeframe. So that would fit quite nicely in with this development, with the potential to have Park and Ride facilities once we don't have this shortcutting traffic coming through this area. I think that's all I wanted to comment on at the moment. As I say, I think we've addressed the majority of the transport issues that were raised by submitters. Based on the further evidence that's come in from them, I don't believe there are too many other issues to address. Thank you.
Okay, thank you, Ms. Fosbury. Could I ask firstly then, you highlighted in terms of that access road there, that if it was moved too far, you would lose the access. Yes, you'd lose the access to the point and the ability to attend to the maintenance of the ponds and wetland area. But if it was moved to the northern boundary as asked about by councillor Granger and a loop around down to that same point, is that a possibility that could be considered? Yes, just like
As in
that.
a kind of dog leg.
Yes,
It is potentially possible to do that. It really does depend on what kind of developments go in there and what kind of traffic they need to accommodate. When you are dealing with right angle bends and large vehicles, you need quite a lot more room, quite a lot more road reserve. So that is a more detailed issue to deal with at resource consent. But I guess from a structure plan perspective, the location is somewhat indicative.
Yeah.
So there is some flexibility within that.
okay. Thank you for that.
It may be that Ms. Masters might like to comment on that at a later stage as the owner of the land. Yeah.
Okay, thank you. Panel members. Councillor Granger.
Thank you. The BP station is my local supply of 98 fuel, so I make a number of trips in there and therefore use the little exit onto Tapuna Road. And I would describe that intersection as awkward. The sight lines are not wonderful there because of the offsets and kinks, and so having another intersection with a number of vehicles coming out of it there, relatively close to that. Have you got any comment on that spatial distance in terms of the traffic engineering and requirements between those 2 points?
This is a particularly wide intersection, and my view is that it would operate more safely if it were a roundabout. He's smiling. But from a structure plan perspective, that's kind of out of where we are at the moment. But any potential upgrades as a result of whatever develops in there, that has potential to be altered. I don't know how long the BP service station will remain when there is no State Highway 2 traffic. It financially becomes not as not the moneymaker.
Thank you. Councillor Daniel.
Yeah, a couple of questions from me. Could you comment on the implications for the traffic going past there and whether they decide to toll the Takitimu North Link or not? That's my first question.
I have asked whether there has been a decision whether Takitimu North Link will be tolled, and I have been told that there is still no decision on that. If it is tolled, then there will be some people that will not want to pay the toll and will get off at Minden and come back through and use the old state highway. There may be some chopping and changing. People tend to test a route, and it can take 2 or 3 months for people to decide exactly which is most efficient for them. And it does depend on how you value your time. So I travel that road every day to get to work and to get home again. I don't care that it's tolled. If it's tolled, I will be staying on the toll road. But it won't stop me visiting Tapuna because there are businesses there that I go to. So I will get off to do that, you know, to get my dog food at the butcher's and that kind of thing. But there has been modelling within the regional model, and there are changes in traffic volume. Obviously, if it is tolled, there will be fewer people on the toll road, and more people will divert back to State Highway 2. That doesn't necessarily mean that this road will back up, because it just depends on how many people move. But potentially there could be additional people coming down here and doing the right turn to carry on down State Highway 2. Only if this became congested, which would suggest that maybe the toll's too high, I don't know, that they might pop back down here to come around to Puna Station Road again, but
yeah,
it's in my crystal ball.
Thank you. The other question I had was, as you sort of following on from Councillor Granger's, is that you mentioned you couldn't move the access road too far north because it would interact with the DMS entrance.
Yeah, there's another one in here. Yeah.
Yeah, but when the existing slip road already interacts with the shopping centre entrance road,
Yeah.
is that not a problem that we already have? So there, where you're pointing,
Yeah.
those two roads interact, and it's quite an awkward junction, as Councillor Granger says. So given that we have that, why would it be a problem to have an equally non-ideal situation if the road was slightly further north?
This is a Wakakatahi New Zealand Transport Agency product. I agree with the comments made, having used it myself, about some difficulties with sight distance. But that doesn't mean that what we will want to produce for future access, it doesn't mean it'll look like that, because two wrongs don't make a right. So we are much more focused now on safe system. And to get a safe system intersection, you need speeds to be 30 kilometres. All right. If you impact a cyclist or a pedestrian at any more than 30 kilometres an hour, their chance of survival it diminishes quite rapidly. So I am very much in favour of having low speed intersections to make sure that those vulnerable road users aren't likely to get killed or seriously injured. And this is my crystal ball again, I would see that as Te Puna develops, there would be a change in the speed environment through changed speed limits and infrastructure to support a lower speed environment, which may include raised safety platforms at some time in the future as part of the design of those access ways in the resource consent process.
And would it be fair to say that irrespective of the posted speed limit, the further north you go, the faster the cars will be going anyway?
Yeah, changing the speed limit doesn't change people's behaviour very much.
That's what I mean.
So you need to undertake other infrastructure improvements to encourage them to slow down. If there is no further development up here and this remains rural, it's currently signed at 80 kilometres an hour, posted at 80. That is probably appropriate for the type of development that's in there at the moment. As you enter into an area that is becoming, I think Mr. Mornay's evidence, peri-urban, that's when you need to look at some kind of infrastructure change to encourage people to slow down once they enter it. And that potentially would apply coming through here as well. This section is currently 90. 60. No, within Te Puna it's 60. As you head towards Tauranga, it goes back to 90. I'm aware that they are looking to drop the speed limit between the Wairoa Bridge and Bethlehem to 50 in the next block of speed limit changes, which will then potentially see this piece drop from 90 down to 80 to match the rest of State Highway 2. That drop in speed limit at Wairoa Bridge is due to the extending the cycleway from the bridge.
Thank you.
Sorry.
Ms Fosbury mentioned about moving, and there were some questions around moving the road further to the north and the access to the stormwater ponds. I just wanted some clarification whether it was possible to have an access or maintenance track to the stormwater pond from another point within the development, say alongside the hall site, car park, or somewhere else that may give alternate access to the stormwater pond, which may then allow the road to be moved further north. Thank you.
Okay, thank you for that. You get that question clearly?
Yes, I did. Thank you. All things are possible.
Okay, so it could be considered.
Could be considered, yes.
Thank you.
Thank you,
Okay.
sir. I would just wish to note around discussions of roads being moved north, the affected party to that would be the Kirks and Doug Kirk. So any discussions around that, the applicant would like to confer with Mr. Kirk whether that's something he may or may not want in that regard.
I'm sure we appreciate that, and
Yes.
we're not trying to reach a conclusion
Right.
at this point. We're just trying to understand what the possibilities
Okay.
are for when we come to making decisions
All
about
right.
our
Thank you.
recommendations. Please don't read into it that we've
All right.
got something we're trying to
All right.
achieve.
Thank you, sir. If I could now call Mr. Rayner, who will be providing engineering evidence on stormwater and infrastructure engineering.
Yes, good morning to the Hearings Committee and others present. So I'm Neil Rayner, a civil engineer with Oricon, based in Tauranga, have been for nearly 27 years. So within my presentation, in terms of my initial statement, I'll just highlight a couple of the items there. We'll take most of it as read. Particularly the wastewater and water issues, I believe there's no issues, so I won't dwell on those. Then I will talk through the stormwater, the revised plan that's been put together in response to concerns from other submitters in the Regional Council. And just summarise the what we'll put in my rebuttal evidence. So in terms of my original evidence, I said the wastewater is resolved with the ability to connect to the main pipelines, Yamakaroa transfer main, and water reticulation. There was no issue with that. In relation to stormwater management, within my evidence at 612, in response to discussions we'd had with the Regional Council following their submission, I can confirm, I guess, the assessment that we have done, as alluded to by Mr. Collier, just in terms of utilising this area here, which is very much an existing valley or low area within the site. Our assessment was utilising that area to provide a combination of the stormwater attenuation to hold the peak flows back from the increased runoff. So that's akin to having your tap on really hard into your basin and your plug not being quite enough to deal with the tap. It fills up, but then you turn the tap off and it slowly releases it. So essentially that's attenuation. That's the concept of dealing with higher initial runoff off an area that wasn't as high before. So, and in addition to that, there's some wetland areas which also provide some what we call extended detention. So on this plan, it was what these small areas were there to sort of just diagrammatically indicate. So they provide the degree of treatment prior to discharging into the main attenuation basin, and they also then provide some of that initial extended detention as basically the more frequent rain, sort of just not a storm event, just something that happens more frequently, but does increase the flows off the site. It helps reduce those because those are the events that typically cause erosion of downstream channels because of that initial flood. The bigger events don't happen very often, and so they're dealt with through the larger attenuation. So in assessing this site, essentially the stormwater system that was come up with as part of the application did not allow for any on-site treatment or on-site attenuation to provide confidence that a stormwater solution is achievable for development. Those features, as identified in my evidence, have not been precluded, and they could well be incorporated within the development. The result of that would be that the extent of the area here, or in what I'll show soon in terms of the revised plan, could actually reduce. And so it just makes it easier to accommodate those things if those devices and features are incorporated within the on-site development. In terms of catchment-wide considerations, just in just above figure 4 of my evidence, see 621. There's a diagram there. This is out of the Western Bay GIS data. It just kind of shows 2 areas of the site. Sorry, 2 areas of the catchment. The large catchment, 515 hectares, is essentially the total catchment that at the Armstrong Road culvert. Armstrong Road culvert being, I guess, the first major infrastructure downstream of the site. So within that 515 hectares, the site catchment that's going for rezone is 6 hectares, and in itself is part of a 40 hectare catchment that actually passes through that on-site attenuation zone. So that provides, I guess, overall catchment a comparison. So just to get an idea, I guess, of scale, that's a larger catchment essentially tracks up the Minden Road, and at the top end, it's just pretty close to the lookout, to the Minden lookout. So that's sort of the extent. For those of you, I guess, you'll know the area and give you some idea of the extent of the overall catchment at the Armstrong Road. So my summary in terms of my main evidence and also the application supporting document was that the flood was able to be, the attenuation can be achieved on site to the standards required through the plenty stormwater guidelines to provide confidence that it can be achieved, but it certainly doesn't preclude that additional or features or part of those treatment can be achieved on the sites to actually make it easier. Following the submission of evidence, there's been further evidence from the Regional Council and also through consultation with the Regional Council, and as a result, if I change to, so essentially we've kind of reconsidered the site and particularly around the ecological features and values. So there was a few things. So the location of these existing streams that pass through the site from upstream has been sort of, I guess, more accurately defined. And this is the approximate location of the spring, which also runs through here. So these join together, and when you see on site underneath this large area here, there's actually a bit of a, not large, but an open body. You know, the stream is made wider. There's some standing water within there. So, so to avoid, I guess, reworking, the original scheme basically was making a larger basin generally in that area, and then recreating a stream bed and then revegetating it. So to avoid earthworking of the existing stream, what we've actually done is that that magenta hatched area is essentially an area that we would not be doing any works. We've got some blue areas either side, and essentially they are there to create additional attenuation storage. So that would actually be, we'd excavate down below to about the level of the water within within this mainstream. And they'd be connected to it with a couple of pipes at each end. So that creates storage outside of the area of the existing stream. So those are needed for the volume they provide, but they do so in a way that separates that additional volume from doing works within the main channel. And the bigger storms again, then the whole area does still fill up with water, including over the top of the existing streams, as does happen currently. And through that, I'd just like to clarify, there's been references to offline and online ponds through comments from Mr. Collier. So in terms of an online pond, essentially an online pond is where you have upstream catchments passing through. And so in terms of this main volume of the pond where attenuation, its primary purpose is that attenuation, that that basin with the low capacity outplug. So this is, in this case, it is online. What we have done is we've taken out of that excavation of the areas of the existing streams and the water body in here. So these storage areas are created, I guess, offline, but when the whole thing is in flood, then the whole area is underwater, and it is essentially an online pond in terms of how it activates. In terms of the treatment, so with these development areas, generally the wide areas, we have a pre-treatment pond, so that would be a wetland provide treatment, and some additional volume in there for extended detention. These are offline, and we've positioned those outside of the stream. So this one here would service this area here, so that the flow doesn't have to cross those existing streams, and then it would discharge into the system. So those are essentially offline, or those are offline. And this one here is bigger to accommodate the balance of the site. And because of the height, so they actually, we've got 1,300 and another 400, 1,700 cubic meters of storage, of which, as a wetland, 40% of that remains as water. So there's about 1,100 cubic meters of additional storage within these extended tensions to add to the storage in here to provide that overall attenuation. I have gone through and essentially determined what the volume is in here. This is a different shape and layout, and essentially by not excavating this area through here, we have reduced the volume available for attenuation storage. So essentially this area becomes larger than previous to accommodate, leaving that area alone. So essentially we are excavating further than we were than the initial layout proposed for that reason. And this area here is a larger size through dealing with the balance of the catchment, because essentially the runoff from here is not able to well, from this side cannot come across that one, which was part of the original proposal. And essentially with the height difference, essentially we end up with a buffer around that, a batter with access. So essentially it sort of ends up potentially taking up more room than some of this wide area. As I said, this is still based on providing all the treatment and all the attenuation within this area. So by incorporating potential other low impact design features and the car park storage tanks, then essentially these areas would reduce and you gain more benefit. But that is a more detailed design element. So the purpose here was to show that with leaving the stream areas through here, we could still come up with the required attenuation and pre-treatment and extended tension to service the development, to provide that confidence. So access, as I say, there's actually an existing access that runs down through here. You'll see from the site visit that would be still the primary access. There is a bit of a grade to get down there. There is a height difference, but as I say, there is an existing access that's used. In fact, it was used yesterday to actually gain access to these lower levels, which are the current levels through here. So this is a key, I guess, difference and from the previous concept. No, didn't go back. From the original concept. So, and it's been done to take into account. That won't go forward. Oop, it's gone through lots. While I've got this on the screen, this is essentially a cross section across that facility that utilising the existing. So I've taken it across where there is a wider body of water within the lower areas there. The blue is the existing ground based on LiDAR information. So what we're proposing to do is to leave that margin, leave a sort of height difference above the normal flow level of the stream, and then create this additional volume of storage here either side. We're sort of having to utilise this area as well. That is about the top water level, the 100-year event. And then the wetland, this is the wetland on the northern side, that would actually treat the runoff off the development before discharging into here. So there would actually be at that level, storage at the end of a large event as well. So that diagrammatically, I guess, indicates how we would actually create that. These low areas will have a pipe connection to the main stream so that they do empty out and then remains, well, I won't say dry, it'll be wet, it'll be damp, squidgy underfoot, but they don't have permanently stored water within these areas because we need those to be empty to have the volume ready for the next storm event. And that's just the same diagram, but based on an aerial, more recent aerial. So you can see that the hall is constructed in the car park, and just sort of where how that fits. You can see the existing tributaries through here on the aerial photo, et cetera, et cetera. So in terms of my rebuttal evidence, mainly in terms of responding to the evidence of Susan Ora, Kathleen Theolarden and Keith Hamill. One of the key things that's come out through consultation is identified in 3.3 of my rebuttal evidence in response to Susan Ora's evidence, in particular around the lack of on-site stormwater features for both attenuation, runoff reduction and treatment. There has been a proposal, and Mr. Collier will cover this in his rebuttal evidence and presentation, to put in an additional stormwater management provision with text something like identifies that at the time of building or subdivision consent, whichever occurs first, stormwater management measures shall be implemented where appropriate as follows. Point 1, the use of rain gardens and similar systems for water quality treatment. And point 2, stormwater detention tanks and park and car parking road areas for stormwater attenuation. So within my primary evidence, I did identify some of the proprietary features that could be, that are commonly used for those sorts of things. So there's nothing that hasn't been done before. So in response to, I guess, the consultation, so it is proposed to have that as some stormwater management provisions within the rules for the plan change. One of the things I've identified in my rebuttal, and once again, you'll see from the site, but on this aerial photo, this is an existing low area that sort of runs through here, and it does have the existing drains from the upstream catchments passing through it. So to run an offline pond from that would actually end up, going into a lot of higher ground. It's a lot more difficult to achieve. Because it is, that is I guess, the larger natural low area of the site. So in terms of the evidence of Kathleen Theolarden, within her evidence, she does refer to an assessment of the volume that would be available. So I have essentially through that come up with, in response, they come up with this alternative layout. Responds to that, and that will achieve the 8,300. cubic meters. In addition to that, as I identified, the wetlands will, and extended detention will provide an initial 1,000 or so cubic meters of storage as well for the big events. In terms of the effects on the lower catchments identified in Mr. O'Larden's evidence, the catchment diagram that I identified earlier from my evidence, taking that a step back, the attenuation pond basically attenuates the 10-year flow, the 2-year flow, the 10-year flow to pre-development levels, so that what is the flow rate that's running out of this pond into the drain, which then runs down through the properties to the Armstrong Road culvert. Essentially, in those events, those larger but less frequent events, the runoff is limited to the same amount. As identified, the extended detention actually reduces this very small but more regular rainfall. In the 100-year event, and we've allowed the 100-year event, including climate change, to the year 2130, so there's a climate change horizon allowance within that assessment. The peak runoff from is such that we take the runoff off the existing site, and then our following attenuation, the contribution from that site is 80% of that peak runoff. So actually reduce the 100-year event. It will run longer because obviously we've got volume, but it actually reduces that peak. So in terms of by undertaking that assessment and stormwater attenuation here, then essentially where the water is flowing, those peak flow impacts are mitigated because we're not increasing them, or in the case of the 100-year, actually reducing them by 20%. At the Armstrong Road culvert, as I said, the balance of the 515 hectare catchment joins it. So the site is 1.2% of that by area. But as a portion of the site are already, I guess, contributing larger areas of higher runoff than would it be rural, the actual impact of that additional development is probably less than a 1%. The next piece of infrastructure downstream is a railway embankment just above Boral Road. At that location, there's another 160 hectares of catchment to that point. And so the impact of this site is getting less and less than 1% at that point. And obviously any flow impacts are dealt with through the attenuation on site. So I've covered the on-site features. So in response to the last point, 5.1 of my rebuttal evidence and Mr. Hamill's evidence, and his evidence paragraphs 24A and B, refers to the loss of Raupo wetland, stream and tributary under the pond as it is permanently wet and deep. Just to identify that, clearly the stream and the tributaries are these areas here. The Raupo area is actually on site sort of within this area here off to the side of this small water body pond area here. So in relation to the streams, I think there's been a misunderstanding. The purpose of the attenuation, as I explained, was basically to have all that volume available. So when you get a big rainfall, it then fills up and then releases at a slower rate than that comes into the pond at. The rest of the time when it's not raining or not in a storm event, those areas are actually, as they are at the moment, just base flow running through the stream. So they're not permanently under a large body of water. The whole purpose, the whole way that attenuation works is that they actually empty out so that large storage volume is available for the start of the next storm so they can operate again. So though it's shown as an extent of ponding, this extent here, that's very rare that it gets to that point because that's the larger, very rare storms, and it does empty out. In this case, these sort of facilities, within a day or less than a day, they actually empty out again to a level of base flow only. So the whole, I guess, final design function, how that attenuation pond and the wetlands sort of work in with the ecology of the stream, will be covered by Ms. Wilcox and her evidence, but essentially where's the next stage of design would then start to take those sort of things into account, working with the ecology team. I'm available for any questions.
Okay, well, perhaps just to start to clarify, I've understood you correctly. The two ponds marked in blue,
Yes.
you said would hold about 1,100 cubic meters, is that correct? And then when the whole gully system's full, that was the 8,300 or whatever the number was?
No, not quite correct.
Okay, thank you. All right, I'm glad I asked.
Yes, me too. Okay, so these blue areas, they are part of the main pond. So that's the 8,000 cubic meters is sort of within that area there.
Yes.
The green areas are what receive the water directly from the development first, and so you can see that's 1,300 cubic meters. This one's 400. There is permanent water in those about 40% full. So the 1,100 cubic meters is the additional volume of water that's, I guess, that these green areas fill up to.
Okay, thank you. Okay, then just following up, we heard from Ms. Price this morning that council didn't have any flood information. Do you have any flood information as to how frequently these areas flood currently?
In terms of historic flooding, I don't.
Yes.
No, I don't. So what I have viewed is I guess the flood hazard mapping that's on the council system, which is obviously using is assessing what happens in a 100-year event with the climate change, and looking at where they flow through over on under the site,
yes.
And downstream to identify, just making sure that as an overall development, we're not actually going to block those or cause some issue, or that they are not, to make sure that we're actually incorporating those within our stormwater management proposal. Within the site, there is on the US, there are flow paths that come from the low point here, and also crosses the state highway and runs through the neighbours and then coming into the site. And also there's flow from the pack house over here. It's actually piped down here and discharges in here. So those areas are from the upstream catchment, and the assessment. The assessment that we've done basically accommodates those upstream catchments for those events. So we've accommodated those flows, and the management plan allows for those, and then by attenuating the peak flows here, as you come downstream, these are continuously flowing. Those flood hazard maps also show it flowing over Armstrong Road, so that's a flow rate effect, I guess, of that big event. And then because through this we're mitigating that flow rate, we're not having an impact on there. And as you get further down the catchment to the railway embankment, we're becoming such a part of the overall site.
Yeah.
Yep. So just going then to the railway embankment, are you aware of water banking up there historically? And if so, what sort of size is the culvert or whatever flows under that?
I'm not aware of water backing up, but
Yeah.
I would be surprised if it didn't. There is a large catchment
Yes.
there. Once again, I guess the predicted flooding is that it backs up there quite a bit.
Yes. Okay. Thank you. Yep, that's fine.
Currently.
Right. My colleague, Councillor Granger. My questions. Thank you. Councillor Daniel.
Yeah, well, thank you for the clarification. It was useful to understand what's going on the map. But perhaps you can just further clarification for me. The stormwater runoff from the eastern part, from the hall and the eastern part of the development, does that get piped to the northern wetland?
Yes,
It
that's
does.
correct.
Is it a pipe or just overland flow?
No, that would be piped. One of the key, sorry, it would be piped in terms of its primary flow. So the up to the 10-year rainfall event is piped. Let's go if I can. There we are. But what would happen in larger events? The key thing is to avoid. So in a 100-year event, I guess you've got these areas that become hard surfaces. They would be shaped, and this road would come down and would be a low area relative to the things to actually, so they take the overland flow. So when you get above the capacity of the pipe, so in a 100-year event or anything bigger than a 10, the pipes are surcharged, you end up with flow across the ground, and actually as part of the detailed design would need to be to accommodate that. So it actually comes down through here, and these areas here would, potentially off to avoid running through these wetlands, so that they would be piped initially, and when those pipe capacity exceeded, they run overland flow and essentially would need to come down through into the wetland down here, and down that access track is a common way of doing that because it's the lowest area and leads to where you want it to within the.
Yeah. And my other question was, with the attenuation ponds, what would their construction typically be? Are they lined, and how does, when you have the big flood and that whole area floods, the bunds which separate the existing stream from the attenuation ponds, how is their stability maintained, or is it just a low energy environment? Perhaps you can comment.
Yeah, so these ones here are low, about 1 metre, so that so they're not very high, and typically the water then becomes it fills up and essentially is full all the way across. So there's no actual big imbalance of water level from one side to the other. That's where instability would occur. So that the intention was it wouldn't necessarily be lined. There's an existing embankment that was formed, I guess, for a previous consent associated with the pack house across the outlet. So that will have been to some engineering standards, but that would need to be checked and confirmed. We're not looking to raise the water level really much. So we're not looking to line. There's a whole, I guess, raft of engineering design that would take place at the next stage. And that would include, the stability of the embankments, those very things you're talking about. So these small ones between the storage areas, they're very low, and that would, because the water level would go right across it, there's no imbalance one side or the other. So it'd only be if it emptied quickly, and then those side areas emptied slower. But as I was saying, that's very low level.
Yeah. But if you get the 100-year flood, is it going to be a torrent of water that just wipes out the bunds? That's kind of my point.
No, so because what will happen is it'll actually come in and it will spill out. So you actually end up with, so it's probably not the 100-year event. It's more like the 2-year event where you get those drains running, at just bank full. And so it's less and I guess less energy. So the 100-year event will be a lot more flow, but because the pond is full, it does get dissipated by that sheer volume of water that's in the pond. So it's typically the smaller, like the 2-year event or even a sort of more frequent than that, where essentially would get up to the level before it spills over. It's a lesser storm, lesser.
Okay, thank you.
But that is a detailed design element.
Thanks.
Thank you, Commissioner. All right, we're all done. Thank you, Mr. Rayner.
Thank you very much.
If I could now call Mr. Hugo Mornay Hugo on landscape architecture matters, and then we'll be finishing with Miss Wilcox, and Miss Michael, and then, sorry, never mind, ignore me, before lunch. Before lunch, we're going to try and get through Mr. Hugo and Miss Wilcox. Is that a good plan?
That sounds like a good plan, isn't it?
Thank you.
At the stage anyway.
Thank you. You've all pre-read the majority of the evidence, and I'm pretty sure you've got a clear understanding of everything I said. There were just a few little items I thought I'd raise, and then just dealing with some rebuttal evidence that was sort of written yesterday. So I just wanted to comment in terms of the existing commercial activities under item 8.6. I talk about the existing activities located at the Tupuna Village commercial node have been developed to a good overall urban design, landscape and architectural quality without the need for any specific additional urban design guidance over and above that contained in the district plan, built environment strategy and sort of wider urban design guidance nationally. So I just want to reiterate, I agree with the council planner that the proposed structure plan area does not present a unique and special characteristic that in particular needs any additional bespoke urban design guideline to be produced. And further to that, I also want to highlight that significant landscaping is proposed through the site and in those stormwater areas we just spoke about, as well as the inclusion of open green space and rehabilitation planting to the gully system. The landscaping approach provides for a high level of amenity to the site and will enhance the overall character and quality of the development. In terms of stormwater, I just wanted to highlight that I'm in agreement with the sort of changes that have been made to the proposed stormwater design that was just discussed, and that the overall quantum of stormwater area provides a really valuable area to provide additional amenity to the area and to the community at large, and the future inclusion of things like walking tracks through that area is actually quite a valuable asset and creates a good buffer between the proposed development and the surrounding rural land to the west. So that's kind of a key issue. I just wanted to look at the screen planting issue under 8.17 in my evidence, and just highlight that we are proposing to adopt the existing rule from the district plan, which allows for a 3-meter landscape buffer with 2-meter high planting, and there are some criteria around how quickly that needs to be established. I feel that this is appropriate for this site, and it has also been used all over the district in similar situations. And that I also just wanted to highlight that one of the criteria in the rules to be changed for this plan change is that any design relating to planting will need to be carried out by a qualified landscape designer and approved by council. So the quality of that will be maintained. Talking to the height issue under 8.2 of my evidence, the plan change proposes a new maximum height for the structure plan area of 12 meters, and this differs from the existing commercial zone height of 9 meters. In my view, the 12-meter height limit is of a scale that is compatible with the rural edge character and location of the site and will not detract from the surrounding commercial and rural land uses. In my view, the increase from 9 to 12 meters will not be significantly discernible from the surrounding areas, and this is also in particular due to the hollow in effect that this part of the area sits in. And just in comparison, it should be noted that 12 meter is provided in other commercial centres in the district, such as Te Puke and Katikati, which are actually fronting residential or adjoining residential land, and that, in my opinion, is a way more sensitive environment than the one that we're faced with under this situation. And under 8.25, I said that the from an urban design perspective, the increased 12-meter height limit provides a better use and efficiency outcome for the site and will ensure a better diversity of development that can occur on the site. Then just turning to my rebuttal evidence, the evidence is mainly around the evidence provided by Simon Childs. It was raised in Mr. Childs' evidence that he saw the plan change 93, that it was representing a spot zoning, and it was addressed earlier by the council planner. In terms of a spot zoning, I disagree with Mr. Childs, and in my view, the plan change is a formalization of zoning of the wider Te Puna, which is really a mixed use or peri-urban commercial node, and it extends the existing commercial zone to cover a long-established area and provide additional to the additional commercial needs for the community in quite a distinct area. I just wanted to also mention that further to this, I was involved in compiling a wider master plan for the Te Puna commercial node, which is really the other sides of the motorway, including this site, as a piece of work that was carried out for Western Bay Council. As part of that process, we did also consult with some of the surrounding commercial landowners, and that has fed into the development of this structure plan for the plan change area. Further to that, I just want to say that I agree with Mr. Childs where he stated under 2.3 in his evidence that the key theme through the strategic planning work undertaken in Te Puna has been the need to maintain Te Puna's rural character and the local community value that the area provides in terms of local services to local communities. In my opinion, I do not see other plan change as contrary to this due to its scale and the fact that it's occurring on land which is effectively already part of the village. The land is proposed to be rezoned under Plan Change 93 does not currently have a rural character, but is rather an existing mixed use, I used the word zone, but the correct word is mixed use area, which is rationally constrained and of a size and scale that is appropriate to the location. The rezoning is simply a rational urban design and planning mechanism to formalize and constrain the existing node to an appropriate size and scale for commercial activity in the area. Also, in responding to Mr. Child's concerns with boundary treatments in relation to the Kirk's kiwifruit orchard, it has been confirmed by the applicant's planner, Mr. Collier, that a buffer would apply to the northern boundary, which is that 3 meters and 2 meter high buffer. The screening must also be a minimum of 1.2 meter high at the time of planting and be capable of achieving a height of 2 meters within 2 years. In my opinion, this is an appropriate boundary treatment requirement and will provide sufficient landscape mitigation along the northern boundary. Further, by using the existing district plan rule, consistency is maintained with the wider commercial zones in the district. Further to the above mentioned planting buffer, the interface with the neighbouring properties is managed through an existing building setback and daylighting rule within the district plan. And in my opinion, I do not see a reason that the existing rule framework would not be appropriate in this instance. I go on to explain that under the operative district plan rule 19.4.1D relating to daylighting, all site boundaries adjoining residential and rural zones. No part of any building shall exceed a height equal to 2 meters above ground level at all boundaries and an angle of 45 degrees. So I've produced a little diagram as part of the rebuttal evidence just to explain what that means. And I don't know if we've got that on screen at all, that diagram that's attached to the back of my evidence, but interpreting that, in effect, what that means is at the 3 meter boundary setback, a maximum building height of only 5 meters can be achieved. If you were to look at a 9 meter building height, then that building would be set back 7 meters from the boundary. And in the case of a 12 meter height, as the plan change is applying for, that would effectively mean to achieve a 12 meter height building, you would be set back 10 meters from the boundary of those rural parcels. And you could obviously within that height plan have a sort of a stepping building that's articulated, which is a positive outcome from an urban design perspective. And I think, as again I've raised in my original evidence, is that it should also be noted from a wider landscape perspective, the Plan Change 93 site effectively sits in a hollow in the landscape with the surrounding commercial node on all 3 sides of the State Highway corridor and the neighbouring rural properties to the north and west being substantially elevated and visually dominated over the Plan Change 93 site, which is sitting in that hollow. In my opinion, this clearly establishes a scenario where the proposed 12 meter height limit can easily be absorbed within the context of the wider commercial node and direct surrounding rural landscape. The currently highly modified and mixed use nature of the area also creates a landscape situation with a greater ability to absorb change as proposed and thus being well suited for the proposed commercial use. that covers my rebuttal. Happy to take any questions.
Thank you, Mr. Hugo. Have any questions, Councillor Granger?
Yes, thank you, Sir Chair. I just want to tease out that last statement about sitting in effectively in a hollow. According to my reading of the contour maps, Mr. Kirk's house sits at about 20, between the 20 and 22 metre contour map lines, as does the subject site. So when they're on the same level, how does it become a hollow?
Well, the general landform is that the land drops through the whole level of the wetland pond area and then sort of levels up where the existing hall site is, and then rises again to the Te Puna village side across the road, and similarly rises up on the other side of the state highway. So effectively, if you look at that whole wider landscape, it is quite hollow, and that's that dip that you drive through as you perceive that. So
Yes,
that's
I drive through it quite often. I appreciate the other side. I was talking about to the north of Mr. Kirk's property.
Yeah, I'm describing the entire landform shape there. And if you stand sort of at the back of the hall and stuff, you can see that rises up to the Kirk's property on the other side.
Thank you.
So it is elevated.
Councillor Dino? Commissioner? Okay. Planner Price, do you have anything you wish to clarify? No. Okay. Thank you, Mr. Hugo.
Thank you.
Great.
Sir, and Ms. Wilcox. Ms. Wilcox, I just wanted to highlight to me, this is her first time appearing in front of you, so I'll ask her to introduce herself to you, and she may read from her evidence, but primarily focus on key aspects, including in her rebuttal evidence, which does address the regional council's evidence.
Should have it when I find it. I'll give it anyway. Okay. So, thank you. Okay.
Okay, good afternoon. My name is Fiona Wilcox and I'm an ecologist with Wildland Consultants. I've worked as an ecologist for almost 14 years now, and yeah, I undertook the initial ecological assessment of the site on behalf of the applicant. I will not go into detail on my original evidence or my original ecological report. There are a couple of key things that I wish to say before I get into my rebuttal, and that is, the main thing is that the level of detail provided in the ecological assessment was on the understanding that this was a high level approach to give an overview of what ecological values are currently on the site and what the potential could be for enhancement should the plan change go ahead. There was never any intention for this original assessment to be at the level of detail required for an assessment of ecological effects, and therefore I consider that my evidence should be read as such. In saying that, I do not disagree with the points raised by the Regional Council's environmental scientists. I think that the points they make are valid with respect to issues that should be considered in a detailed design phase. However, I think the level of detail they are requesting is more appropriately addressed during that resource consenting phase. Therefore, the rebuttal evidence I have provided, I've only done so in response to the evidence provided by Regional Council. One of the key, a few of the key issues that I believe have come out of the evidence are in terms of the accuracy of the mapping that has been provided. There are a few areas where it has been indicated that stream extent will be lost as a result of development footprint, and buffer zones are narrow, very narrow, according to the original buffer plan as shown on the screen. It was my understanding that this layout was indicative only, and that the final design of any buffers or restoration or enhancement of any stormwater ponds would be dealt with in a detailed design phase where we would do that in discussion with the stormwater team. Therefore, I do not think that it is accurate to say that there will be stream loss as a result of either development area 1 or any of the other footprints shown on that slide. Having said that, due to the issues raised by Regional Council, and as Mr. Rayner has already described, we have been discussing other options to ensure that no stream loss extent will occur. Again, the actual particulars of how this will work and to ensure that ecological values are maintained will be part of a detailed design phase. In terms of the wetland loss that is likely to occur, even considering the amended design that Mr. Rayner has described, it is probably still likely that we will need to modify some of the current wetland extent around the existing pond. However, as my evidence has stated, I believe that this wetland habitat has formed naturally since the existing pond was constructed about roughly 10 years ago. It is also my opinion that Raupō and Carrick's sedgelands are easily able to be recreated. They will pretty much recolonize any permanently wet or damp habitats pretty quickly following, once disturbance has ceased. Therefore, although I agree that ideally it would be good to not remove the existing Raupō, I do not feel concerned that we will not be able to reinstate any extent that is lost. One of the other key issues that was raised by Mr. Hamill was about buffer widths. Again, I agree with Mr. Hamill that ideally a minimum buffer width of 10 metres would be desirable for any riparian buffer margins. However, a lot of the buffer widths, I believe, will be 10 metres or greater on at least one side of the stream. Where's the pointer?
Those ones move the slide.
Yeah.
That's a point.
Okay. So, for example, these areas on this side, the areas on this side of the stream, these areas around this part of the stream reach, and pretty much all of the northern stream reach. It's my understanding that all of those will either meet or exceed the 10 metre minimum buffer width that is desirable. The narrower sections will be along these areas close to the southern development platform. Again, ideally it would be good to have them wider, but I believe that having a narrow buffer width in those locations, as long as it is well designed and well planted and well maintained, will still confer some ecological benefit to the stream channel and will be better than what is currently present at this point in time. Most of the rest of my rebuttal evidence is discussion on the literature and options for different buffer widths. So I won't go into this in detail unless anyone wants me to. So I'm happy to take any questions.
Thank you very much. Councillor Daniel?
Yeah, thank you. Could you maybe with the laser pointer,
Mhm.
point out for each of the stream sections and arms and of that,
Yeah,
which bits are low, medium or high ecological value
okay.
and why, and where you disagree with regional council on that matter and why?
Sure. So this, you can't see the stream on this part of the figure. However, this reach from the boundary right up to, actually, you've got another, hang on, I'll just find a better, okay, so this shows roughly where the stream is. So, so all this section is what I have called the northern stream reach in my evidence and in my report. And there's also a bit of stream in this section. So there's a culvert in this area under the access track. There's also a section of stream in here just before you get to the ponded area that I also consider to be part of the northern reach. So all of that bit is of moderate to high ecological value. I take Mr. Hamill's point that if you are using an EIANZ assessment, the presence of long finial in that reach would elevate the ecological values to high, and I accept his correction on this point. This bit here, so that the pond, the current pond is roughly, you can see here there's a tree, that's a willow, and that's basically the southern extent of the current pond. This pond is extremely shallow, well it was on my site visit, and that has high levels of sediment and there's not any tall riparian cover. So this pond is highly likely to become very warm, and have poor water quality parameters, which long finial aren't really that keen on. Therefore, I think, although our closest record for long finial was in this section just past the culvert, I think it's unlikely that they would use that pond or any of the southern reaches on a regular basis. So there, on that basis, all of these reaches, the southern main reach, which comes out here, comes out here, the southern tributary and the southwestern tributary. Southern tributary is southern mainstream is definitely moderate ecological value. Again, as highlighted by Mr. Hamill, this section up here from basically Mr. Rayner's magenta point up to here is not particularly modified and still has some good in-stream cover. However, the section through here has been heavily modified, channelized, and in-stream cover from my period margins has been removed. So it's definitely of moderate value. Further, if we were to undertake further investigation on the values of that stream, like if you did a fish survey, it's plausible that it might have higher in-stream values than I have reported, but the values I've given it are based on the information I have to date. These two small streams down here are, I don't believe, would be of any greater than moderate ecological value.
Thank you. And why did you disagree with the regional council? Just the long finial issue for the.
Yeah, from memory, Mr. Hamill had suggested that the southern main tributary should be elevated to high ecological value because I think he felt that long finial could potentially utilise this reach based on the habitats in this easternmost portion. But I'll leave that to Mr. Hamill to elaborate on in his evidence.
Thank you.
Councillor Granger.
You said that you agree that ideally 10 metres on each side of the stream channel is the appropriate buffer width. But on that northern reach, on the maps we've got, that strip is only 10 metres wide in total. So it's basically 5 on each side, isn't it?
No, so this northern stream reach, I've done a few just horizontal width measurements on online mapping software available. the maximum, so going up to the top of the bank, which is where I believe the developable area will stop. That ranges between about 8 and 15 along all of this section. Most of it is 10 metres or greater. The only area that is less than 10 metres is in this part of the stream near the existing culvert.
Can you change it back to the?
Yes, so
structure plan?
that's based on my mapping of what's existing and why I understand the buffer zone to be on the.
If I could perhaps clarify,
Yep.
Mr. Chairman, because the stream doesn't run centrally on that buffer shown on the structure plan, it effectively runs on the boundary of the site, the stream. So it's off to the side. It's
Oh, I
not
see.
central through there.
Right. Thank you.
And yes, the original lands, the original master plan appears as though it's very narrow. But again, as far as I understand it, that master plan was indicative only, not intended to be an absolute extent of developable area.
Just one question, if I may. You've distinguished between a brief for a structure plan, which is what you've done, and a brief for a consent. Can you imagine that any proposals as part of a consent application or conditions thereto would require more land than is proposed? Or do you believe that whatever may be required can be carried out and consented within the land set aside?
I'm not quite sure that I understand your question.
Well, okay, you've distinguished between your ecological work for a structure plan, which is what you've done. You've pointed out that you have not done all the work that you would envisage may be necessary for a resource consent application. So my question is, can you imagine anything arising out of that resource application process which would require more land than has been set aside for those purposes?
Okay, so you mean more land in terms of the buffer zones and potential future wetland habitat and those kind of aspects. I think that Mr. Rayner has already demonstrated that there is a lot of scope for amending the stormwater design so that it will be more suitable for achieving good ecological outcomes. And I think that the pond areas and locations shown are of sufficient size to be able to realise a no net loss of the wetland habitat, which has been raised by Regional Council. I don't think that any additional land is necessary to achieve the aims of good ecological enhancement.
That's what I was asking for. Thank you. You've answered my question.
Ms. Price, did you wish to ask? No. Okay. Thank you, Ms. Wilcox. That's great. Thank you. Ms. Barry Pacino, do you wish to proceed further or do you want to call a lunch break now?
It would be my suggestion that's probably a good time to break.
Yep. Okay, that's very convenient for us. So thank you. We'll take about half an hour and be right back.
So my next witness is Tapuna Springs Director Annalise Michael, who's speaking on behalf of the landowner.
Thank you. So as Kate said, my name is Annalise Michelle. I'm the CEO of the Supermac Group, of which Tapuna Springs Estate is part of. I'm also a director of Tapuna Springs Estate. Tapuna Springs Estate was my father's company, and as you're aware, he died on the 21st of July last year in an accident at Tapuna Quarry Park where he was volunteering. I wish to defer to our experts in response to the opposing submitters. As you're all aware, this has been a very long process for us to get to today with significant investment on our behalf, both in the past and the forward investment that we are looking to do in the future. The commercial development that was envisioned 17 years ago is significantly different to the one before you today. We've had many challenges over the years, especially with the acquisition of land under the Public Works Act for roading and the Tapuna Community Hall. This has significantly reduced the accessibility and overall connectivity of our site, as well as significantly diminishing the commercially zoned land available for us. There was an agreement of like for like and the equivalent of lost land being rezoned to commercial, which has never happened, hence the private plan change becoming necessary. The Tapuna Community Hall would not be located in the Tapuna village without the support of my father, who facilitated this to the detriment of his own land and development. Not only did he make the land available, his businesses supported the build and provided a site office, water and power to the site for construction. The Hall Committee at that time were unequivocally supportive of our commercial development around them, to which they wrote the letter of support which you have before you. We are still supporting the Hall with their stormwater attenuation. We are currently at the mercy of the stormwater discharge from multiple other sites without any easements or any current resource consents in place. This plan change and subsequent stormwater discharge resource consent would look to address this formally in a managed way and ensure adequate management for the site. The requirements for this mitigation have had a significant detrimental impact on the developable land, as illustrated in the revised map that you saw from Neil today. This current plan change has been actively developed since 2018. If this plan change is approved, we've got connections now available to the Mokoroa wastewater pipeline for our entire site, which has alleviated concerns that was previously raised by council. As you're aware, we're currently using the site as storage for our other entities. With my father's death, community growth and changes in our business model, our priorities and needs have changed. That's reflected in the updated structure plan before you. Our intention is to move completely off-site and the land be developed for commercial usage as part of the wider Tapuna village. This is not a rush plan change, but something that has been very well thought out and rather ensures that the development on the site can occur in a planned and cohesive way. Part of our land is already zoned commercial and we've gained resource consent to build. We had gained resource consent to build over the natural spring and southeastern tributary. Our updated structure plan enables preservation enhancement of this string instead, while extending the commercial zone over our entire property, including our previous property, which is where the Tapuna Hall is, which is already zoned commercial, but it's that little wee bit. We're satisfied that our extensive consultation with the community over this plan change has been transparent and comprehensive. There's been very little opposition from the community about our proposal and even less opposition regarding the rezoning of the land. In discussions within the community that I have personally had, people are excited to see further development, and indeed I'm fielding multiple queries a week, people wanting commercial space. It is our intention to direct the development of Tapuna Springs Estate ourselves, and as such, we will retain control of the development and can ensure that it is cohesive, of a high quality, fit for purpose, sustainable and environmentally conscious. I acknowledge my father's land modifications over the years. That being said, I'm not Rex, I'm not my father. I can't change the past, but I feel that we all really need to move forward and look to the future of Tapuna. We've listened to our community and responded to give them what they want, us off our own property, high quality, sustainable, cohesive commercial development, spring and waterway restoration. The rezoning of the balance of our land into commercial is critical for the future growth and development of Tapuna. This is a growing community that has significant needs that they want met locally. Without rezoning of this land, this cannot occur. Thank you.
Do you want to go? Yes. Thank you. Ms. Michelle, can you give us a date when the current pond and Raupo areas were established?
Aaron probably can be more specific on that.
Yes, Councillor. Around about post 1997, which I think was when the original work was done. So in the sort of mid to late 90s.
Councillor Daniel. Commissioner Withy. Okay, done. Thank you very much. Oh, sorry, Ms. Price, did you have anything you wish to clarify? No, sorry. Yeah, we're done. Thank you. Okay. So Ms. Barry Pacino, that's the conclusion of your, well, you've still got Mr. Collier, sorry. Star, yeah. I shouldn't be depriving you, should I? Okay.
If I could now introduce you to Mr. Collier, and he has prepared a original brief of evidence and then a subsequent rebuttal brief, which was sent through yesterday. So hopefully both of those copies are in front of you. Mr. Collier, I understand that you're familiar with the members of the committee, but if you could go through, introduce yourself quickly, go through those key aspects in your evidence and perhaps the rebuttal evidence in greater detail, given that those are where the remaining areas of disagreement appear to lie. Thank you.
Yeah, so thank you and good afternoon. I've been involved with the plan change for approximately the last 5 years. The plan change started very much as a collaborative approach with the council staff, where we were looking at the needs for Te Puna and Rex McIntyre's vision for the site at the time, which was effectively to tidy up the site and provide for some further commercial development in the area. The commercial development that had occurred in more recent years on the southern side of the state highway had largely occurred out of zone. And I've said in my evidence approximately 50% of that land on the southern side has occurred either through land use consents or it's just naturally kind of happened. And so you have a proliferation of vehicle entrances over there, signage and all sorts of things that have unfortunately occurred. So we decided very early on in the process to develop a structure plan approach. We engaged Mr. Hugo to assist with that. And we had a number of workshop meetings, and it's what I call true structure planning. So we actually sat down with council staff and with others, including Pere Darkel and some of the other developers and landowners, and worked up what we felt was a really good layout and structure plan for the site. So very little of that was done in isolation. It was done collaboratively using a team of people, and including some senior people within the council, such as Mr. Martelli and Mr. Ellis. The process at that stage actually became the catalyst for resolving one of the big environmental concerns for that area, which was groundwater contamination from wastewater. And so as part of that discussion and process, we suggested the council went away and looked at an ultimate solution for Te Puna, which Mr. Ellis did, and that came back as effectively the Amakara pipeline as being a connection for the existing commercial areas. So we waited until that had occurred before the plan change was ultimately submitted to the council. Perhaps if I can just start, and that's kind of some background for you, because I think that's really important about how we got to the point that we got to. In terms of the Section 42A report, I think it's fair to say that Ms. Price and I are not too far away in terms of our thinking around the plan change, and it is kind of refreshing to see such a concise and well-written Section 42A report. Many of them that I see are many hundreds of pages long, and I think it's very concise and well drafted. The commercial zone, in my view, is the most appropriate outcome for the site, which addresses the purpose of the Act in terms of Section 5. And so as part of the Section 32 analysis, I think the committee needs to be aware of the options, which are the commercial zone or retention of the rural zone. In my view, the retention of that rural zone does not give effect to Section 5 in terms of providing for the needs of the community, social, economic and cultural wellbeing considerations being the paramount matters under Section 5, nor does it result in any positive outcomes under Section 6 and 7 and to some degree Section 8 matters of the RMA. There's been a lot of criticism from the Regional Council about what the applicant hasn't done, but I think it's important to focus on what the applicant has done. And so there are no district or regional plans that will actively require and promote the ecological outcomes, for example, that this plan change proposes, the stream enhancement that would occur as a result of this plan change. The alternative zoning in terms of the Section 32 analysis means that the land would effectively stay as it is. And I would encourage you to go and have a look at the site. You'll get a good feeling for the condition of the land, what's occurred in the past, the nature of the streams and the existing environment that's on the site. I have addressed in the plan change document I suppose the assessment around how the plan change best fits with the existing district plans objectives, which is really one of the key considerations that the committee will need to take into account. And these relate mainly to the commercial zone and include some of the key objectives in relation to scale and whether the scale of the development is appropriate. The other core objectives in the plan relate to matters such as whether the plan change can operate without causing considerable constraints on surrounding activities, and also a key objective, and it's 19.2.2.3, is limiting the establishment of commercial activities in non-commercial zones. And as I say, there hasn't been any land rezoned in Te Puna since the early 1990s, and a history of ad hoc development occurring out of zones. So I believe the plan change is very consistent with those key objectives in the commercial chapter of your existing district plan. One of the key matters associated with the preparation of the plan change is of course the structure plan. And the RPS provides some guidance around the preparation of structure plans. And typically they're only required to be provided on the basis of what the RPS refers to as large-scale land use change. I don't believe this is large-scale land use change at all, but what I do believe in is that a structure plan is the best and most appropriate way to deliver a positive and beneficial outcome for the zoning. And so that is the reason why I adopted that mechanism. One matter which is of relevance is in terms of the district plan's definition of a structure plan. And what the district plan definition says is it requires applicants to show proposals for infrastructure. Not detailed design or specific design or anything like that, but generally proposals for infrastructure. And so my view is that the applicant has met that test under the definition in the district plan of what is required to be addressed as part of a structure plan. You've heard quite a lot of discussion around the matters of stormwater, and there's extensive evidence on that. And I believe that the level of detail provided is sufficient to enable you to grant or approve this plan change. In my evidence, I have prepared some amendments to the provisions that were proposed in the Section 42A report and also in the applicant's submission. So I assume you've read the submissions. The applicant put a submission in on their own plan change. The reason that that came about is that the discussions were occurring between the council and Oricon at the time, and unfortunately I wasn't involved in those, so I didn't manage to make any amendments to the plan change before it was notified. So we had to effect that through a submission process, which we did. The amended provisions, which I've proposed in my evidence and through the submission, are all permitted activity provisions. In other words, they sit effectively in the structure plan chapter in the main, and they are provisions that are required to be met by permitted development. Now, in the instance where one or more of those provisions are not met, then under the existing district plan framework, any activity becomes a discretionary activity. And I've purposely done that because I didn't want to start to play around with the overall structure of the district plan. And I think the same approach applies to this particular site as would any other kind of commercial area in your district. So those amended provisions are the removal of the industrial type activities. So when Mr. McIntyre passed away, there was a decision made that Supermac and Modcom would leave the site. And so those provisions which had provided for things like rural contractors depots and the sorts of activities that Supermac were engaged in at the time, they were removed or sought to be removed through a submission from the applicant themselves. I also made a submission to strengthen the reverse sensitivity definition that was in the plan, and I've dealt with that in 3.2 of my evidence. I've also in my evidence included the new provisions that Ms. Fosbury touched upon, which are effectively prerequisites for development of that part of the site that fronts onto the state highway, and that cannot occur until the TNL is effectively in place and those traffic flows change from what is currently occurring. I have, in response to mainly to the submission from the Regional Council, included a further rule in relation to the riparian margins, and that's covered in 5.12 of my evidence. That includes the introduction of provisions relating to the buffer planting, fish passage, and the requirement for a stream enhancement plan. Now, we will be doing all of those things as part of the regional consent process, but I have incorporated those into your district plan provisions also. I've also detailed in paragraph 6 of my evidence, because I thought it was important for you to understand your existing stormwater provisions. I've effectively teased all of those out of the district plan and provided those to you, and they include both general stormwater provisions and your more specific structure plan stormwater provisions. So there's some criticism from the Regional Council that your district plan is in some way deficient. My view is that your district plan is not deficient. Your district plan extensively deals with stormwater matters, and it even goes to the extent of referring, for example, to low impact design measures being incorporated, and that would allow the use of things like rain gardens and stormwater tanks up on other parts of the site. In terms of the provisions of relating to wastewater, we have also written I've also written a rule that I'd suggested that be incorporated. That was in response to the District Health Board and to some degree also the Regional Council. I feel that nobody is ever likely to use an on-site effluent system on that site because they would not get a regional consent for it. The Regional Council have made their position very clear. They put a lot of pressure on this council to sort out the wastewater problem. So I have included that as a provision. Again, if that isn't met and someone comes in with a wastewater solution for a particular part of the site, if they require some kind of on-site system, that would also trigger a discretionary consent under your district plan. I don't know why anybody would do that. Now, there's some suggestion from the DHB, because I corresponded with them, that they wanted a non-compliant activity status applied to the use of on-site wastewater systems. I think the issue is a red herring, and I would resist a non-compliant activity status, particularly when the regional plan already provides for some permitted activity wastewater systems on commercial zones. I just don't think it's a good fit to go from permitted to non-compliant in terms of a planning response. I've also included in paragraph 5.1 of my evidence some further stormwater management provisions which allow for the use of some on-site measures. As you've heard from Mr. Rayner, at this stage we haven't had to rely on that. We can make it work without that, but I have included those provisions. In terms of my rebuttal evidence relates mainly to responding to the Regional Council matters, and that's just in terms of stormwater. Mr. Tipari's evidence in particular, I've provided quite a few comments around that. Mr. Tapari describes the site as both small and marginal, but I think the response from the regional council has been far from treating the site as if it's one that's small and marginal. And the evidence of Ms. Gravitt and Ms. Bowden is responded to in my rebuttal. I have met with Ms. Gravitt in relation to the hall's concerns, and I have agreed with Ms. Gravitt that we would look at removing the road that previously ran from outside the hall site to the northern boundary. That road doesn't really, in my view, serve any purpose. And in fact, the internal road may end up moving, and it may be that it's incorporated as part of car parking areas, etc. If you have a look at the development and the nature of the commercial development across the road, for example, there is an entrance, but then once you get into the site, there are various laneways and car parks and buildings and things. And that's how I logically see the site developing in the future. So finally, probably the only other comment that I've got to make is I would encourage you to do a site visit, because I think a site visit is important for you to really understand the context of all of this so that you can understand the site, the streams, and the nature of the existing environment. I have agreed with Ms. Price to assist you to provide you with a full track change version of the provisions. And I would be working on those based on what I hear today with a view to providing those to Ms. Price and Ms. Pacino and yourselves tomorrow. But they will be effectively a final suite of provisions, and they will be effectively a copy of the relevant chapters of the district plan with those provisions added. So thank you. I'd be happy to answer any questions.
Thank you very much, Mr. Collier. Councillor Granger. Councillor Denia.
Perhaps you could just clarify why you think the 12-metre height limit is appropriate when that's not the case for most of the rest of the district in terms of the commercial zone. I understand the town centres have a higher one, but the most of the rest don't.
You've got a guiding policy around that, which I've mentioned in my evidence, and it talks about some of your smaller settlements like Makatu, Paingaroa, etc. And to me, it's about proximity of some of those taller buildings to immediate housing. That's quite clear in the plan objective, and there's a supporting policy which deals with that as well. Your plan doesn't deal very well with commercial activities outside of the main street kind of commercial environment, which is typically Te Puke, Katikati, Waihi Beach and the like. So what I have heard based on the evidence from Mr. Hugo, and I agree with that because I've been out and had a look at myself, is that the scale and height and mass of those buildings in terms of how they impact on the character is already quite pronounced. So the commercial buildings that are there are all on very elevated sites, sitting up quite high, quite dominant in the landscape. So it's my view that there is no reason why a 12-metre building height shouldn't apply, subject to appropriate setbacks and screen planting. I certainly don't think the site is a sensitive environment. It's not in close proximity to residential. There are no issues of dominance or shading. And quite frankly, if you look across the road at the DMS site, you'll see very large, very tall buildings.
Do you see any particular requirement, should we say, for 12 metres, as opposed to just giving you general flexibility? Is there a particular usage in mind that you has been discussed?
No, but it would provide for some taller buildings, for some 2-storey, potentially 3-storey buildings. I mean, there has been some discussion in the evidence, for example, from the Hall Committee around the need for residential, for example. I'm not saying that's an immediate use or one that the applicant might be looking at, but these zones are in place forever. And looking at it long term, perhaps in time there may be the requirement for that. But I at this stage, I can't see any reasons or any kind of logic to apply a 9-metre building height. I'm not aware of any other commercial zones that I've ever dealt with that have had a 9-metre building height.
Okay.
If I may add to that, to the Chairman. In terms of looking at the provisions, for example, in suburban residential zones within tier 1 councils, that's as a standard going to go up to 11.5 meters, I believe. So really the 9 meters is actually a very restrictive thing in this kind of key proximity, which is really usable for things like multi-level residential and so on. And again, with those setback rules and daylighting rules, there's enough protection and requirements for quality design and articulation of the structure to actually mean that you can do that, and it aligns better with where the national urban design policy is going.
Okay, thanks.
Okay, thank you for that.
Thank you.
Oh, no, sorry, keep forgetting. I'll learn. Thank you for that. Ms. Barry Pacino, you wish to summarise before we go to the submitters, or?
Oh, sir, I'd probably leave that to my right of reply after.
Yes, yes, if you're happy with that, we'd be very satisfied.
Yes. So thank you. That completes the evidence from all of the witnesses for the applicant.
Thank you.
Just tabling the document, sir.
So we're just tabling a document from Toiti Ora. Thank you. All right, so if we move to our submitters, first up we have the Regional Council and Sue Ira. Would you like to come forward, please? Oh, sorry.
Good afternoon, everyone.
Yes, so Ms. Ira, people have received your presentation and have read that. If you'd like to just speak to it now, please.
Yes, no problem. I will just share my screen if I may. I have a.
Sorry, sir. Can I just start by opening our case first, and then we'll jump into you? Is that okay?
No problem.
Sorry, apologies, commissioners, just taking my time getting up, but just a little bit of organising after hearing lots from our other side this morning, which has been really useful for us. So thank you. And just to say, we've received this letter from Taitoora just now, so that's good. Thank you. Good afternoon, commissioners, members of the council, those that have prepared the plan change on the applicant side, and also people that have responded to the plan change. My name is Nathan Tapoti. I'm a planner. I've worked for for Toi Moana, the Bay of Plenty Regional Council. Do I need to go through any of my previous experience, or are you happy just to take it as read in my statement?
Take that as read. Thank you.
Thank you. Yeah. I also trust that the commissioners received the communication yesterday that our principal stormwater engineer, Kathy Teladen, is got a respiratory infection, so she can not join us today, but she's happy to provide written responses to any of the questions that you have. And hopefully her original statement has set out clearly what her concerns were around offsite effects, et cetera, et cetera. So yeah, happy to respond to any questions to the applicant, or any questions that arrive from the applicant or through the panel. I just thought it'd be useful just framing at a summary level before Sue takes us through water quality, what our salient concerns are, or the essential concerns to the Regional Council. So our current position after seeing the plan change with the original version was that we hadn't seen that the applicant had demonstrated a feasible stormwater solution within the plan change area that wouldn't encroach on the extents of the commercial zone. So that was our primary concern, but also that the change would result in loss of stream extent which is contrary to the directions of a national policy statement for freshwater management. And also that the plan change would result in loss of values from things like post-development stormwater discharge off the commercial sites, which of course are located in close proximity to the receiving environment. And also, in the absence of a catchment-wide analysis, it's not possible to determine downstream risk or to understand the potential effects of volume increases or the requirements for the sizing of the final stormwater solution. However, yesterday in the afternoon, we received a revised scheme from the applicant, which we feel is progressed, but not answered all the questions for the Regional Council. And so each of the witnesses will address the matters in their respective areas this afternoon. But I would just like to add that without the benefit of technical assessment and the views of Kathy Telarden, who I rely on in reaching my conclusions, that we would prefer to reserve our final position if that's an option open to us. And I would just say that because if particularly identified in paragraphs, I think 45 to 49 of Kathy's evidence, she goes through quite a number of concerns around the feasibility and the extent to which that stormwater solution is appropriate, which I've already mentioned. And she concludes that it's highly unlikely that a solution can be accommodated within the area shown. So in reaching that conclusion, she's looked at what the original proposal was from the applicant, and then doing her own volume calculation, she's looked at an alternative. So it's just not a ski-whiff assessment. She's, given the applicant the benefit of the doubt and tried to understand, can we accommodate a solution? So the order of our speakers today will be Sue Iro, who will comment on water quality, and she's obviously on the live stream, then Keith Hamill on ecology, and finally, Mark Townsend, our engineering manager, is available here today to answer any general questions, if that's acceptable to the applicant side, although he won't be able to comment on any of the specific details relating to stormwater. So if that's useful for the parties to progress the issues, then we suggest Mark Townsend be made available to the proceedings. So if there are any questions on my evidence, I'd be happy to address them towards the end, or is there any other sort of opening reflections you'd like from the Regional Council before we go through the experts?
Yep, I think we're happy to proceed to the evidence. Thank you. Thank you. Yeah, yes, you'll come back. You'll come back at the end. Is that
I'll be the last. Yeah.
Yes.
Yep.
Okay, great. Thank you, Sue.
Thank you. Good afternoon, everyone. I did prepare a presentation, so I just wonder if that presentation, the PowerPoint presentation, could be put up on the screen for everyone to have a look at. And I might have to ask Mr. Tapiri to go through the slides for me, as I'm unable to share my screen due to the live recording.
Yes, just okay, one second. Oh, okay. Yes, so sure. Thank you indeed. Right. Thank you.
Are we okay to start? Sorry, I can't see the screen.
So just coming up with that now, Sue, won't be a moment.
Thank you.
Thank you.
No.
Oh, no, there is 193 here, Otherwise. That's it. Yes, thank you.
Fantastic. That looks more familiar than the other one. Thank you. Good afternoon, everyone, and thank you for having me here today. I do apologize that I can't be with you in person. I will take my evidence as read, but just to let you know a bit about my background, I'm an environmental scientist with over 20 years experience. The main areas of expertise that I hold is that of resource consent processing for stormwater and water quality discharges, catchment management planning, water sensitive design, green infrastructure, and I also do stormwater training in water sensitive design and advanced stormwater management nationally across New Zealand. What I thought I would like to do, and everything I'm telling you now is in my evidence, but I really wanted to start off with a common understanding of stormwater management and why it's important that we manage stormwater effects from urban areas so that we can make sure that we direct the most appropriate management actions towards those effects. If I could have the next slide, please. In terms of understanding stormwater effects, the most important thing we can do is think about probably back to our high school geography lessons where we had to learn something called the water cycle. And the water cycle is there, and it tells us that when it rains, we get a lot of infiltration. You can see there on the natural water cycle on the left, a lot of infiltration going into the ground. We get a lot of evapotranspiration going back into the atmosphere, and we get some portion of that water cycle coming off the land as runoff. When we have urbanization, these impervious surfaces, and these surfaces actually reduce that infiltration component quite significantly. So if we have a look at the urban water cycle on the right-hand side, you'll be able to see that there's much less infiltration. We don't have as much vegetation within our urban areas, so we have less evapotranspiration. And what that means is because the volume of water within the water cycle is always the same, it doesn't change. It's just the form that that water changes, the form that the water is in changes. So we have more runoff coming off our land. And it's that increase in runoff which increases flooding and peak flows, which causes the effects of stormwater discharges. And we also know that the impervious surfaces are dirty. So whenever it rains, we get contaminants that are entrained in that stormwater, and they are discharged to our receiving systems. Next slide, please. So because of this change in the water cycle and the construction of these impervious surfaces, we get three key effects from stormwater discharges that we need to manage. The first effect is water quantity effects, and these you'll all be very familiar with. The effects of flooding, increased flow rates, that causes erosion risks both to ourselves and our property, as well as to others. And that photo at the top was taken in 2004 for the large floods that occurred in Whakatane. You might remember those floods. The second effect that we have is that of water quality, and these are threats to our health as well as to the health of our aquatic ecosystems. And in this case, for this plan change area, we're looking at and trying to understand the effects that would occur on those freshwater ecosystems. The third and final effect that we get from this construction of the impervious surfaces and that urban water cycle is around the loss of our freshwater resources. And this is both due to the increased volume of water that we get off the land, as well as the deterioration in the water quality. Next. So in terms of these effects, my evidence deals with the water quality effects, but I also deal with the integration of these three key effects as we go through and have a look at the proposed structure plan approach for stormwater management. Ms. Thiel-Larden's evidence has addressed water quantity effects and has raised concerns around the feasibility of the proposal to manage peak flows, as well as the increase in volume of water and the duration of flooding that could occur from the development area. And Mr. Hamill's evidence will deal with potential loss of freshwater aquatic resources due to the proposed stormwater management approach. Next slide, please. So in terms of water quality, which is what I'm focusing on, it's really important that we understand the key contaminants of concern from an urban environment, because it's only once we know what those contaminants are that we can then start to direct our management approach at them. So in the urban environment, if we think of large-scale commercial impervious surfaces, the contaminants that we're concerned about are sediments, but also metals. So metals such as zinc, copper, and lead. We're concerned about hydrocarbons, which are oils, and also temperature effects from the impervious areas. And Ms. Wilcox addressed some of the temperature effects in her evidence earlier. In terms of urban areas, you can see some of the red circled areas on the plan, on the photo there. So in terms of zinc, one of the key sources of zinc in urban areas are roofs, especially ungalvanized roofs or zinc aluminum roofs. And the reason for this is that every time it rains, zinc will leach from those roofing materials and get discharged into the receiving system. Just to give you an example, as I gave in my evidence, the unpainted galvanized roofs link total zinc or create total zinc loads of about 2.24 grams per meter squared per year. If we used a different type of building material, an inert building material, such as a color steel roof or a clay tile roof, then that zinc load decreases to something like 0.02 grams per meter squared per year. So that's a significant difference just by changing our approach and thinking about the materials that we use in a particular development to avoid the discharge of certain contaminants. Copper is also widely used in the manufacture of alloys of zinc, so thinking about copper is important as well. In terms of roads and cars, roads, trafficked areas, zinc comes from tire wear and copper drops off brake pads. So every time you get in cars that are stopping and starting, accelerating, turning, those highly trafficked areas generate quite significant volumes of zinc and copper, which then can get discharged to the receiving systems if those areas are untreated. Next slide, please. In terms of the effects on streams, we do have those water quality effects on streams that I mentioned, but also we need to keep in our mind that temperature is actually a contaminant, and that some of the streams within the area are susceptible to temperature changes. And I have addressed that point in my evidence for you. But something that's also worth understanding is that because the volume of water within the water cycle never changes, if we're having more runoff, that runoff is occurring at a faster rate and it's occurring for a longer duration. And so that increased duration and flow rate causes accelerated stream channel erosion within our aquatic resources, and then subsequent downstream sedimentation, potentially of some of the estuarine areas, which can be of concern. Next slide, please. So an approach which I have spoken about in my evidence, which does offer a way of managing these effects by both avoiding some of the effects we've spoken about as well as mitigating them, is an approach called water-sensitive design. Now, water-sensitive design is not new. It's been around for a long time. In the USA, it's called low-impact design. In Australia, it's called water-sensitive design, and in the UK, it's called sustainable urban drainage systems. So the philosophy of low-impact design is quite clear. It's a design approach to site development that protects and incorporates natural site features, and it incorporates those into the stormwater management plan. So it's not pro or anti-development in any way. It's all about how you actually develop your site. And the reason for this is because decisions on land use have direct effects on the amount of impervious area that you're going to have, and that location and configuration of impervious area, because we know it affects the water cycle so critically, has a direct effect and linkage to those stormwater discharges. So water-sensitive design promotes this interdisciplinary approach to planning and design. It's about protecting and enhancing the values and the functions of natural ecosystems. It's about addressing stormwater effects as close to the source that those effects occur as possible. So for example, for zinc, we would look at making sure that we don't have materials that leach zinc or leach copper. But importantly, it's also about using natural systems that mimic that natural water cycle. And this is often known as systems called green infrastructure approaches, such as wetlands or rain gardens. The Bay of Plenty Regional Council's stormwater design guideline does reference water-sensitive design. It calls it low-impact design, which we know is the same thing. And it requests that that low-impact design should be incorporated into all developments to reduce the potential impacts of those developments on the receiving systems. Next slide, please. A key aspect of water sensitive design is using an approach known as a treatment train approach, where we use several types of stormwater management practices together in an integrated way to provide for a comprehensive stormwater management system. What's important is that each part of that treatment train has a different focus. So you would use source control for your contaminants like zinc, your roofing materials. You might use rain tanks to capture roof water for reuse. So then you're getting some sustainability of supply and using stormwater as a resource. And you would look at source treatment like swales or rain gardens, and then a final polishing of that stormwater or providing attenuation through larger scale wetland and systems. So as we start to develop land, which is a little bit more difficult to develop than previously, so that treatment train approach becomes really more important. And it also allows us to give effect to some of the policies that we see within the MPSFM and the RMA. Next slide, please. So in terms of the applicant's proposed approach to avoid, remedy or mitigate water quality on the stream, it has changed, as you're all aware, and we heard this morning from Mr. Rayner, it has changed since this plan that has been put up here. And there is certainly a far more water sensitive approach that is being taken by the applicant by trying to minimize the works that would need to occur to the base of that stream by keeping the attenuation to the side of the stream. But just to be aware that on each side of the main attenuation pond, we have these two water quality wetlands. Unfortunately, you can't see me pointing, but if you would have a look at the slide on the right-hand side, thank you, yes, we can see the two ponds there. So those were originally proposed to be stormwater ponds, and they are now proposed by the applicant to be constructed stormwater treatment wetlands. So these are not wetlands to offset any loss of other wetlands. They're wetlands purely for the purposes of providing for stormwater treatment and extended detention. So I'm supportive of the use of those wetlands over ponds. And I'm supportive of the fact that the applicant has said that they are not precluding the use of on-site devices such as rain gardens or rain tanks within the commercially zoned areas. What I'm concerned about is that their approach hasn't integrated the use of those devices into the overall framework for managing stormwater. Next slide, please. I think it is important to understand why I made comments in my evidence around stormwater ponds and why we opposed the use of ponds themselves. First of all, ponds are not cost-efficient devices for removing urban contaminants such as metals. Ponds only remove about 30 to 40% of zinc from impervious surfaces, whereas a device like a wetland would remove about 70% of zinc from those impervious surfaces. So if you're trying to think about getting value for your money in terms of the stormwater infrastructure that you're building, a wetland is far more cost-efficient practice than what a pond would be if your objective is contaminant removal of metals. Stormwater ponds also cause effects. So because they are large open water ponds, we heard from Ms. Wilcox in her evidence that the current pond that is there now heats up and is not a good ecosystem for the animals to live in. So that heating up of that water can cause thermal shock and effects downstream if we have stormwater ponds as our key mitigation measures. So as I said, I'm supportive of the wetlands. They're better at contaminant removal. They're much safer stormwater quality systems because they are shallower, so you don't have as much risk of drowning as in ponds. Previously, the ponds were proposed to be quite deep. And also the dense vegetation surrounding the wetlands and within the wetlands is a bit of people won't want to swim in it like they might want to swim in an open water pond. And as I said, that they're more cost efficient. So it is really good that we're moving towards understanding why wetlands are better and why we need on-site management to actually provide for better water quality outcomes. And this is because it's the vegetation within those practices of wetlands and rain gardens that help to mimic the natural water cycle. What's important though, and what has been missing previously within this application, is understanding the connectedness, the interconnectedness between the water quality systems, the need for attenuation on the site, and how that affects the aquatic freshwater systems. I did mention in my evidence, and Mr. Rayner mentioned this morning as well, that online ponds are not a preferred approach for management. You should not be using the receiving environment that you're trying to protect for your stormwater management approaches, if at all possible. Next slide, please. So really what we're seeking here is the integration of the stormwater management solution within a land use planning framework that achieves a holistic management of effects. Really, the place for the vision and the framework for the stormwater management approach should be set at the structure plan phase. Those objectives for management should be set at the structure plan phase, and then the feasibility in terms of whether or not those solutions to meet your objectives are feasible needs to be understood at the structure plan stage. That is really what we're lacking here at the moment, and Ms. Thiel-Larden's evidence will address that in terms of the feasibility of those water quantity solutions across the site. In terms of the water quality solutions, you'll see there that little treatment train diagram I've put in there again. We are certainly moving in the right direction now that the applicant is suggesting the use of on-site stormwater management measures as well as wetlands. I would like to see them go further in terms of managing building materials as well, so that we can avoid having to treat so much of the zinc that would be coming off the site from those roofing areas. The expectations in terms of stormwater management are set at the land use stage and the land use decision stage. And that is because stormwater management is so closely linked to the level of imperviousness on a site. And that is why we have requested information from the applicant around the feasibility of their approach. Next slide, please. The other key reason why we need to understand the stormwater management approach at the structure plan stage is to deal with the issue of cumulative effects. We've heard from the applicant this morning that this is a small scale plan change, that less than 1% or around about 1% of the catchment, it takes up 1% of the catchment and the peak flows. At the same time, we've also heard that this could be a catalyst for further development in the area. At some stage, we need to manage stormwater discharge effects from these business areas in a holistic way. We cannot keep having ad hoc development, which then leads on to effects on the receiving system. And unfortunately, when we're looking at stormwater discharges, effects from stormwater discharges are often only assessed as significant when they're considered cumulatively. Small contributions of contaminants or gradual increases in flow through development are often not noticeable on a day-to-day basis. But as you can see from the diagram on the right-hand side, as you develop more land and over time, so with catchment increases, these small increases in flow or in contaminants collectively combine to lead to noticeable and significant effects. And this is why we need to deal with those cumulative effects at the structure planning stage. Section 3.5.1 acknowledges this in the MPSFM, and it does direct local authorities to adopt an integrated approach as required by Te Mana o Te Wai to manage the effects of land use on the receiving environment. My experience as a resource consenting officer and then as the manager for the former Auckland Regional Council Stormwater Consenting and Compliance team has taught me that the resource consent process is prescriptively narrow. And trying to consider these cumulative catchment-wide stormwater effects through the consent process is really very challenging at best. And you also have no ability through the consent process to revisit issues of zoning or locations of zoning, which have direct linkages to those impervious surfaces. So there's very limited ability through a resource consent to deal with the matters of feasibility in terms of a good stormwater management approach to address cumulative effects. Next slide, please. So that links really onto the work that Ms. Seal Larden has done, and unfortunately she won't be with us today to be able to discuss her evidence, but she has done a fair amount of work to try and understand the feasibility of the proposed solution, and that can be seen in her evidence. Next slide, please. So in terms of the recommendations and outcomes which I have sought through my evidence, I do believe that an integrated approach which manages cumulative effects at the district plan level is needed. And that integrated approach needs to be based on best available information. We've had a few questions this morning around whether or not there are historic flood records for the catchment. And whilst there aren't these records, I do note that the Western Bay of Plenty District Council does have a catchment-wide hydrological model which could be used and which should be used to assess the effects of the structure plan change area on the wider catchment. So that information is there and it is available for the applicant to have used. It's only once we have this understanding of what that potential effect in terms of water quantity would be through a catchment model that we can then start to understand what options we have available to us to avoid, remedy or mitigate effects. And then we can start doing that assessment of feasible alternatives. And these alternatives, when we're talking about stormwater management, are both structural as well as non-structural. So structural in terms of stormwater devices like rain gardens and wetlands, but non-structural as well, thinking about impervious surface limits, zoning provisions. It's really important to realize with stormwater management, there is no one silver bullet answer. No one solution is going to be able to address all three of those key effects that I mentioned at the start of my evidence. And so this process, the structure planning process, this feasibility of understanding what you can do on the site from a stormwater management perspective, it's all about finding the optimal combination of structural and non-structural approaches which manage stormwater effects in a cost-efficient way. You cannot go into this process with a predetermined idea or outcome in your mind of what the stormwater management approach might look like. And finally, I seek that the outcome is that the integrated stormwater management approach through the structure plan has clear planning provisions set at the structure plan, the district plan level, so that we don't slowly start to erode outcomes as we go down through the consenting process. By setting it at the district plan level, it provides a degree of certainty for the community, for the local council, for iwi, that the outcomes set through the district plan, through the structure plan change can be met, especially since many of the community won't necessarily have the opportunity to submit on future resource consent processes, depending on how those pan out. So that was really everything that I wanted to cover, and I'm most happy to answer any questions that you may have. Thank you.
Thank you for that comprehensive presentation. Questions? I'll start this side this time. No? Yeah. Okay. So, sorry, we do have one.
Sure. Yeah, I say, sorry, Ms. Era. I just want to probe that assertion you made that said that it was hard to discuss feasibility for stormwater treatments in resource consent processes. Could you explain how and why that is, please?
Yes, sure. Sorry. What I meant was more, not so much the feasibility, it's the feasibility of assessing cumulative effects through the resource consent process can be challenging. So often with the resource consent process, it's very much directed at looking at just effects from a particular site that you're consenting the stormwater diversion and discharge consent for. But because with the nature of stormwater, so the effects, we start to see them on a cumulative basis, it gets really hard to start looking at it through that wider lens at the resource consent process.
Thank you. Yes, we have another question now, Councillor Granger. Thank you. In paragraph 12, you say that traffic areas where vehicles are slowing down, turning, parking and speeding up represent high contaminant generating areas due to tyre, brake pad wear and tear. Now, my question is, given the fact that State Highway 2, the roundabout, the service station and all the activities that are currently there now receive no treatment whatsoever, are we going to get a net benefit by having the treatment that is proposed compared to what's there now?
I don't think so, no. And the reason I'm saying that is because the treatment is only being proposed for the new impervious areas that are there. The treatment is not being proposed to account for those existing impervious surfaces that are there within the state highway area and around the BP. So what we're trying to do, or what the applicant has done in terms of their treatment wetlands, is it's just looking at those new impervious surfaces and trying to mitigate what will come off those impervious surfaces. So those contaminants are not being generated at the moment within the proposed new zones because they're not urban. And so the water quality treatment devices, those two wetlands, are only there to treat new impervious area. They're not going to be offsetting or treating contaminants from the state highway or from the BP area. Does that make sense?
Well, where are you suggesting that runoff goes to now then? The current runoff?
The current runoff goes into the stream. And so what the applicant is going to do, though, is that they're not capturing that current runoff that goes into the stream and putting it through a treatment device. It's going to just keep going through the stream. So that situation is not going to change. But on their own site, they're now creating new impervious areas, which facilitates more traffic. It facilitates more buildings. It facilitates more commercial areas. And so they're providing treatment for that additional impervious area that this plan change would facilitate.
Thank you. Yes, Ms. Price.
Thank you, Mr. Chairman. I just have one point of clarification, please. Ms. Ira refers to the cumulative effects, and is that for regional council consenting processes for discharge consents? If she can clarify, please.
Sorry, could you ask your question again? I couldn't quite hear.
You were referring to cumulative effects. Is that for discharge consents for regional council consents only?
In terms of the ease with which you can consider cumulative effects?
You were mentioning that the cumulative effects need to be taken into account. Is that for discharge consents for the regional council?
No, that's in this plan change, cumulative effects need to be taken into account as part of the plan change. It's at the plan change stage that you have the ability to decide on potential zoning for areas and impervious surfaces. And it's at that time that you need to be able to consider the cumulative effects of those increases in impervious surfaces. Once you get to the resource consenting stage, those land use zones have already been set. You cannot change what's been zoned through a regional resource consent for a stormwater diversion and discharge consent. All you're doing is actually managing the effect of that impervious area that has already been agreed to through a district plan through particular mitigation devices. So the time to deal with cumulative effects is the time when you decide on how that land use will change and be used.
Thank you.
Thank you. All right, thank you for that.
Thank you.
Mr. Depari, did you wish to call you on next, Mr. Hamill?
Sure, Mr. Hamill.
So just if I might, just in terms of time management, I note that the Bay of Plenty Regional Council has 1 hour with several other submitters with tight timeframes, as well as the right of reply on the basis that plan change 94 is scheduled for tomorrow. So I am just mindful that we're 37 minutes into the Bay of Plenty Regional Council's timeframe of 1 hour. So I just would point that out in terms of management for them going forward in terms of time. Thank you.
Yes, I'm very mindful that we have a significant number of submitters to get through, and we do wish to get this concluded today and give you that opportunity for your right reply. So thank you for pointing that out.
Yeah, Mr. Teilhard's not giving evidence, so I think we've got enough time. Thank you.
Right.
Thank you. Is that me? Thank you. If we can have a slide up, please, of the site, the one that Nathan would have sent through. Got the map? I'll give this a map of the site that we used.
Can I change the same one that Sue?
No.
The one that Sue referred to. Sue's recent presentation, it should be slide
Cool.
15.
I'll carry on while you do that. I don't need it for a while. Okay. I just want to. My name is Keith Hamill. I'm a freshwater ecologist, water quality scientist. I've been working in this field for about 26 years. It's been kind of a privilege to be able to work through quite a few jobs from beginning to end, designation, occasionally plan changes through to the consent and implementation. And in my experience of this, if you allow me just a general statement, many projects start with really good intentions for streams and ecology, and too many fail to achieve these good ecological outcomes because of inadequate detail, inadequate consent conditions, and inadequate provisions. The applicant is asking you, so I'm hearing, to basically accept weak provisions and a very fluid footprint and trust in a future consent process to deal with these effects. But sometimes that trust in that future consent process is not perfect, and sometimes you don't actually get the good outcomes. From my experience with past structure plan changes, you can make provisions now to give confidence of achieving good ecological outcomes. So you can make changes now, and you don't have to just pass it all off and then trust that that's going to work. And from my experience, it doesn't always work. And I'm going to give you lots of examples of that. Okay, so changes have been made in the right direction with this in recent days. I'm really pleased about that. And I just wanted to probably just work through from paragraph 27 of my evidence. And I'll just work through that paragraph, which really is the core of my concerns and how those have been changed or modified in the light of recent evidence. But before I do that, I just want to make a typo correction. And thank you to Ms. Wilcock for pointing this out in page paragraph 16 of my evidence. I refer to in the first sentence the southern. I switch around the southernmost tributary, southwestern tributary, and the southern tributary. So in paragraph 16, where it says the southern tributary has a narrow riparian margin, that should be southwestern. And further down in the third sentence, it says the vegetation along the southwestern tributary, that should be southern tributary. So hopefully that avoids confusion. I'm sorry about that. Reference to the photographs are correct. Okay. I'll try and be concise. So paragraph 27, I'll just take all this as read and focus on the issues. Look, the site has really good ecological potential to enhance ecological values. It's pretty degraded at the moment, and it's become more so over the years, judging from aerials. But there's still a high risk that the net ecological enhancement may not actually occur. And I'll go into why that is. So my first point here, the ecological effects will likely be more than reflected in the application. The changes by Mr. Rayner with his alternative option largely address a lot of those concerns I had about stream loss. So by working with a detention basin approach rather than a detention pond and a deep detention pond, very happy with that. But if it's not followed up with strong provisions in the plan, which there are not at the moment, then I have no confidence that that will be addressed. So second point, I refer to potential loss of the Raupo wetland. Again, the alternative option put forward by Mr. Rayner gives a really good opportunity to now, even if it is lost, have areas where it can be recreated. This type of wetland can easily be recreated, as we've heard. But you need the right space. You just can't do it anywhere. You need a nice low spot. You need wetlands, need water. So previously with a deep pond, it was looking pretty marginal where there'd be sufficient space, but now I think there is. So that's a very good, nice little tick. However, just talking to Mr. Kirk during today, I was getting his understanding of how the site has changed over the years, and my understanding from him now is that that wetland appeared to be there well into the past. So originally I was looking at aerials and it was pretty hard to tell whether there was a wetland there or not. And so I was falling on the side that it probably was induced after that pond was created, so subject to the pond. But hearing anecdotal discussions with Mr. Kirk that it could well be have been there existing prior to any pond was being put there. And if that is the case, and I'm sure he'll talk to you, if that is the case, then it falls under a natural wetland under the NPS, National Policy Statement for Freshwater, and the National Environment Standards, and there'll be a requirement to avoid it. And so I'm sure that can be talked to. So that's different from what my original view, but it's sort of a, yep, you can talk to him, decide on how that fits. Okay, my third point I was making, I was concerned about the buffer widths. So I think Ms. Wilcock and I both agree 10 metre buffers or more are a good practice. I guess I'm particularly concerned in the, I can see this now, in the upper section of the southern reach. So if we look on that map, and I don't have a pointer, sorry, but maybe someone, oh, thank you, that one there, perfect, thanks. Yeah, the upper section of the southern reach, it's got nice, quite nice riparian habitat. It's quite functional, and currently that footprint, as it's placed, thank you, will be falling within about 5 meters of the stream, and which will be halfway down the slope. So that's okay. Oh, sorry, what am I doing? Oh, yeah. Thank you. Okay, yeah, just, yeah. Halfway down that a steep slope, and so we'll be losing riparian margin. So it's not just a case of, say, in the southern tributary where it's very close to the stream, but the riparian margin is pretty rubbish there at the moment. It's been lost over the years. It's still okay functionally, biodiversity a little bit different, and we'll be losing it. So I don't think that's really been picked up by the applicant at all, this balancing of potential ecological benefits with actual losses that will happen if it goes ahead as put to us. So yes, that's my particular concern, pulling back that without that area being pulled back to a minimum 10 metre buffer, we're going to be losing riparian habitat, and as a consequence, losing some ecological values, because that stream and the habitat is integrally linked. Okay, so that's for me has not been addressed. You had that question about whether it's high or medium values. In my view, we found longfin eel have been found with eDNA here. They found in one of the stretches eDNA, no eDNA, eDNA, eDNA. If you want to, in my view, it's highly likely that longfin eel will be utilising this reach. The habitat is suitable, and if you want to use eDNA, the reliability of those results is strongly dependent on the volume you push through and the number of replicates. So if you use 6 replicates, is generally the accepted standard for getting the same, highly likely of getting the same number of fish as if you're doing standard sampling methods. So there have been certificates taken over the whole site, and I think that's a good representation of the likely fish in the site as a whole. But I don't think you can just take one eDNA coming up negative here to say there's nothing upstream of it. That's not a conservative outcome. So I would suggest this is a good potential habitat for longfin eel, and they're really close by, so why wouldn't they go there? Okay, so almost there. Yeah, my last concern is this potential of not pulling back the riparian widths, is that you get this near permanent loss of restoration potential. And I think this concept of restoration potential is important. When we're looking in a consent process of stream loss, we often would use a stream ecological evaluation technique, SEV, and that looks at not just the current state of that stream, but the potential of that stream, what it will become. And one important reason for this is that it doesn't give this perverse incentive to go and degrade all your streams before you go through the consent process, which is kind of has been happening in this site for a decade or more. So the potential ecological is important, and what might be happening. And if you put hard surfaces like a concrete, and this has happened all over the country over decades, you just cut that out. If you're trying to go and do ecological restoration on an urban stream where the hard surface and the margins come right up to the stream, it's really, really hard work to get a good outcome. And so that's would be my concerns about locking these footprints in close to the stream edge. And I'd be very encouraging you to pull them back to the top of the slope, at least 10 metres back from the buffer. And I think we both, Ms. Wilcock and I both agreed that is a good outcome. And I would be saying that it should be the outcome. Okay, lastly, I've made a few provisions in paragraph 32 of my report, suggested changes. It is not great structure plan wording, but it gives you the idea that we just need to have some certainty in there that the outcomes that are anticipated will actually occur. And I don't see that certainty in the structure plan at the moment. Thank you.
Thank you very much. Do we have questions? Thank you, Commissioner Withy.
I'm not sure whether you were present, so please help me. Were you here when Ms. Wilcox gave her evidence?
Yes.
And were you here when Mr. Rayner gave his evidence?
Yes.
And if I can refer you to your paragraph 32 of your evidence, you recommend a number of things. And I'd just like to know which of those have not been addressed in the evidence of Mr. Rayner and Ms. Wilcox.
I'm not seeing any provisions for 10-metre setbacks. I mean, that's been said. It's all very well to say it, but if it's not in the words in the provisions, then it's not there. The requirement for ecological enhancement within those areas, at the moment, that possibly is covered loosely. Avoid loss of extent and values of streams, wetlands on the site. I'm not seeing any provision that requires that. Well, it could be done potentially, but it could just as well not happen. Seek to avoid damage to the Raupo wetland. Well, at the moment, I'm hearing that the Raupo wetland will be damaged, but the hope is to have a no net loss approach. But again, I'm not seeing any requirement and provisions to require that to happen. And restoration will be undertaken in accordance with a stream and wetland restoration plan. I think that is in the current provisions in some way.
Would you not agree that most of that is to be covered under a resource consent process?
Yeah, of course it could. It could be covered at this process as well.
That would be under the control of your council.
Not with the council.
Where you're advising the Bay of Plenty Regional Council. That council would have control of that process.
Of what? Of the
resource consenting process.
Well, process. It has control of a resource consenting process. I'm not a planner, so I don't know whether it will have ability to pull back footprints if they're put in the wrong place. I don't know if that has that ability through the consenting process. And I would have thought that it would be, I mean, I guess I put it to you, is it responsible to set a footprint that an expectation of it doing commercial development that is highly likely to cause adverse effects? And that's what we're seeing with some of these footprints, and suboptimal.
Yeah, I think you've probably taken it as far as you can. I accept you're not a planner or a lawyer, but I've noted the things under your paragraph 32 that you're still concerned about, and that's what I wanted to be clear on. So thank you for that.
Yes. Could you describe those three tributaries, the southern and those three that come down? Are they in any way ephemeral? We had some pretty dry summers the last couple of years ago. I think I read that the Tapuna stream on the eastern side continues even in dry weather. But is that true? And what about the other two?
I don't know. I was out there on a rainy day in June, so it was not a good test. Ms. Wilcock might have some views when she was out there, whether they were dry or flowing in March. If they are ephemeral, then damage to that southern reach would not be generally accepted to offset that damage by restoration on those two tributaries, because it's just generally not accepted to offset damage to a perennial stream by restoration of an ephemeral stream. So I guess it is kind of a relevant question in that regard.
Because that foreshadows my next question, which was going to be, if they are ephemeral, what is the ecological difference, if any, between temporarily altering a wetland that may not be functioning as a wetland at that point anyway, and having it, the difference in it being destroyed because of the dry weather and being destroyed because you're temporarily reconfiguring it?
The wetlands down in the pond area, down here, in my understanding, that it's not ephemeral, it's fed through this reach. Potential intermittent, and I think I'll be doubtful if they're ephemeral, but probably seasonally intermittent, so it would dry up in summer, but not in winter. If they're that, it'll be these reaches here, and I say I don't know if they are or not. These reaches, particularly this one, is pretty degraded, so there's potential for restoration in there.
Okay.
Has that answered your question?
Yeah, I think it does, yes.
Thank you.
Councillor Granger. If I understood your final comments, when you finished your evidence, you said that we don't lock in footprints now because they're very hard to change later. Is that an accurate summary of what you said at the end of your evidence?
Yes, that'd be a concern of mine.
And yet you also asked us to get all the rules now and not rely on resource consents.
No, not all the rules, just sufficient to have confidence that, because we've been hearing how wonderful this enhancement is going to be, but if you strip away the footprint that's there, because we've heard it can shift, so let's ignore it could be anywhere, then you just look at the conditions. What is in those provisions that gives you any confidence that the restoration is going to happen or be a positive thing, or going to be a nice 20-metre strip down the lot, or just a tiny couple metres around? We're just flying. I have full confidence in Ms. Wilcock's intent and aspirations, but is part of a big project, and she's not in control of that project.
Thank you. Ms. Price, would you wish to clarify? Okay, thank you. Thank you.
Sorry, Mr. Chair, could I ask a couple of questions of clarification of Mr. Hamill through you, please?
Certainly.
Mr. Hamill, if you wouldn't mind turning to your diagram figure 1, where you've got in your evidence of aerial photograph. Oh, it's up there, so that's easy. I know you've said you're not a planner, but I'm just trying to understand, did you perceive in terms of giving your evidence that the areas in yellow are potential building footprints?
Yes, I perceive that those are areas where you want to put commercial zone. And yeah, and I think there's been a lot of confusion here about that. I've heard those footprints have shifted around. In evidence I heard from Ms. Wilcock, there was confusion about whether those are going to be in those places or at the top of the slope or 10 metres on the slope.
So if I said to you that those areas in yellow, as in the context of a structure plan, are there as indicative development areas rather than building footprints, does that address some of your concerns around how close it goes, for example, to the Northern Reach or other areas?
If they're indicative building areas, why don't you just put them where you're likely to be built? So we have this in stream designs all the time, right? We have a specimen design for a stream with a long section of cross section, and our rubbish designs. And I say, look, this is a terrible design, and engineers say, look, don't worry about it, we'll deal with it in detailed design. So put some conditions in, it doesn't get dealt with in detailed design, and you end up with a rubbish design. So, I can list off lots of projects like that happening right now. So if you want to put the footprint further back, why don't just put it further back?
So if I can just talk you through a bit of the process just to clarify what your thoughts are here. Just one thing, if I could refer back to Ms. Era, and she discussed that the regional council's got quite a different approach to stormwater and how it's handled now, that the regional council's seeking different solutions in stormwater ponds. And I know you're not a planner, but my understanding of that process is that it is one that's generally a discretionary activity for larger projects. And I'm just wondering if you could clarify, do you get involved now in those projects, given that she's referring to wetlands and other matters as preference to stormwater ponds? Do you get involved in the consents?
Which consents?
For stormwater with the regional council?
Yeah, all over the country. Yeah, with this regional council?
Yes.
For stormwater? I don't know. Oh, look, I can't recall if I haven't got any on at the moment. I'm doing work with Whakatahi at the moment, Greater Wellington Regional Council, done work with developers in the
I'm just
Waikato
asking
region.
in regards to this regional council, do you get involved? Do they bring you in as an ecologist to deal with stormwater discharge consents in terms of ecological assessments? Or types
I haven't been, but I'm not sure if that's what the point of that reference is, because they have a range of consultants. Okay. Yeah. Can I make one more point though? If you're talking about that indicative footprint, meaning buildings, I'm not just concerned about a building being butted up there, but it's the retaining wall. Like if you're pushing out your dirt and you're steepening up those slopes, that all has potential impacts on the stream. If you then put your this infrastructure close to a stream, then you want to be able to protect that sort of stream, so you end up putting lots of heavy rock in it, and you change its form and design. And there's so many examples on Tauranga where that's happened, and they're just bad stream designs. And that's because you put the infrastructure really close to a stream.
Okay, I think you've made your point. We need to move on. I know taking Ms. Barry Pacino's point, your hour is gone. How long do you need, Mr. Tapari? Are we able to go through that quickly, or should we take a short tea break now?
I'll make it quick.
You'll make it quick?
Yes.
All right, thank you.
Thank you. Sorry. Yeah. Right, so I guess I just wanted to bring us back to this issue of what a structure plan is. From a planning perspective, we've heard from the experts. They have various views about all of these various different things. But I guess this is all running through a planning process. And because there's a planning process, there's a policy framework, which we need to have regard to. And there's also the nature of this particular site and as to why I think it should be structure planned. And I support the comments of Mr. Collier as to, progressing structure plan in this area. Now, if you look at that map, there's a number of competing things all happening very close to each other. I mean, you don't have to be particularly educated to see that there's land use conflicts there. Now, at the same time, we've got some very strong directions set out in our National Policy Statement for Freshwater Management. And I'm not sure whether the commissioners are very familiar with those directions that are in there and the extent to which they apply to this plan change. Yes. Okay, great. And just the point that I really want to emphasize there is this whole issue of avoid. That's a very, very strong direction in resource management practice. And so it's not a remedy, it's not a mitigate, it's avoid. And so I've set out my evidence, that test. And I guess for the purposes of that constrained site, when we look at the importance of mapping those maps in the correct locations, but then also considering that that's a primary consideration for the development of a structure plan. So objective 2.1 inside the NPSFM it prioritizes the way in which you develop land. It's a really different frame from what we're used to. And in fact, what we're looking at first is protecting the health of streams and then later providing for economic development. On a greenfield site like this, I'd say that's a primary consideration, and it's probably fundamental to our concerns, because probably what we may have found in the past is that, yes, there may be opportunities for ponds and wetlands and all those sorts of things to be constructed in these locations, or for zoning to fit around a scheme. But I guess what we're saying in this case, and also having regards to the concerns that Kathy Theolardin's raised, that I'm still not confident that our concerns regarding a feasible stormwater solution have actually ultimately been reached. And the principal reason that I want to address that is if we could, just wondering could someone show us the map inside the evidence of either Aaron Collier or Neil Rayner for us, which demonstrates their proposed solution? Please. Yes, thank you. Yeah. The latest proposal, please. The one we got yesterday. Yeah, that one. So, I mean, just to demonstrate the point, and I think the applicant has actually done us all a benefit here, because in terms of structure planning, what we see is zoning proposed over the top of a stormwater solution. Now, if you're a landowner and you were going to buy that piece of land, would you want to implement that, implement the rights entitled to you by that zone, or would you want to implement or provide space for a community solution, for a stormwater solution? In my mind and my experience of structure planning, this is a spatial planning exercise that's identified. Clearly, we have a land use conflict here, and this needs to be resolved. I mean, this is the fundamental reason of what Kathy's concerns actually amount to, is they've done the sizing, but we've got, structure plans about layout, and it's quite obvious to me that those green areas that sit over the zoning are conflicts. And so why would we embed a conflict into a plan rather than resolve it? And we have heard discussions around, well, this is indicative zoning, but on a small site like this, I think it would be quite an uncertain, imprecise approach for zoning to be only indicative? I mean, and certainly, does that provide certainty for landowners? Because of course, this gets transposed onto a district plan map, and that would be on property boundaries and all the other aspects that go with it. There's ownership and rights that are conferred by the zoning of that land and by that map. And that's the process of a structure plan. And, you know, spatial planning is a good step when we talk about indicative things. Let's be indicative. But here we're talking about extents of considerable land use development rights above the rural zone. So it's really, really different. And I guess that's one of the principal differences we have with the approach with the applicant, particularly on a small site like this, because if that appeared in a district plan, certainly you'd want to see some certainty. And other plans such as Omokoroa, stage 2, they show clearly the extent of that structure plan and which properties it relates to. And I don't see this to be anything different than that. And certainly we're not seeing any provisions in their plan that would advance that issue around where those boundaries should lie. And we think it's wholly an issue to be dealt at the structure plan. Otherwise, we're just basically rolling over an unresolved issue. And
could I interrupt you there?
Yes,
So in
yes.
summation, you're saying regional council would want to see some restriction of the zoned area to enable greater area available for stormwater relief.
A reduction, not restriction. Restrictions controlling.
Sorry. Yes,
Yeah. Just to make the
I used the
distinction.
wrong word.
Yeah, no. It's good. It actually highlights exactly the point, which is not controlling effects, but two different uses on the same piece of land. Yeah.
Okay.
So almost.
Yep.
Almost there.
Quickly.
Yep. So in the same regard, we feel that the same approach should be taken if advancing anything to do with provisions as well. You know, clearly we've got, because of the adjacency of all of the things happening on that little site, that it is necessary to have specific planning provisions that apply to the site. Generally, district plan rules are very good in existing environments where you've got a known urban form and all the issues are generally considered and we can deal with it site by site. But a greenfield site is a fresh slate and it has its own particulars with its own aspects, and the structure plan accordingly should respond in that particular way. So we don't think that it's just a generic response that you would otherwise have in determining what's the appropriate measures to manage effects on a greenfield site, which is different from existing urban areas. Just wanted to make one further point too, particularly on the matter of stormwater discharge. There are a number of assumptions that have been built into how stormwater is being addressed on this particular site. And in order for those assumptions to ultimately be implemented, a mechanism via the structure plan process should appear, in my view, in the district plan. My assessment of what I've seen in the preparation of the Section 32 analysis requires assessment of options, selection of an option, and then various different measures to address the effects of that selected option. In my view, it hasn't occurred. And that's a fundamental omission in our minds, particularly to do with stormwater management. And those are the reasons that Kathy's expressed those particular views on that. So I guess what I'm really saying is that there's a role for discharge consents on a greenfield site, and there's also a role of a stormwater management plan. I've had a look at what the preparation of how that example's been prepared for the applicant, and I don't think it's robust enough, and I don't think it'll provide the level of certainty to actually protect the community and the environment. If that is not properly managed, there's a great risk that future recipients of the land will either have to retrospectively deal with those issues, and often this falls to the council, or the environment suffers, because the stormwater mitigation that goes in there isn't sufficiently guided by the structure plan. It's the role of the structure plan. The discharge consent in the end will simply reflect the important parameters that have been rolled over through the assessment of the structure plan, and then make sure it performs in a particular way. But design is very important, and hopefully that's come through from the presentation from Mrs. Ira. So those are probably the most important points. The last point I just wanted to make too is that I don't think there's any conflict to do with our original policy statement and UG7A with regards to growth. Clearly, under the National Policy Statement for Urban Development, it's about enabling growth. This is a contiguous extension to an existing area. So we don't have an in-principle issue, and that's why it wasn't a feature of the Regional Council submission. But certainly the salient issue here is the extent to which that stormwater solution is either fully feasible, having regard to and giving an opportunity to Kathy Theolarden to respond to that, because I think it's fundamental. And also the ability and the certainty to ensure what we're saying now happens in the future. And I think we've heard from Mr. Hamill, also Sue Ira, with her 20 years of experience in stormwater management, including being the consents manager and compliance manager in Auckland, that we can't rely solely on discharge consents. So there's an interrelationship. It's site preparation and layout, considering the effects, and then relying on discharge consents. Thank you.
Thank you, Mr. Prime. Commissioner Withey, do you have any questions?
Just one quick one.
Sure.
Do I apprehend that what would satisfy you and your team would be a stormwater management plan within the structure plan acceptable to your council? Is that really what you're saying?
It'd be a combination of reduction of zones as per that map. So we'd want certainty on the zoning. That's the first consideration, because clearly they're proposing stormwater infrastructure over zone land. Second one would be, yes, a stormwater management plan. I think there's definite value in that. And also for it to be guided by the modelling that's been already available, and it's very recent modelling available to Western Bay that's currently being prepared by them, and that should guide the sizing of that structure, and also supported by provision for a further risk assessment, which would actually protect the downstream infrastructure users. And I think we are going to experience an increase in stormwater flows, and under the regional policy statement, under policy NH4B, there is an obligation to ensure there's no increased risk on downstream users.
Okay. Questions?
And just to add, if it's useful, we are happy to, of course, work with the applicant further, subject to resolving some of those layout issues.
Yeah, my question, I think, is partially been covered by Councillor Scringer's question and Commissioner Withey. But am I to understand that if you roll back the white development footprint from those fluorescent green wetland areas shown on the map, you would be that would make you comfortable?
That would be the first step. The second would be an SMP, a stormwater management plan. And I think under the law as well that it would have to be signed off by Western Bay, but we would be a party to signing that off. Of course, you know, we would be consulted in that process. Yeah. But both of them are equally as important to address our concerns. Yeah.
Okay, thank you.
Councillor Granger.
Yes, I'm still trying to tease out the existing flooding issues, which you mentioned a number of times in your evidence of the known history of flooding and flooding issues experienced in the area, and the history of flooding a number of times. Can you give us some evidence of that history of flooding and how often and to the extent that it occurs?
I don't know the full details. I probably have to refer to Kathy Theolarden on the details of it. I just relied on her evidence.
Give it in her evidence either.
All right.
She said it happens, but there's no evidence in her evidence of it. And I just want to know where this comes from.
I think one of the sources was there was a greater concern when the previous comprehensive stormwater consent was considered for the wider area. And as a result, they terminated it at the edge of the urban extent, but didn't include this particular area. And there was a great concern at the time, I understand, from both Western Bay, Bay of Plenty, Pirirako, and also may have been a local community group, I can't recall the name, that an MOU be signed to look to investigate future options because of the ad hoc nature in which this area has developed without a comprehensive solution. So that was my understanding of that in response to known flooding history. Yeah. Yeah. Oh, and Kathy can address that for you, Councillor, if that's helpful.
No, okay. Now, we were told that Mr. Townsend would be available to answer questions. I'm seeing him down the back there. Were there any questions, members, in regard to Mrs. Teal-Larden's evidence? No. All right. Oh, thank you for being here.
Sorry, I just had a question. That was a question of clarification really for Mr. Martelli and Ms. Price relating to the stormwater modelling that's been referenced by two of the regional council witnesses. I'd just like to understand if the council's flooding maps that are being updated, whether those reflect the modelling that's being referred to in the district plan. I just want to get clarification on that if I could. The TMT modelling that's being referred to. Thank you.
Thank you for that. I have actually clarified that question that's come up from Sir Ira. I asked Nick and Rianne, who were here earlier, for that question. I asked, has the catchment-wide hydrological model, do we have one, and has it been used in the assessment of this site? Nick has confirmed to me that we have a flood model for the Tupuna catchment, which is based on the hydrological model. Note, he didn't clarify whether that was the TNT model, but we can clarify that again. In short, this model is part of the current flood model. We use the flood results to assess this site. Hope that helps.
Can I help and assist in that regard? I just know that the flood map information under the TNT model is different to what's mapped in the district plan, because I also work in natural hazards as well as part of my other role, and was involved in a natural hazard working group that Philip will be familiar with. So yeah, I can clarify that for the benefit of the panel.
Thank you very much.
Sorry, Mr. Chairman, can I just clarify a point because it's quite significant?
Yes.
There is no flooding shown on the district plan, on the planning maps. What we're talking about is flood modelling shown on the council's GIS, and people keep referring to district plan and maps, but it's the GIS.
Thank you for making that point clear. Good. Okay, we're going to have a break and we'll be back at 3:30 and look forward to hearing from the local Tupuna people. Thank you very much, Regional Council. Thank you, ladies. I hope you all heard that anyway. So without further ado, we're moving into the section of the local Te Puna people. And I believe we have Mr. Doug Kirk up first. So you're getting your team together?
No, yeah, I'll just let Mr. Simon Childs start.
He's going to start. Okay, thank you.
He's going to do the introduction. Yeah.
Good afternoon. My name is Simon Childs from Hasten Nell Planning Consultancy in Tauranga. I'm here today representing Mr. Kirk in his capacity as a submitter on the proposed plan change. Accompanying us is Mr. England from Seeker, and we're each going to take it in turns to briefly summarize the key points of our evidence. Starting us off will be Mr. Kirk.
Okay, thank you.
Good afternoon, gentlemen, ladies. My name's Doug Kirk. My family trust, the DC Kirk Family Trust, is the owner and operator of the Okaro Orchard, which is located at 35 Armstrong Road. My family and I live in the neighbouring property at 49 Armstrong Road. My family and I own and operate Okaro Orchard, which is located on the northern boundary of the site. The orchard is 5 hectares in size with 3.5 canopy hectares, meaning the planted area, and produces gold kiwi fruit for the export market.
Sorry, Mr. Kirk, could I interrupt a moment, please?
Certainly.
We have read all those statistics more than once.
Yes,
so
yep. Well, I was just going to summarise
the chase
quickly,
fairly quickly, please.
Yep, don't worry, I'll get to the chase.
Thank you. Appreciate that.
Yeah, at present, the measures proposed in Plan Change 93 to manage the interface between the orchard and the plan change area are minimal and will be inadequate. That is not surprising to me, given that despite the significant implications of Plan Change 93 for my land, the applicant has not made any great efforts to consult with me. In considering the options available for management of the interface between the orchard and the site, the council officer's report appears to suggest that the applicant has reached agreement with me on measures to manage the effects on the orchard. To the contrary, no constructive discussions have been undertaken and no agreement whatsoever has been reached. Although I'd much rather that PC 93 did not proceed at all, I've tried to take a pragmatic approach to the proposal, recognising that there is demand for development in Te Puna. On that basis, I've worked with the technical kiwi fruit production expert, Ethan England, on my left, and planning consultant, Simon Childs, to prepare a solution for the boundary that will minimise effects on the orchard and my property. The applicant has proposed a setback rule for sensitive activities. The setback rule will not offer a practical solution because the main risk of spray drift is from complaints, not actual harm arising from spraying. In other words, that people typically become anxious about spraying activities even when the chemicals being applied are not harmful. If complaints are received, spraying companies are unlikely to want to service the orchard, and this would register the orchard unviable. On that basis, my opinion, the only solution is the extension of the existing berm in the northwestern corner of the site along the entirety of the boundary with the orchard. As set out in Mr. Child's evidence, the berm would serve a number of functions, providing a buffer area that limits the risk of spray drift and dust incursion, screens the commercial development from my property while continuing to allow airflow from the site. In addition, the rules should be imposed to ensure that landscaping on the site avoids species which attract pest species which attract, such as passion vine hopper, which can be hugely detrimental to the orchard. In the last 10 years, the occupier of the planned change area has undertaken a lot of earthworks, bringing hundreds of truckloads of fill onto the site. A large amount of fill has been deposited in the northwestern corner of the site. And since that fill has been deposited, we have seen the quality of the stream decline rapidly over the last 20 years. It is now filled with sediment, which runs down the stream past my property and continues on down the road and ends up in the Te Puna Harbour. Since notification of Plan Change 93, the applicant has commissioned an ecology report and revised the proposed structure plan to avoid development over the stream. In my opinion, much more could be done to improve the health of the waterway, in particular by addressing the large amount of fill that has been moved onto the site. The removed fill might then be used to form the berm along the boundary with Okaro Orchard, thereby also addressing the adverse effects of development in the orchard. On a personal note, my grandmother was an Armstrong. Her family donated the land for the original site of the Te Puna War Memorial Hall. We safely assume that her family envisaged Te Puna to continue over the decades to be a place of connection, community, and commerce, not a mishmash of disconnection and disjointed, unsightly use of land and piecemeal planning and infrastructure. You watching, Mr. Martelli, as it currently is. Whilst my immediate concerns are for my orchard, I hold the view I am only its caretaker and that my land will be intergenerational and continue our lineage. These concerns extend not only to my immediate family, but the wider community. Without the correct foresight and planning, the Te Puna community will be left in an ad hoc and community unable to reach its full potential and prosper as it deserves to. What I am asking is that you stop and think carefully, please, about the future of Te Puna as a whole, not just piece by piece as it happens to come up. Most of you do not live in Te Puna, but many families in this area are intergenerational. Our 4 children have all attended the local Te Puna school and deserve to see the community prosper. To be a place where business is done, services are exchanged, and positive community relationships are forged. To make Te Puna attractive not only commercially, but aesthetically to the wider district, make it a destination, not a disaster. We have one chance. Do it properly. Do it once, do it properly. And finally, Commissioner and everyone, I heard Mr. Collier say earlier on that that he would entertain everyone coming and having a site inspection of the whole property. And if the applicants will allow me, I'd be more than happy to be your guide, as I've been walking around and running around for 60 years, and I can show you how everything used to be and how everything is now. And I'm sure you'll find that useful in your final decision.
Thank you very much. Mr. Kirk, now, do you wish to take questions now?
Yes, sure.
So, Commissioner Withy, do you have any questions? No. Councillor Granger.
Yeah, Mr. Kirk, I asked the question earlier on of the applicants about moving the road to the north to your boundary. Would that assist in mitigating any of your issues at all, if that was done?
Thanks for your concern, Mr. Granger, but a road still allows the spray drift to go through, and you've got a visual of cars going by as an entry place into the new village. If it was to happen, a berm and a controlled planting would be far.
Sorry, I wasn't suggesting instead of
a
visual barrier, but behind the barrier.
Oh,
So
behind the
still
barrier.
there will still be screening.
The barrier and then the road.
Yes, and then whatever.
Yes,
setbacks and buildings.
yeah. Well, the further away, trying to run an orchard operation would be far more easier to operate. No doubt about it.
And okay. Thank you, Mr. Kerr.
Hi, my name is Ethan England. I'm here as a kiwifruit technical manager from Seeker Limited. Where Doug Kirk not only supplies his fruit, but also we provide some staff and expertise to the orchard. So I've had 9 years experience in the kiwifruit industry, specialising in technical aspects of growing kiwifruit, that is fertiliser programs, spray programs, trials and new products and techniques. I was engaged by Mr. Kirk this season to come up with, to review the plan change and to see if there's any implications on the growing system of Okara orchards. As you've noted, it is a 3.46 hectare gold tree kiwifruit orchard. It is located on Armstrong Road and the corner of Tapuna Road. So it's owned by the Kirk family and managed by Seeker Limited. So we need to do many conditions and many applications throughout the season to ensure that the product of the fruit is high quality and reaching all markets for zestberry. So that's where it comes into play with spray drift. Although we don't want spray drift to happen, there is always the possibility that it can happen. With that the southern boundary of Okara Orchard being right next to the development, we see that as a risk, as it is the anxiety of people that causes more issues than it is the spray drift itself. If they see or hear a sprayer, that can cause a lot of issues and complaints. And therefore the spray operators refuse to work on those orchards, making it hard for us to get the premium quality that we need for our crops. Throughout the season, we're likely to do about 12 to 16 sprays. Not all of these will be an agrochemical. Some of them will be a foliar nutrient, but to the general public, that is irrelevant. They see a sprayer, they hear a sprayer, they consider it an agrochemical. So in terms of solutions for managing the spray drift, the artificial shelter itself will be catching about 30% of the particulates. But not only that, it's going to be decreasing the velocity of the airflow going through it. So therefore we need a buffer beyond that, a planted berm buffer, to catch those particulates before they land on anywhere that the public can access. If we were to put in a natural shelter like was added in there by the Fruition consultant, that natural shelter needs ongoing maintenance with its trimming and mulching. It also then is competing for nutrients with the orchard. And if it's mismanaged on one side of it, you can get quite a dumping effect with the wind coming across it, which will then cause more damage to Doug Kirk's kiwifruit on the other side. Not only that, artificial shelter allows a nice even permeability of the air. So that creates, that allows any frost, cold air to not cause a frost pocket. By putting a natural shelter that is mismanaged, we can then create a buffer area where it sits, and the cold air will sit within Doug Kirk's orchard and causing damage to his shoots. So we would like to keep the artificial shelter as it is, but with a berm on the other side to allow easy access air naturally flowing through that. Pest incursions. So over the previous seasons, Okara Orchard has suffered great losses to sooty mold. It is mostly due to passion vine hopper. They are small insects that come across through your boundary and they travel quite a large distance. We therefore would like the plants that are planted within the berm, the buffer zone berm, to be according to the Zespri planting guide that shows where they are safe to do for passion vine hopper and thrips. Otherwise, we will be getting some market restrictions on the fruit or further crop losses. Dust incursion is another one. So there are a couple of times throughout the season that we're looking at sensitive periods for dust, and that is during August, where we've got application of bud breaker products. If the dust is coating the cane, we can then get meaning that the products will not adhere to the cane itself. They'll drip off and we won't get the same production as what we're currently getting. As well as at the time of pollination, which will be in November. And that's where the dust will settle on the stigma of the plants and it will stop pollen grains entering into the flowers. So to rectify that, we ask for any appropriate measures to manage dust, including dampening of bare soil surfaces when high wind events are expected, and by applying shredded hay to any bare surfaces that are not currently being worked on. So in my opinion, the current change plan hasn't taken into account the Okara orchard's needs sufficiently, and they need to be rectified to include that berm, a planted berm on the northern boundary, to ensure that there is no harm taken to, no interruption to Doug Kirk's current orchard that is on there and has been there for many, many years. And so we would like that to be written into the rules for the construction and operation activities within that zone there. So there's no chance that it cannot be missed out and causing harm to Doug. That is all from me.
Thank you, Mr. England. Commissioner Withy, do you have any questions? You addressed a very practical issue, Mr. England, in regard to passion vine hopper and said that there'd been significant fruit loss in the past. Have you treated for that in the past?
Yes, annually there is 2 applications minimum that have been going on this orchard. And we would like to keep that as a minimum if we have to. If the plants are attracting more PVH into the area, we would likely see that go up.
Thank you for that explanation. Ms. Virginia?
Actually, a similar one, I guess. With the passion vine hopper, if the kiwi fruit is a suitable host for that insect, and you have 3.5 canopy hectares, I'm just wondering what the impact of a thin strip of vegetation along the boundary will have in terms of somehow maintaining a population of passion vine hopper.
So that would be a huge incursion, can be a huge incursion. So 3.46 hectares of canopy that we're spraying annually to remove these, but we're not spraying our shelters because we cannot spray our shelters, and we're not spraying our neighbour's property. That is where all of the passion vine hopper are coming from the neighbouring zones. So even by having a planted berm in any old plants, that can still lead to great losses for Doug Kirk.
Appreciate that. Thank you.
Councillor Granger.
Thank you. Yes, just going to the spray drift question. How is that handled and dealt with vis-a-vis the footpath on the western boundary, where there's, I don't think, any shelter built at all?
Footpath?
Yeah, from the footpath, generally we leave a couple of rows unsprayed near the footpath, or we do it extremely early in the morning and have a patrol officer at each end of the footpath to make sure that there is no traffic coming when the spraying occurs.
Including foot traffic as well. And I've been doing that myself for the last 3 years in August.
Thank you. Yes.
Point of clarification, please.
Certainly.
Mr. England, at your point 2.9, and you've mentioned this a couple of times about a buffer zone. I just wanted to clarify with you because we've used that term several times in maybe different meanings. On the structure plan map, we have a red dashed line, which is the 30, which has been previously maybe referred to as the 30-metre buffer setback. Are you in your point 2.9 referring to more of a landscape buffer, maybe similar to what Mornay Hugo has referred to in his evidence, his rebuttal evidence, where he's provided a diagram that shows the 3-metre wide landscape strip?
A 3-metre wide, I feel, will be inadequate for this buffer zone. It needs to be a raised berm with a planted raised berm on top of it.
Yes. So sorry, just to clarify, if there was a raised berm within that 3-metre wide buffer strip, a 3-metre wide landscape strip with the planting on the top of it, that is required under the district plan. Would that satisfy your buffer zone requirement?
Ideally, we'd like to see a little bit wider than 3 metres, but
how much? Sorry, just for clarification.
5 metres, 5 to 7, I would presume.
Planting?
Yeah. A planting, and the berm just needs to be within that. Yes.
And just one other question, you mentioned the passion vine hopper. Have you got some plants that you would recommend avoiding to assist in avoiding passion vine hopper, or are they just in everything? Like, have you got
so the planting guide that was part of my Appendix A, the Zesbury planting guide, there is a detailed list of which
pages
ones.
Was that on? Sorry, because you've got 178 pages there. So what's that? Right at the end.
What is appended to my statement?
174.
Yeah. There's a list of all natives and a few exotics and their status of good, okay, and bad for passion vine hopper.
Great, thank you.
So anything that is green would be great. Anything that is the orange would be acceptable in places, but nothing in the red.
Okay, thank you.
Okay, thank you, Mr. England then. I think that completes that. So we're round to you, Mr. Child.
Okay, thank you. I'm just going to briefly cover a couple of points or key points I made in my statement. In my opinion, a master planning process is required to properly and coherently provide for Te Puna's growth over the long term. The risk with more piecemeal development proposals, such as Plan Change 93, is that the outcomes of a future master plan process may be preempted or undermined. In the absence of a master plan process, piecemeal zoning proposals, such as this one, are likely to continue, potentially resulting in disjointed and poor quality planning outcomes. The way I illustrated that potential issue with a future master plan process for Te Puna was through a discussion of the proposed 12-metre height limit. In my opinion, this raises a question about whether the plan change appropriately responds to the existing character of the local area. In particular, a 12-metre height limit will not maintain a small-scale character and village feel amenity. Potential big box retail development would be enabled by the plan change, but in my opinion, this would not be a good fit for the site or surrounding area. In my opinion, the plan change request has not provided a compelling rationale for the increased building height. Therefore, I agree with Ms. Price's conclusion that the permitted 9-metre height limit for the commercial zone should be adopted in the event the plan change is approved. A 12-metre height limit may not be appropriate for the wider Te Puna village, as that assessment has not been completed as of yet under this plan change or otherwise. The other issue I'd like to address briefly is that of the boundary interface issues that Mr. Kirk and Mr. England have addressed already with the Akara orchard to the north. Earlier today, we've heard about the daylighting and landscaping buffer standards under the district plan being applicable along the boundary. However, these are considered inadequate in mitigating the adverse effects on the adjoining orchard as detailed in the collective DCK statements of evidence. I won't summarize these again and go through the potential adverse effects on the orchard. However, it's clear that the 2-metre high landscape buffer on the boundary, 3 meters wide, will not likely address the dust spread and spray drift issues that we've already covered. If a 12-meter high building is set back 10 meters from the boundary, there's potential there for other land uses causing problems for dust spread, for example, in the example of, say, a car park in that intervening space. There is therefore potential for the proposed plan change to adversely impact the working operation of the orchard in spite of the district plan daylighting and landscape provisions. It's for this reason I consider landscape design and associated provisions as presented in my statement of evidence as needed for the plan change with respect to the shared boundary with Okara Orchard to the north. If clarity on the interface and the protection of the orchard activities is not provided under the plan change, then the adverse effects could potentially worsen through a future resource consent that would include a breach of the daylighting provisions through a proposal to locate buildings closer to the boundary. This is clearly a potential outcome as the final site layout has not been determined as of yet. There's a potential for any resource consent such as that to not address all of the adverse effects on the orchard as presented as part of the accompanying assessment for that resource consent. What I'm proposing is that the plan change provides certainty for the interface with the Okara Orchard rather than relying on inadequate district plan provisions for this situation and the uncertainty of the final site layout design and any associated resource consents. And finally, the use of specific provisions for a structure plan area is a common occurrence. For example, even within the Western Bay, with regard to the Te Puna Business Park, within the industrial chapter of the district plan. Thank you.
Thank you very much, Mr. Childs. Questions? Commissioner Withy, clear? Councillor Pena, Councillor Granger.
Yes, thank you. I'm mindful of our warnings this morning that the Te Puna plan should not be taken as much guidance because it's a non-statutory document, but nevertheless, you did quote it. And you talked about piecemeal development and you quoted the plan which suggested that the any future development should be consolidated and located in this area, which this plan change does. So that seemed to be a conflict to me. Can you tease that out, please?
So the potential piecemeal state of this plan change is specifically relating to a wider, more comprehensive plan change for Te Puna Village. And in terms of where that boundary would be, in terms of the wider area, it hasn't been determined, and that's the point about any potential conflict for the wider land use pattern as presented under the plan change in front of you.
Okay, thank you. All right. Apologies, Mr. Collier.
Sorry, so just through clarification, because it may assist me in working on some of these versions of us.
Could you turn your mic on, please?
Sorry, just a point of clarification and through you, Mr. Chairman, because it may assist me in working through these provisions that I said to you that I was going to work on. Just in relation, and perhaps it might be best if Mr. Kirk can assist. In terms of the boundary interface, which seems to be the main matter that's been raised here, does, from an orchard operational kind of point of view, does having an artificial shelter with planting sitting directly behind it work, and is it easy to kind of maintain and manage from the other side of the fence? Or is Mr. Kirk not wanting the 3 meters of planting where the artificial shelter is remaining? Because a provision could be drafted around maintaining the shelter and or maintaining some planting. And I'm just trying to clarify whether it's both that is being suggested or one or the other.
Thank you. Could we refer that? You may wish Mr. England perhaps to assist in regard to that, I suspect.
So we still wish to have the current artificial that is there
to remain in place,
followed by a planted berm with the landscaped area within that landscaped area. So
is that clear?
I think so. Thanks.
Yep. Thank you. That's where I thought we'd got to. So, okay. So I think we're satisfied there. So thank you, gentlemen, for your presentation. Just before we move on, perhaps a bit of a change. I understand, Mr. Tapari, that the Regional Council has some recommendations they wish to table for us for our consideration. So would you like to deal with that now?
Thank you. Look, I'll be really. Yes. Okay. Yeah, look, thank you for the opportunity to address you guys again. Just in response to some of the questions that have been raised and better understanding the proposal. Obviously, we just saw it yesterday. On the basis of reduction of those extents to include those green and blue areas and a sufficiently increased size for stormwater allocation, the Regional Council are happy that that would address our principal concerns. However, to ensure that implementation occurs in line with what's expected by A, the statutory documents, and B, what that stormwater design was actually intended to do once it's implemented, these are the essential provisions that we think would address that. Karen, keep going. Yeah. And so just quickly, in a very quick way, by summary, the first three under one deal with water quality, and that addresses the conditions that and some of the issues identified by Sue Ira. We've got an objective, a policy, and a rule. The rule is probably the most important bit because it addresses the use of inert materials. We're talking about commercial land uses very close to streams. We have to control its source. Roofs are a big source of that. Second one is a stormwater management plan, and it's about addressing cumulative effects. A key feature of that is that we have a discharge consent approved alongside the development of a stormwater solution for the site, and that stormwater solution is sized by the most up-to-date modelling that gives effect to climate change, which currently sits outside the district plan. So we've brought those elements together as a way of determining what the appropriate basis is for the sizing requirements of that infrastructure, now that we feel if the panel is minded that we have sufficient space for that solution. So these are the provisions that would ensure that A, the sizing is right, and B, the discharge consent and subdivision won't occur at odds with each other. So they're considered in parallel. If that makes any sense. So essentially we don't end up with piecemeal solutions for dealing with stormwater. And when you design the stormwater, the subdivision elements, then at the same time you'll consider to what extent would you have space provided for water sensitive urban design solutions, which are yet to be identified within the commercial areas. So that's the full complement of stormwater management for this site. And the reasons are set out in there. Following that, we've got a few, there are two important elements under 3. The first one being we have an issue identified in the evidence of Kathy Te-Alarden about downstream risk. We think a subsequent risk assessment would assist in ensuring that that occurs, because we obviously need to protect those downstream users and the infrastructure, which I think has already been raised by the panel at some point. Secondly, on the site, there's actually a convergence of 3 stream systems. Now, what that means is that when the development platforms are occupied, it means it's going to change the sequencing of how that flow will operate in that stream, right? So that means adequate assessment at time of design needs to be had for that future change in duration between those 3 stream systems to make sure that the mitigation pond doesn't fail. And that's the advice being given by our engineers on that. And, you know, if you wanted to ask any further questions, Kathy Te-Alarden would be happy to do that. Lastly, there's an opportunity for alternative modelling platforms. And then really the pertinent question or the pertinent thing here is under item 6, which are the 3 elements that we consider essential to secure at the structure plan stage for this particular site for stormwater management. The rest we can deal with through a discharge consent. Yeah. So, and then the last one is a performance standard to ensure that other people doing subdivision comply with the FCMP. So this is the level of robustness that the council consider to ensure the outcome occurs at implementation. Sorry, it's a lot to go through. It's all very clear in my mind, but I'm not sure whether that's translated.
Well, we will take a bit more time to consider this when we do our deliberations, but thank you for making that clear. And we have the paper and we have, which puts it in a more concise manner. And as you say, you've made the offer that we can approach for further questions if we require. So thank you. Yes, Commissioner Withy.
Yes.
I presume this isn't something you just wrote in the last hour. What's the origin of it?
I wish I had that level of expertise, but I don't. It is something we prepared for the structure plan in the event that we would be able to address our principal concerns around sizing. So we had already prepared this. However, because our sizing concerns hadn't been addressed, and I set this out in my evidence, we didn't think they could be resolved through planning provisions alone.
I just am puzzled as to why it's only arrived on the council table now. Why was it not provided to the council a week or a month ago?
Well, because we worked on a scheme. We've only just seen a scheme yesterday at 3:30 in the afternoon that would broadly address our concerns and had an opportunity to review it. Otherwise, we'd remain in opposition to the plan change.
So this document is something that's been specifically prepared for this hearing. It's not something that you have on the shelf for other contexts. Is that right?
It's similar to a stormwater solution for structure plans for Washer Road, but slightly different because of the nature of the effects that arise out of that plan change.
Okay, thank you.
So it's just not a verbatim thing that we've rolled out and we're going to put on everything, but there's similarities because of the nature of our policy documents and what they require. Yeah.
Okay. Any questions before I leave? Okay, thank you, Mr. Tapari, much appreciated. And as I say, we'll be considering that as part of our deliberations.
Many thanks. Thank you.
Thank you. All right. I think from memory next was the Puna Heartlands. Okay.
Good afternoon, gentlemen. I'm the present chairperson of Te Puna Heartland Inc. My name is Richard Cumming. And I'm just going to reflect what the community is presently saying to us. Amongst all of the plethora of comment, analysis, claim and counterclaim contained in what has become a labyrinth of tortuous paths and a seemingly ever-changing presentation of the basis of the applicant's application, Te Puna Heartlands has failed to publicly acknowledge and thank the original harbinger of the news of the existence of this application. Heartlands, over its near 20-year history, has always had a robust and mutually respectful relationship with its local councils. Thus, it was perfectly normal for us to see councillors Don Thwaites, Margaret Murray Benge and Murray Granger giving up their private time and attending our usual bi-monthly Heartland meeting on the evening of Thursday, the 9th of December, 2021. Whilst most of that meeting was concerned with the issues of the permitted industrial zone on Te Puna Station Road, under the final item of the agenda, Councillor Murray Granger gave the meeting notice of the recent receipt by council of this private plan change application. Thank you, Councillor Granger, for this advice. Had you not given us this information at that time, 9th of December, the depth and detail of our submission of the 4th of February might not have been so polished, or we think it's polished. The main part of my presentation on behalf of the Tapuna community is that I ask you to look at the whole scenario from December 2005 to today, but to look at it from the community point of view. We are a community group. We have no axe to grind in respect to this application, except and to the extent that it conflicts with our Tapuna community plan, and or it includes assertions made as to our alleged involvement through alleged consultation or otherwise in respect of this site over the last 17 years, which are factually incorrect or nuanced in a way that conflicts with the community's point of view. Although not formally lodged in evidence, Hartland strongly implores you to carefully study our Tapuna community plan for December 17. You will more clearly understand the community's view. It's a good document to be studied by anyone looking at Tapuna as a whole and wishing for its residents to vote for them at the next election. Late in the evidence process, we have lodged a copy of a council plan, Annexure D of our further evidence of the 5th of July 2022. Hopefully it's going to be posted up on the Yeah, it's not perfect. And it's somewhat faded from the reproduction machinery. Its only purpose is to reinforce the fact that Tapuna is primarily rural. The area on the four corners of our major property intersection was then, now this plan came in relation to the inclusion of, in the 2010 district plan of the Minden lifestyle zone. But it is the only, the presently zoned land, which is right in the middle, below the pink below the separate zoning for the post-harvest facility of DMS. This is the only commercial zone land in Tapuna. This plan is represented on page 6 and the zoning and infrastructure plan on page 35 of our community plan. I'm indebted to the evidence of Simon Charles dated the 1st of July 2022, and in particular, the Google Earth photographs on page 31. Let me put those up. They are in evidence. The first photograph shows the site at the time or shortly after the applicant's acquisition. It is particularly helpful because it shows the superimposed new roading arrangements being planned at that time and how this roading development was to so affect our old 1920s War Memorial Hall. Now, I, for one, and I'm certain there are many others in this room who will be in the same position, clearly remember the scene painted by this photograph. The rural zoned land was rural. The stream was flowing. The cows, or sometimes the goats, were grazing. And for those concerned, the stock had easy access to many available water troughs and a bridge, and they had no need to try to navigate the steep stream banks and thereby degrade the clear mainly spring-fed water or disturb the eels and fish stocks that were present in abundance. The scene was clearly visible from Tapuna Road, and the footpath along that road was easy to navigate. The second photograph shows how this applicant has changed the scene and still somewhat amazingly considers that it is not breaching the rural zoning of especially the northern section of the site. Many people knew Rex McIntyre, myself included. I think it is fair to say that he was an affable character, at the same time as being a hard-nosed businessman, who had no hesitation in trampling over you if you got in the way of his business plans. Nothing much seems to have been said, apart from Doug just a few minutes ago, about the manner of the degradation of this site by this applicant, same applicant of 17 years. The seemingly total ignorance of the environmental issues that were caused by the manner of the use of this site. No doubt the regional council will have records of the instances when they received complaints from the public about breach of this rural use, especially when large fires were lit to get rid of excess industrial cool store insulation panels, creating a pool of highly toxic black billowing smoke over the neighborhood. However, no doubt this sort of behavior is irrelevant to the planning process. However, what is relevant, again, from the community's point of view, is the collection of allegations that the applicant has had significant consultation with the community. In rebuttal, the community says, we have no evidence or recollection of any involvement of or by the applicant in the preparation of the Te Puna plan published in 2007, 1.5 years after the acquisition in December 2005. This is in itself a plan worthy of your study. The whole community was approached. The council was involved in that whole community approach and asked to play their part and participate in the process. This process was repeated in 2017, and again, there was no involvement by this application in that process. We have no evidence or recollection of any involvement of or by the applicant in the district plan review process that led to the current district plan being adopted in 2010, or strictly adopted in 2012. Surely that would have been the time to make this sort of application. We have no evidence or recollection of any consultation of our community being sought by the applicant when it made its planning application for light industrial use of its land to the council in February 2015, apparently according to the applicant's evidence by way of a private plan change. Similarly, we have no evidence or recollection of any consultation of our community being sought by the applicant when it attempted a private plan change in 2018, of which this application is a continuation of the process we started in 2018. The community is also concerned that the council issued a resource consent in 2016, allowing the applicant to site commercial workshops behind BP on existing commercially zoned land that encompasses the main natural spring on the property. Presumably, this resource consent will still be actionable if this plan change application is declined. What is to stop the applicant from commercially developing this area, as according to its own words, it has only not acted on this resource consent due to the impending plan change. The community is also very concerned that the assertions that the applicant, in the guise as Supermac or Modcom, will relocate from the site if the land is rezoned. They think it's a veiled threat that if the application is declined, Supermac Modcom will not relocate, notwithstanding the applicant's alleged change in circumstances. Community trust in this applicant is in short supply. This state of affairs has only arisen through the actions of this applicant over the past 17 years. Our community is again concerned that the applicant is using throughout its application and evidence, and indeed in the legal brief presented to you this morning, the passive tense when it refers to the state of degradation of the applicant's land and the impossibility of returning the rural zoned land to truly rural uses. It's really actually dodging the reality of the situation. And why not own up to the fact and accept that in its 17 years of ownership, it has knowingly and wantonly degraded and modified and dumped off-site fill onto the site, thus transforming in 17 short years a pristine rural area that the Kirk Armstrong family had carefully stewarded for the previous 131 years. And they converted it into this total mess and eyesore. I can give examples of that use of the passive, but they're in the evidence. The Te Puna community is also very protective of the Memorial Hall and supports its committee on the many issues that it's had to face in the time since it became apparent that the original hall was going to have to be moved. The letter produced by the applicant is a prime example of how brutal Rex McIntyre could be. The members of the then committee were in an invidious position. They had no negotiating powers. They were merely pawns in the chess game that Rex was playing. The Transport Agency was reluctant to exercise their Public Works Act powers, but were honour bound to acquire a like-for-like site and fund the cost of the new hall up to a sum that reflected the cost of moving the old hall to its new site and bringing it up to modern-day required building code compliance. Rex was requiring the Transport Agency to pay the fullest commercial per metre squared rate for the hall site, including that part that is zone rural. In the end, a private sale arrangement commercially beneficial to the applicant was concluded. In order to get the deal done, the council, as eventual owner, required the hall committee to meet one of Rex's conditions of sale, to sign this letter prepared by Rex. No doubt because he thought he would give him some leverage in the future. The questions of coercion and duress come to mind, let alone the fact that the applicant's then proposed plan was very different. It's another dismal example of how this applicant has operated. The new assertion that the hall committee operates by virtue of the good grace of council on a piece of council land defies the history. Who gave this land to the county council? No consideration passed hands. The local community constructed the hall at no cost to the county council. This is how things were done in the country in the past. In my very recent conversations with members of the community, a common theme is emerging. How come the council did not protect its community by policing and enforcing its own district plan? Are we wrong to think that the council is there to protect us when a landowner openly flouts the rules? What is it with this applicant? What hold does it have over our council? Why is our council effectively rewarding the appalling behaviour of this applicant by granting it a private plan change? How come this applicant is getting away with paying reduced rates based on rural zoning when it is using this land for light industrial purposes? These are the questions being openly asked of me when I talk to members in the community. And then no doubt, if you approach them, they'll say the same things to you. I understand that this is not the appropriate forum to deal with the wastewater issues. We are, though, looking forward to DMS being allowed to join onto the transfer line and thereby significantly reducing the pressure on the adjoining valley stream, the Hakau. In respect to the hall site, it does seem odd that what was good enough 4 years ago is considered already out of date. It also seems odd that the application received by council on the 4th of December 2021 bothered to deal with the wastewater issues when apparently they were already sorted. So those are my concerns. I'll hand you over to my secretary, Beth Bowden.
Do you want to proceed, and then Beth, and you don't need to go over the history again. But,
no intention.
And if you want to add anything now, and then we'll have quick go to questions.
I have 2 points to make, Mr. Chairman. The first is that mine was the work of drafting and putting together the submissions and paperwork for the purposes of Te Puna Heartlands. I'm here to register my dismay at how difficult a task it was, largely because I could not actually rely on the facts and evidence-based professional opinion being put forward. I had to do considerable research to establish what basis existed, if any, for many of the arguments the applicant has put forward. I think they could and should have done better, and beforehand, and without denying, as they did, that no rural land is really affected on account of it's been deruralized already. I am dismayed as well at the lack of nuance, the lack of sincerity with which the material that I did supply was treated and described. I do not think it is good enough to have our measured and clearly expressed doubts and misgivings summed up as support just because we did not actually say we did not support an element of the application. We would like a little more respect for the efforts that are made by admittedly amateur participants in the process for getting to grips with the situation. To be short on this matter, Mr. Chairman, we set up ourselves along with the sorts of expectations that have been recently expressed by the Regional Council. We want expectations to be set at a structure plan stage. We do not want to have to deal with the Tipuna heartlands of the future with the cumulative effect of decisions taken in this room over the next little while. We want the best available information so that our generic submissions can be decently put together and not have to be constantly revised in order to accommodate second thoughts on the part of the applicant. Allow me to say at this point that Tipuna is the landscape of my childhood. I'm here to say that I used to park my bike behind the Tipuna store in the 1960s. I will remember the gully that ran down beyond it, and I have explored it, and it was always boggy. If it isn't a natural wetland, I don't know what is. So just a little bit of additional information for your benefit. Finally, I'd like to talk briefly to the height issue. I provided a portfolio of photographs that are in evidence that show how much fun stuff does go on in our admittedly rather schmozzly Four Corners area, but it is noticeable that the built forms incorporate breaks in the building, verandas, and are tucked into Tipuna's undulating topography to good effect, so that where there is a rather large and height building, you can actually read it in terms of the hill behind it. Quite by accident, when I was taking the photographs of Alistair Clark's paddocks, which are, you know, what Tipuna used to look like, I turned around 45 degrees and took a shot. Could I have it up, please? Straight down Tipuna Road. Now, just in terms of height, I think it gives you a really good understanding of the effect of the DMS plant on the eastern side of Tipuna Road. And quite fortuitously, there are a couple of cranes on the western side. And I think they're at about a 12-meter height and about 10 meters back. And I reckon the description of a canyon is not overstated. In short, we say today at this hearing that we accept, Tipuna Heartland accepts that our hard work has had the effect of educating professionals on a better way of getting their desired future. That's how it goes, I guess. So that's my major point on the difficulties of dealing with the process when the ground keeps shifting, when it hasn't been shifted 17 years and counting. My final point, I said I had two. My final point is to earnestly and sincerely ask you not to underestimate the precedent value of the decision you make if you accept this application as it stands. To do so will give significant encouragement to careless developers elsewhere, and not just in Tipuna. We think you should avoid this. We want to avoid unforeseen consequences. So could you. Please don't contribute further to haphazard planning and reward, as I say, careless developers. We really need a strategic structure plan for Tipuna so that everyone understands just how much care has to be taken to look after this tiny part of the planet. All we want, as the Regional Council has said, is some certainty among the members of the community that they will have a reasonable idea of what the Tipuna of the future, the 30-year future as postulated in the UFTI work by Smart Growth, of which I was took a part. They need to know how their place that they live in, love, work, play in is going to be. They don't really want to see mushroom, slab-sided, high-line buildings popping up just where somebody thinks they can get away with it. One last point. At 4.6 of my additional, the Heartland's additional information that we put in on the 5th of July in response to, I think, the two latest briefs of evidence, we drew attention to this precedent question. We asked, and I state, on these grounds alone, that the present application be declined. That wasn't intended to indicate that you only had one ground on which to decline it. The phrase was intended to show how important this aspect of your decision today could be. There are, of course, many other reasons why you should decline the application.
Thank you very much.
Can I have to add one thing, please, sir? In 2019, there was a council consultation on this. 2018?
The map came out in 2019.
Yeah, the map came out in 2019, but there was in 2018, there was a consultation, and this is council map. So I'm throwing it up. The point to mention is that, as has been mentioned by the applicant, there's a large part of the southern section which is out of zone. It's a mess. It needs to be tidied up as one. And no one's mentioned the TNL.
Okay. Well, thank you for that. Those are all things that we will consider as we go through our deliberations. So thank you for the presentations. Are there any questions? Mr. Granger.
Again, the caveat that we're not to rely on such documents as this, but it does say Te Puna is to be kept essentially a rural area by limiting industrial and commercial areas to current locations and focusing on local services. And this involves recognising the existing commercial activity at State Highway to Minden Road and State Highway to Clark Road. We'll leave Clark Road away for the moment, and consolidating any future development at these locations to serve the local catchment. Do you not consider that this is delivering on that?
No, it's not a consolidation, it's an extension. It goes out beyond existing coloured squares onto rural land. There are opportunities for consolidation and considered development that are already potentially available without eating up Te Puna's resilient and versatile soils.
I might add, Councillor Granger, that we offered the applicant to go back to our community and revisit that plan, because by now it should have been reviewed already. It's a plan with three early reviews, or 2 3 early reviews that covered 10 years. COVID interjected, and we are presently with the council organising through a different set of people a review of that plan. Now, there's no if the community says, yeah, go ahead with it, fine. We have no axe to grind, except to the extent that the current plan disagrees with what is now being proposed, because that's what the community said in 2017. Now we accept the views change, but we haven't had a response to the suggestion that we take it at a slightly less hectic pace.
One further thing.
Sorry.
Ms. Bowden, you said that you want to avoid careless developers elsewhere and haphazard planning with things popping up in random places in Te Puna, which is admirable. Again, I go back to my question, isn't it therefore better to concentrate it with the existing commercial area to prevent that sort of haphazard mushrooming?
I think this is exactly the sort of example I meant when an expression of opinion is taken as in some way or another a veiled support for a particular proposal. I don't accept that sort of logic. I'm saying, in a way, Of course, it is better to try and concentrate commercial development around an existing commercial zone. My second point would be, what is to stop anyone else just having a go and setting up a commercial operation of their own and waiting for the district council to tell them to stop?
Thank you. Councillor Daniel.
Yeah, my lines of question were similar to Councillor Granger's, but maybe just add some extra clarification if you would. Because I had understood that, like Councillor Granger, you wanted to extend the commercial area in where it is already. But it sounds like you're saying we don't want any expansion whatsoever.
That's what the plan says, limit the commercial activity to what we've got at the moment and have a robust and strong planning process. And that involves much more consultation with the community, in my view.
So it's no expansion whatsoever until
If the
comprehensive
community says go
plan.
for it, fine, go for it. If the community says stay where we are, that's what we represent. We don't
We have no
give you
extra-
a personal opinion. We're just the mirror.
But nothing short of a comprehensive plan for the whole area is
We think that's
sufficient.
a much better approach, a much better outcome of good planning. I'm assuming you will go and see this site and give a really good view of what has gone up already, what is on off zone, and could it have been done better?
Thank you.
Okay, thank you for that. Ms. Price, did you want to? No. Okay, well, thank you very much.
Thank you.
Appreciate that. So if we could call for Te Puna Hall Committee, and while you're coming forward, Joe, if I could just, I know time is marching on seriously, but I'm still, my plan is to try and complete this process today, please. So if we could have that in mind for your final comment, summing up, Ms. Price and Ms. Barry Pacino, that would be great.
Tēnā koutou katoa, everyone, commissioners. Probably the Hall Committee is in a unique position in that we're the ones that are surrounded on three sides by the applicant. And really speaking in general as an advocate for the best possible future operating environment for us and for our community. You have our strategic plan. We have a mandate from the community as being their representatives. And so this is speaking in terms of what is the future that we want for our village. And the difficulty is that we have heard that some of the submissions are out of scope. But in our opinion, this is the time when we can actually wave the flag and say, these are the issues that we want to have considered. Now, we've heard a lot of debate about what is within the overview of the structure plan and what could be actually deferred to consenting processes. The key thing that the message that we want to get through, and I've heard it a lot today, is the word certainty. We want to know what is likely to be our operating environment. We want to know what can happen around us that may influence what we can do on the land which we have. So we would like clarity brought by the various parties as to what is going to be the overview, hearing about the words cumulative effect and integrated planning and all the great planning jargon. We want it to know, what does this mean for Te Puna? And how are we going to be sure that we have the village that we have set out in the community plan? So knowing that I was last on the list today, and I think everyone's minds is probably getting a little bit absorbed. I'm not going to repeat a lot, but I did underline a few things which I do want for your consideration on the second page. We do require clarification about the status of the Hall property. We know at the moment, and we've heard today, that it is under the commercial zoning, except for the little slither on the northern side. But I would be asking, when and how does council consider gazetting this into reserve so that we do have certainty about how it's going to fit into future planning for that area? And this is a strong request that we want to know how the future of the hall is going to be sealed rather than being under the umbrella of the general plan change considerations. This is an important issue for us, and we have not had any discussions raised with us by the council. So this is a place in which we can get some certainty as to what is envisaged for that site. So over to the next page. And we do want, under the structure planning, again, it's this debate, does it come now or does it come when there may be pepper-potted consenting processes? Is there going to be connectivity through that area, or is it going to be sealed off as private roads? And so therefore we want to know in B2, what is the intention and when do you indicate that there is going to be walking and cycling through that area? And how is it going to connect across the current state highway to the bus stops and up to Minden Road? So those are issues which are important to us to get accessibility to the hall site. A number of submitters and the applicant have said that this is the community hall site is one of the pivotal areas within the village. We want to make sure that that is actually built into future thinking. Now, the planners and everyone else will argue whether it's at the overview structure planning stage or whether we leave it to what may or may not happen under resource consenting stage. And so we have suffered, and others have said too, because we haven't had a comprehensive structure, which some of us were hoping for about 15 years ago, but disappeared off the radar. Over to D, urban design. It's been referred to in passing, but we are proud of our village. We're proud of our hall. We built it purposely so that it did reflect a country hall image. And certainly, as I've stated a couple of times, a 12-metre maximum height does not go with the image of a country town. There's been reference to Matakana. I don't think that we would envisage that we would be doing the same things in tourism and centred around a river in the way in Te Puna. We're looking more for ecological re-enhancement on our back door for the hall. And so therefore, we are taking a great interest in what is happening in terms of the three tributaries of the Oturu. And culturally, there has been reference in the various reports to the role of Pirirako. My understanding of cultural is that it's actually anything to do with the people and the things they do, both past and present and future. And unless anyone else disputes it, I would suggest that the village hall is one of the cultural centres from which a whole range of activities will happen. Therefore, it's important that these buffers and the landscape zoning design is appropriate. And we have great expectations of being involved in all of those discussions along with Pirirako. An acknowledgement to Pirirako who are online, and also to our chair, Ian Duncalf, who couldn't be here this afternoon. So we do look to a shared partnership along with council, because as we have said, we expect and hope that we will get again the word certainty of future management by actually having this vested in council. And I look to council in its wider responsibilities to actually be taking those steps at the appropriate time and ensuring that in the meantime, the planting plan and the restoration is up to the expectations of the community. And then to Transport and F, we have suggested, and Ms. Fosbury said that anything is possible. We would like to have the access road off to Puna Road actually in the centre, you've already heard the discussion about why it shouldn't be on the northern side. As someone who knows nothing about transport planning, it would seem to me that to have one virtually little main street that goes in opposite DMS, and it will only be the exit, I think, if they observe their exit rules. They don't. Therefore, there is conflict on that intersection now. But if it was properly managed, we could have a mini main street, and then we would actually have somewhere that is a bumping place and a place where people can actually be able to walk. So we ask respectfully that the transport people come up with a solution that actually puts that access road in the centre at least, so that there's not going to be conflict with our northern outside area of the hall. To those of you who don't know, it was designed to have outside reception area and on the lawn on the northern side, which would be right to the boundary. I think you can all visualize it. While there will be landscaping, we have already asked that it will be at a controlled height, because we're looking maybe to have solar energy along that whole northern side. So we would not want shading of that. So that is a key thing to the structure plan that we're asking, that maybe it's reconsidered, and we acknowledge the applicant for having already pulled the T intersection, which was going to be outside our French doors. So thank you for that. And the stormwater things, I think the debates between the professionals will carry on. As far as our hall is concerned, we wish to have, dare I say, guarantees that there will not be contaminated water from the hard surfaces coming down onto our surface, because our grass will be a precious part of future outdoor activities. And we want to make sure that we eventually get a good surface there that is not going to be subject to either contamination, flooding, or baking out in the summer because of cracking. So we want to make sure that we have the best possible growing environment for our lawn around the hall, and not stormwater running down off the, in particular, the slip road and maybe the new road. So those are the main things, Mr. Chair, except to go to the last point where I'm saying that if the applicants do not see their way clear maybe to meet on some of these requirements, And I remind you of Ms. Barry Pacino's comments this morning, where she tabled all the statutory requirements which you are meant to consider. And we know the words that are in some of the regional council expectations. And also, on behalf of the Hall Committee, I also know the local expectations. So I ask that you give serious consideration to what we are actually wanting in this area in the next 30 years. I also have been part of smart growth discussions, and you will note that it has been the wish of the Hall Committee that there would be emphasis on mixed use with some affordable residential. People are quoting blithely live, work and play, but we would like to know and have assurance, again, that there will be wastewater capacity if there are people permanently living there. And I have given some figures which question whether the 9.5 cubic meters that's been estimated is enough when you have people actually living on that proposed site. So those are key things that the Hall Committee values their responsibilities. We are acting on behalf of the community. The Hall is 100 years this year in October, and we want to have something to celebrate for the next 100 years. And that doesn't actually sit well with having 12-metre buildings on our side that may not be compatible with what we have as our vision. Thank you, sir.
Thank you very much, Joe. Mr. Withy, no questions? No questions? No questions?
Just a point of clarification, please. In topic 3.5, Ms. Grevitt has requested the road be moved further north to give a buffer to the Hall site. I just wanted clarification whether thought has been given by the Hall Committee to the alternative if the road was to move further north, that would then put the commercial buildings directly against the Hall site, and is that a better or worse alternative to the Hall Committee compared to what's currently proposed, which is landscape buffer strip, road, landscape buffer strip, and then the commercial buildings?
That has been talked about, and we know that there will be the how many metre landscape strip there anyway. And the likelihood is that if they're small commercial retail, that they will face, hopefully, the main road that goes in, and that we would have parking in behind. Now, again, is this part of the structure plan debate, or does this come when it comes to noise, lighting, and all those things when a resource consent is sought?
So I'm just seeking the clarification, as the commercial development would likely be the back end against the Hall site, and without knowing where car parks and buildings are to be located, there's the potential for a 9-metre high building to be located on close to the boundary, and whether that's been considered by the Hall site.
I believe the commercial rules should give adequate protection. Anything is better. We've heard today there could be articulated trucks going along, and that's not much fun when you've got an outdoor reception going on across the buffer planting.
So just a further point of clarification then, if the 9-metre high commercial building was to be against the Hall site boundary, and this may be clarified by the applicant, it may be unlikely that a landscape buffer is provided. The building may shade the whole site, and that was something that you wanted to avoid. So has thought been given to that?
It's chicken and egg because we're actually seeking a 9 metre.
Yes, but a 9 metre high building on the northern side may still provide shading to the whole site.
That should come under normal shading rules, I would anticipate.
Under the commercial zone, there is no daylighting angle between commercial zoned sites.
So is this a structure plan discussion? Or will that come at consenting?
Yes,
I'm sorry, I'm confused.
Sorry, it relates back to the location of the road and how that would then affect the whole site if the road location was to be altered.
In terms of noise and amenity and us being able to use our outdoor area, I can't speak for the whole committee, but I would suggest that having a central road would have more advantages to us.
Okay, thank you.
Okay, well, thank you very much, Ms. Gravitt, and thank you to all the submitters. Always impressive to see local people and the passion they bring to a local issue. And so thank you for coming and sharing. Two or three, one very briefly, but two things remain. And so, Mr. Martelli, you wish to interrupt me?
Well, just in relation to that, Mr. Chairman, perhaps before, because I know what you're probably going to say, but just as a procedural matter, with the later evidence that was tabled by the Regional Council around those pages of rules, I suppose I'm a bit concerned about the short time frame to be able to give you adequate time to give, and Anna in particular, to give her professional opinion about whether they're acceptable or not. The same may or may not apply to the applicant. So I'd be happy for Anna to give her right of reply now on everything except perhaps that, which we could bring to you tomorrow, or whether you want to park the whole thing to tomorrow, and I'm sort of perhaps whether Ms. Barry Pacino may have a comment, so we can coordinate to give you the best response you can.
All right, well, I'll hear from Ms. Barry Pacino before I make a comment.
So I did have a brief chat with Mr. Martelli about this. I think there's a huge amount that's been put into 3 pages, and I haven't even been able to turn around to my engineer to ask about those. So my suggestion is that I would concur that those should be parked. I am mindful it's 5 o'clock, but with all the submitters here and not wanting to throw them out to try and get them to come back for another day, I recognise that for them it's their precious time. My suggestion is that I deal with my right of reply on everything else but the regional council matter, which we can specifically come back for if that's a way that you would want to address it.
That's exactly how I would like to address it. So if both parties are comfortable, we'll proceed on that matter, and you'll provide your right of reply in regard to the regional council request later. So Ms. Price, we're in your hands.
I just would like to start off by thanking everybody for all the evidence that they've presented today. It's been really interesting listening to you all, and I thank you for taking the time to be here. I just have several points that I just wish to make in response to the evidence that I have read and listened to today. Regarding Ms. Fosbury's and Mr. Collier for the applicant, I recommend that Mr. Collier's point 5.8 regarding the access to the southernmost development block be restricted to once the TNL has been constructed, and that there has been a recommendation for some wording prepared by Mr. Collier, which is part of his evidence, so I would recommend that be accepted. Also, after hearing the evidence of Ms. Fosbury, I would also like to add an additional provision within the structure plan to respond directly to the connectivity for pedestrian and cycleway through the site. I would maybe recommend that a dashed line could be shown on the structure plan annotated with indicative pedestrian cycleway linkage with some text similar to what has already been proposed in 8.4 around pedestrian and cycle connectivity shall be provided through the structure plan site from the southern slip lane area through the stormwater area to connecting to the Te Puna Road. And I can provide you with that wording as well. Also, I support the applicant's tabled structure plan update, which removes the northern road and intersection. Just for clarification, that was this map, which removes the northern road access and removes the intersection adjacent to the hall site. Just turning to the 12-metre height limit, and which was topic 16 of my 42A report. After hearing the evidence of Mr. Hugo and Mr. Collier, I agree with the assessment given in relation to the 12-metre height limit and associated setbacks, the daylighting setbacks due to the required daylighting plane. I've given consideration to the surrounding landscape, built form and the 14-metre height limit at the DMS post-harvest facility, and I would recommend accepting the 12-metre height limit. However, given the concerns around the height limit adjacent to Te Puna Road, I would recommend that there be some form of setback provided there in terms of building setback from the road, and then also a height limit setback from the road, just to avoid creating a canyon effect. And I'm happy to provide some more wording around that just to assist. In conjunction with and as raised by the evidence of the DC Kirk Family Trust, I would support a berm within the required screen planting area along the northern boundary, and this would be in conjunction with a suitable planting guide which would assist in reducing the risk of passion vine hopper, and also to achieve a screening height of 9 metres, which would include the berm height as well. And this is outlined in point 2.13 of Mr. Child's evidence. Just turning to Mr. Hamill's evidence for the Plenty Regional Council, I would support the recommendations suggested at point 32. These actually tie into the recommendations of Mr. Collier's point 5.12 in relation to riparian margins.
I just think some people are struggling to hear you.
Sorry. So they tie into Mr. Collier's point 5.12 in relation to the riparian margins within what's been proposed in the structure plan provisions. I recommend that the point 32 of Mr. Hamill and Mr. Collier's point 5.2 kind of be integrated together to achieve the outcome that's desired there. And then just my final comment was just noting the suggested provisions by the Regional Council, and I will need to discuss those further with our utilities team and senior staff for further comment. Happy to take any questions.
Thank you, Ms. Price. Questions?
Suggestion. See that in writing by Friday.
I was hoping that would be the case.
I will circulate it in writing for you as well.
Yep, thank you for that.
Sorry, others may not have heard. I'm just suggesting if we could have that in writing by Friday would be very helpful.
I can have that to you this evening.
Thank you. That's all. Councillor Dinion, Councillor Granger. Yep. Awesome. Okay. Ms. Barry Bassino.
Thank you, Mr. Chair and councillors, and thank you to submitters. In terms of the presentations that have been provided, I will go through each of the submissions and comment on them and try as best as I can within the timeframe available to address matters raised. First, if I could deal with Toi Te Ora Public Health and the letter that arrived. I think that was anticipated by the applicant in terms of the position through consultation with them, and Mr. Collier's evidence covered that the concerns that they raised were ones that were addressed by seeking confirmation of wastewater reticulation. There has been planning conversations between the Western Bay Council in terms of policy direction from Mr. Martelli as well as Ms. Price with Mr. Collier, and the concern that they have, whilst it's really not a material matter for the applicant, because of course they're going to link to reticulation if they can, is consistency with the whole plan and also with the regional plan. As it stands, as a matter of policy, as noted by Mr. Collier, there is the ability to use wastewater septic systems if it's an on-set type treatment as a permitted activity. And there's a rule in the district plan that's discretionary. As well as this area, I think the need an overview of the whole plan is one that you as a committee are tasked with. This is not like a land use consent where you're drilling in just on this. There is the overview of the plan as a whole and how it fits into the plan as a whole and all the areas and all the zones. So for that reason, it's not been supported. It's considered to be unnecessary. And whilst that may be a matter that comes up in future plan reviews, as discussed, it's not a matter for this plan change that we would support in terms of leaving it as a discretionary activity. Consider that it's a matter that's a non-issue, really, in terms of costs and benefits to make that plan change amendment at this point in time. With regard to Mr. Kirk, I wish to thank the evidence of Mr. Kirk and his experts. Actually, just if I can focus on Te Ora, the last remaining matter, I would note that they've tried to feed into the regional council in terms of support on stormwater. And I would just note they did not submit on that in their submission, so that's out of scope in terms of their final paragraph. The other aspect of Mr. Kirk, as I noted, I would like to thank his experts for very practical suggestions of relief. There has been attempts to consult with Mr. Kirk, and I stand by that because I'm aware of those. I think the difference in consultation, and it's one that comes up often through plan changes and consents, there's a difference between consultation and finding agreement, and they often, the two don't meet. And it would be fair to say that the relief sought in the submission, which wasn't touched on particularly directly in the evidence, is it set out at paragraph 7.4 of Mr. Kirk's submission, where it was sought that this area be included as part of a future growth urban area, and that this be included as relief that was discussed as being outside of scope of this plan change. And there I refer back to my original submissions, which is where you have a discrete small plan change such as this, matters of incorporating other areas are not within your scope to grant. And that's important for Te Puna Heartlands as well. Those matters may come up in terms of the 30-year plan for wider plan review, even specific to Te Puna, but that will require a public plan change or a private plan change if Mr. Kirk should wish to, but it's not before you today. I go back to my submissions where I comment there is nothing in this plan change that prohibits that or compromises that in any way in terms of those future plan changes should they arise or when they may arise. In terms of the suggested provisions around buffers and setbacks that were put forward in Mr. Childs, Mr. Collier advises me that those are either A, supported in terms of being what's suggested to extend that buffer. We're happy to include that either referenced in plan provisions, which Mr. Collier, when he does an amended set, will come up with addressing that. Or to the extent to which they're already addressed within the district plans, there can even be a cross-reference within the structure plan, where often there's a note back to other rules and how they apply, just for clarity within the structure plan area as to what rules apply. There has been an updated structure plan that Boffa-Miskell has done during the day, but I'm wondering if it might be easier to tie that into tomorrow, although I do have it on a stick in front of me if Ms. Clark wishes to take it from me, that I could pull it up on the screen just to clarify what's been done.
Just while that's happening, could I just make a request that you've already referred to one instance where Mr. Collier supports some things that have been asked for. Would it be possible for you within, say by Friday, give us the text with the track changes from what was proposed today and what is acceptable?
Yes, that is my suggestion, that Mr. Collier comes up with some amended provisions that will include track changes that have incorporated any matters that have been raised in evidence where the applicant considers that they have merit and that they can accommodate. And that will also include the regional council suggested provisions, which we'll comment on further tomorrow.
Sorry, Sarah, I'll give you the entire chapters because I think it's important you can see the context of the changes.
Some of the matters that were raised by Mr. Hamill with regard, I think it was by Sue Ira, excuse me if I'm pronouncing her name incorrectly, Ira, related to the existing discharges to the site. And in my submission, while it's correct that this plan change is dealing with discharges from the site, there is stormwater that's been piped directly onto the site from the road, also from the TMZ site. And the context of that, when I've spoken to Ms. Wilcox, is that when there's planting built up around the stream and the area, there is the potential for that to either slow things down or contain some of those contaminants. So whilst it's correct that it's not directly addressed that in terms of attenuation, treatment ponds or wetlands, the broader enhancement of the stream area is one that will have ecological benefits in general to stormwater that's been directly piped onto the site in its current environment. I would just note that in terms of Mr. Hamill's evidence as well, matters that he discussed appeared, although he said that he wasn't involved in advising in an ecological input into the discretionary stormwater consent process that is usual with the regional council. I do note that they have their own freshwater ecologists, as I understand it, in-house, and that now I've been advised by Mr. Rayner that that's much more a common process in that consenting process, that the wetland type approach or looking at better stormwater solutions in line with what was put forward by Ms. Ira is included as part of that process. I can't possibly comment on what it would be like for her to be doing consenting up in Auckland, but I would suggest that the environment of that would be quite different than Western Bay. And whilst it's acknowledged that this is a tight site, I don't think it's anything like the urban commercial areas that you would see in Auckland. And there has been, through the structure plan, the opportunity to set aside a significant part of that site and put it aside for stormwater. I want to deal with the other matters raised by the regional council tomorrow. I would just now comment on the Te Puna Heartlands submission. I consider it very unfortunate that anyone would think it appropriate to address matters of somebody that's deceased and not on the road to defend themselves, just as a matter of standard, what I would consider good manners. However, I would note that as a matter of legality, this is not the same legal entity. And so for the committee's perspective, whatever occurred in the past 17 years that was under different ownership, and this is Te Puna Springs Limited as a different legal entity for you to consider. I would also note that there has been no attempts to reward any past ownership activities on the site that are not compliant or non-complying. The aspects to which the site is compromised or been compromised, as referenced in any of the assessments done by consultants, relate to existing activities that are approved on that site, not non-complying ones. So I do not wish to get into compliance that the council may have chosen or otherwise to do. That is not your job either. You would be pleased. This before you today is a plan change which is looking to the future, not the past. And what has been addressed in terms of baseline of existing environment is only those activities which are approved through land use consent or through existing zoning. I do want to pull up, I've given Ms. Clark a stick, and on that stick, there's firstly this, which although it's shown as minuscule, does identify that proper setback and the 3-metre adjustment, and the setback of development areas, which the Regional Council talked about, which was always intended by the updated evidence. We just didn't have a chance to do that overnight, but that shows those areas now on the site. Another part on the stick that I've given to Ms. Clark, if she wouldn't mind pulling it up, is some previous diagrams that were provided with the Te Puna Hall Notice of Requirement. And I see Commissioner Withy will be well familiar with this because he was a commissioner on that hearing, as I recall. Yes, I thought my memory was going to fail me for a moment. So Joanna Scones, if you could pull hers up, there is I'm not sure if that's, sorry, I might have got the wrong diagram. It's really her sketch diagrams, which I wanted to show. It might be at the end of her evidence, actually. Very end. Thank you. Yes, there they are. So if you go back to the picture on the front page, and if you could zoom in on that, please. And you will see that at the front of this site and what's there now, the extent to which NZTA was utilising the site for its construction of the state highway. Now, that is not a contamination of the site done by the previous Mr. McIntyre, but in fact was what was going on the site during construction of the state highway. You will also see that this is quite different than the pictures that were shown by Mr. Kirk. But that development that sits there in that surrounding area, whilst it's not the pristine area or photograph shown by Mr. Kirk, it does indicate that none of what's shown there, other than the very far corner, I don't even think you can see what Mr. McIntyre had in terms of containers on that picture, none of that relates to any development of his that has caused the urbanisation of Te Puna. So to lay that on his shoulders is in fact factually and legally incorrect. Oh, the Heartlands talked about a photograph. Thank you. It might have been provided by you two then. I'm not sure where that photograph came from that the Heartlands put up. Never mind. So if we just carry through and just scroll through some of these photographs, I think they're a little bit helpful to show 2017 what we were dealing with. We keep scrolling. That was the old Te Puna Hall. You can see there the extent of what was already developed. If you carry on through, you can see what was planned for the site, and the Te Puna Hall site in terms of abutting right beside the stream in terms of developable land area and what was planned. If you carry on, you'll see again the type of development that was occurring through that area of the site. You carry on through, again, you will see that this is built up in the lower picture, the extent to which this was used for earthworks and deposits of roading materials. Carry on through, you will then see the part that's the storage sheds and then the other remaining parts of that site. The reason I wish to show that is really the context of this is a long history of the site being compromised from its rural uses that does not sit on the shoulders of Mr. McIntyre, but in fact is part of the growth of Te Puna in a wider sense beyond the previous owner. However, this applicant is seeking to do a comprehensive plan change to try and address what is there now and does allow for a planned expansion into more compatible uses to cater to the Te Puna community's needs, as well as address in a better manner the stormwater on the site. Irrespective of not agreeing with the Regional Council's expert as to the timing of the detailed design, there has never been an argument of the outcomes that the Regional Council has focused on. It was really a matter of how that method and what was suggested was put through appropriately through a plan change Schedule 1 process as opposed to through consenting processes. And I just want to note there that in terms of Mr. Tapiri and the documents that he's put forward, and I think he referred to this in his evidence, there was, I think he relied heavily on the regional council's involvement in the Pukerangi Heights plan change in Rotorua. And I just want to note there the considerable differences in the two. That was a 74 hectare residential development in Rotorua that had significant flooding issues. It involves multiple landowners, and I think that's an important consideration that appears to be missed. That in this case, you have one land ownership who intends to undertake the development. That's a material difference, and until such time as it's subdivided to the point where you have potential for different landowners, you have the ability to ensure comprehensive outcomes are controlled and managed by one landowner. That's highly unusual in a plan change where there's usual multiple titles involved. And in this case, the only other landowner that has development going forward that might change is the council with the Te Puna Hall, which I think the commitment through that designation process, even though it moved on the site, that recognition, I think Ms. Gravitt referred to it and I would concur, it was always intended to be a social hub for Te Puna in terms of its relocation. And even though it's now more internally in the site, it does provide that connection, and having some surrounding more amenable commercial uses, potential for other residential as a mixed use will complement that going forward into the future. The other comments that were made by Te Puna Heartlands was commenting on the written approval. I would just note there, the written approval that was provided in support of the plan change was done so on behalf of the Te Puna Hall. It was not done on behalf of Te Puna Heartlands. So in regards to that, his evidence on that should be striked. He does not have the ability, nor did he sit here before you representing Te Puna Hall Committee. With respect again to the matters that I raised in my opening submissions around mandate, they are not a community board. They do not, the Te Puna plan is not a mandated plan under the Local Government Act. And to the extent to which they represent that committee, again, clarification of that has not been given any further light through the submissions that you've heard today. To the extent of talking to the community, in my submission, this plan change did so to the community. It's a publicly notified plan change as if it was public. Therefore, the opportunities for the community to have their say were fully notified and put out to the community, and hearsay evidence of what he said, she said, or somebody over the fence said is not relevant to your considerations. What is relevant to your considerations is the submissions that you have in front of you. And as to who they represent, if they wish to say that they represent a wider part of the community, then I would suggest that that membership and understanding of that needs to be clarified and presented to you and tabled as further evidence. I haven't seen that to date, as I said. What I do have is a series of submissions where, for the main part, the applicant has been able to address the concerns raised, and that has been done through consultation. Again, there have been areas where there hasn't been agreement. And for the main part, it's not, for example, with Mr. Kirk, not because we don't support that perhaps there's a logical expansion of Te Puna to those sites. It's just that it's not within the scope of this plan change to be able to either agree to that nor include it in scope. But again, it's not in scope for you as a panel either to suggest that this be held up in terms of decision-making to incorporate any future aspirations. But the merit of doing a 30-year planning for Te Puna is one that I would support as good planning, and I'm sure that the applicant would support as well as a local. Just some comments on the comments by Ms. Price. We are gratified to hear that she has considered the expert evidence on the 12-metre buildings. I do think that, as shown in the evidence for the growth of this locality, and as noted by Mr. Hugo in his evidence, the trend towards greater urbanisation and more efficiently using urban land to the best extent possible is consistent with a higher height, because that is where the trend is, that where you are going to urbanize land, you do use it as efficiently as you possibly can. And in that regard, with respect to the suggestion around stormwater and it not being able to be fit on this site, in my submission, the question that I would consider in terms of your job, in terms of risks of acting or not acting and costs and benefits, there is a strong thrust now within Section 32 around economic benefits, balanced on those other matters in terms of costs. But I think that where you have a situation such as this, with an indicative structure plan, the risk that the stormwater consent process ends up with less developable land, the risk of that sits with the applicant. It's not a risk that sits with anyone else. It's not that the stormwater won't have to be addressed and that a comprehensive consent won't be required before any development can go ahead. So the full risk of having a lesser developable area sits with the applicant. And I think that that's an important consideration when you're weighing up, as you're required to do, the plan change risks and costs and benefits that Section 32 requires. So on that note, I will end my submissions and note the caveat that we're coming back tomorrow for another closeout on hopefully have the provisions in a state to be able to look at as track changes and also be able to address the final submissions on the regional council in terms of the proposed provisions. Thank you.
Thank you very much, Ms. Perry-Pacino. It's great. So just a couple of procedural matters before we close off for the day. Could I have someone please move the receipt of all written and verbal evidence? Moved Councillor Granger, seconded Councillor Denia. All in favour, please say aye.
Aye.
Against? Carried. So secondly, I'm going to adjourn this hearing very shortly. I think you're all aware that we will be resuming tomorrow to consider Plan Change 94 in regard to Washer Road in Te Puke. And after that, the conclusion of the day tomorrow, the hearing will again be adjourned, and we have set aside a couple of days over the next week, I guess it is, to consider the matters that have been brought before us today and tomorrow. And I guess in due course, when we've come to resolution of those matters, you'll all be notified. So thank you very much. I know it's been a very long day, and I really appreciate your willingness to stay late and get this all cleaned up today. So thank you very much. I declare the meeting adjourned.